What officer? Hello? What officer? Sir. What officer? What officer? What officer?
ಎಲ್ಲ ಸರ್ ಥರ್ಡ್ ವೀಕು ಫೋರ್ತ್ ವೀಕು ಸರ್. ಹಲೋ ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಮತ್ತೆ ಯಾವ ಲಿಸ್ಟ್ ತಗೊಳ್ತಾರೆ ಮೇಡಮ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮೇಡಮ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಸರ್ ನನ್ಗೆ ನೋಡಿ ಸರ್, ನಿಮ್ ಕೇಸ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ, ನಮ್ಮ ಕೇಸ್ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ ನೆನ್ನೆ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ. ಐ ರಿಪೀಟೆಡ್ ಇಟ್. ಈಗ ನಿಮ್ಗೆ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದನ್ನ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ನಿಮ್ಗೆ ನೆಕ್ಸ್ಟ್ ಮತ್ತೆ ಏನಾದ್ರು ಇವತ್ತಿಗೂ ಡೇಟ್ ಕೇಳಿದ್ರೆ ನಾವು ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಲಾಂಗ್ ಡೇಟ್ಸೇ ಹೋಗೋದು. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮತ್ತೆ ನಾಳೆಗಿದೆ ನಾಡಿದ್ದಕ್ಕೆ. ನೋ 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 ನೋ, ಎಸ್ಟರ್ಡೇ ದೇರ್ ಇಸ್ ಸ್ಟ್ರಿಕ್ಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಲೆಟ್ ದೆಮ್ ಸಬ್ಮಿಟ್ ವೇರ್ ಎವರ್ ದ ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡೆಡ್. ಇಫ್ ಐ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ದೋಸ್ ಮ್ಯಾಟರ್ಸ್ ಯು ಶುಡಂಟ್ ಗಿವ್ ದಿ ಡೇಟ್ಸ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಆಯ್ತಾ, ನೀವು ಆತರ ನೀವು ಸಬ್ಮಿಷನ್
Its petition was filed
On
on,
12/2/2020. I was not the council, my lords, when.
no, orders will not depend upon councils.
Yes, my lords, I request this honorable court only one indulgence, my lords, section 14 limitation, if that is granted.
So it will come between, what is the date? From 12/2 till the order is ready.
1/4, my lords.
Till the order is ready.
My lords, still.
Order, when is order passed? That is only, that is where I can grant you, not more than that. When the order is passed,
My lords, the
order is passed on 17th February. So you will have because I have not given you the time. So from whatever is the pending time before the court, 4 days, you will get 4 days. I will not grant. Section 14 applies means the benefit of section 14 is only that during the pendency of those proceedings.
Yes, my lords, until 1/4.
No, I will not grant that. Please come. The writ petition was disposed of on 17th February 2026, giving liberty to the petitioner to avail the appropriate remedy. Now the IA is filed seeking the benefit of section 14 of the Limitation Act. It is stated that in other matters, this court has granted the limitation. Hence, the order dated 17th February 2026 is modified. And it should be read as follows. The writ petition is disposed of with the liberty to the petitioner to avail appropriate remedy in accordance with law before the appropriate forum. He shall have the benefit of section 14 of the Limitation Act.
Very much great.
Serial number 2, list number 1, serial number 2, Maruti, GB.
And for petition, my lord.
And for this, you want to mention? Huh? No, why are you mentioning this matter? You can't wait for item number 2. I'll not hear any. This is matter. Don't add that matter to anything. This is matter in the month of September.
Serial number 3,
I will not.
Uni Krishnan M.
I think the petition in this matter, my lords.
Yes.
Senior is unwell, like.
Huh?
Senior is unwell, my lords.
Yes.
So a week's time, my lords. It's the
Already this
determination of the
matter
market
underwent
value.
on your request earlier also.
My lords, no, my lords, I had asked for a week's time. However, my lords gave the very
This is
shorter
matter
date.
in the month of August.
My lords, please, my lords, not,
Number 4,
Huh?
please, my lords, please, my lords. Just, I had asked on the last date also 1 week's time, but however, it was listed just within a day. So that's the reason, my lords.
How many times it will be adjourned? That's
No,
what
no,
I'm
no,
asking.
no, my lords, no, my lords. In a week, surely, my lords.
Everybody will come in the morning and make mentions when the matter is listed, ask for time.
No.
Again, come up with a memo for listing the matters. How isn't it difficult for the court?
Sorry, man. I bowed down. I'm sorry.
List this matter on 22nd.
Much okay.
serial number 4, Vaidya Ravi.
No representation list in the month of September.
Serial number 5, serial number 5,
I am for the petitioner, madam.
Yes.
Pati.
My lord, petitioners are the defendants in the before the trial court, madam. The petitioners are filed the wakalat on 4/11/20.
What is the IA?
And my lord, stay the interim order, my lord. Stay the further proceedings of the trial court, madam.
What is the IA filed before the trial court?
Permission now to file a written statement, my lord.
What is the delay in filing the written
7
statement?
days, my
Huh?
lord. 7 days.
When counsel for the petition submits that, the court has failed to take the written statement on record, as the same is filed with a delay of 7 days. It is submitted that a coordinate bench of this court has suspended the operation of the amended act. In that view of the matter, there shall be a stay of all further proceedings pursuant to the order dated so and so. Petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 23rd of July. Or else the stay granted by this court stands vacated.
Serial
Yes,
number
yes.
6,
My lord,
GB Nandish Gowda.
writ petition is by the decree holder. Decree holder in the execution proceedings.
Is it on the mic?
Writ petition is by the decree holder in the execution proceedings.
Yes.
Suit for declaration and for possession, the trial court decreed the suit. My lord, the sketch and report, my lord, the commissioner report based on the commissioner sketch and report, the trial court, my lord, the pass the decree. I would like to take my lord attention to.
IA.
Now, my lord, the executing court directed the decree holder to furnish the sketch and report. Accordingly, my lord, I have furnished the sketch and report, for which, my lord, the judgment debtor has filed the objections. disputing the identity of the property in the execution proceedings and also the topography. My lord, the trial court, my lord, the unless, my lord, the withhold, my lord, the cancelled the earlier commissioner report and sketch. Ordered, my lord, the directed the decree holder to take the, my lord, take the appropriate action to identification of the property in the execution proceedings. That is not permissible, my lord.
Let's see. Where is the order?
Memo ink page number 188. I filed the memo along with sketch.
Where is the impugned order?
Impugned order annexure K.
Page number.
Page number, my lord, the 191, last, my lord. It commences, my lord, the findings 195, para 10 onwards. The objections raised by the judgment debtor therefore cannot be brushed aside lightly. The contention that the decree has become incapable of execution in absence of the proper identification carries a considerable force. At the same time, the
Come to
outright
paragraph number 6.
6, yes, ma'am. Upon careful consideration of the rival contention and perusal of the material on record, this court is of the considered view that the core issue that arises for determination is whether the execution schedule property is properly identifiable so as to enable the enforcement of the decree. My lord, the kindly turn to, my lord, the findings.
Complete reading the order.
Yes. It is a settled principle of execution jurisprudence that the decree must be capable of execution with certainty. The executing court cannot travel beyond the decree, but at the same time, it must be in a position to identify the subject matter of the decree with clarity. Where the identity of the property is uncertain or incapable of ascertainment, the decree becomes inexecutable in its present form. In the present case, it is not in dispute that the sketch relied upon by the decree holder is for the year 1992, and the judgment debtor has specifically raised the contention that the physical features of the property have undergone the substantial changes, including the removal of the fencing and construction of the wall. This contention assumes the significance in view of the report of the bailiff, indicating that difficulty in executing the warrant due to the lack of proper identification. The production of an old sketch without correlating the same to the present physical status of the property does not advance the case of the decree holder. The executing court cannot proceed on the conjecture or assumptions while identifying the immovable property. There must be clear, cogent, and contemporaneous material enabling the precise identification on
What is
spot.
wrong with this order?
Please, my lord.
What is wrong with this order?
My lord,
When was the judgment and decree?
My lord, the judgment and decree, my lord, on 9/3/2001.
9/3?
9/3/2000, suit is of the year 1990.
1990.
9/3/2001. This honorable court, my lord, confirms the judgment decree
Yes.
of 21/10/2021.
Yes.
My lord, while dispose of the property, the trial court and this honorable court relied on the very same commissioner report and the sketch.
After 26 years, after the 26 years
Well,
from the
the-
date of the decree,
I
the
would like to-
property will not be of the same nature.
I would like to take, my lord, into ink page number 174. My lord, the commissioner report and sketch is
You
also
are
part of
seeking
the
India,
decree.
you are seeking execution.
What
after-
happened, my lord, the commission, there is encroachment only with respect to 5 feet by 43 feet. My lord, he is the adjacent house property.
No, any decree has to be executable. For that, the court has, even the bailiff has stated before the
My lord,
court that it is difficult to
for the
execute.
first time, the judgment debtor, the my lord disputing the identity and my lord the topography. That is not so. In 174.
Whatever the, no, where is that? The court has specifically observed it,
When
at
there is
para
a-
8.
My
In the
lord, when
present
there is a-
case,
yes.
please read, in the present case,
In the present case, it is not in dispute that the sketch relied upon by the decree holder is for the year 1992. The judgment debtor has specifically raised the contention that the physical features of the property have undergone the substantial. Where is, my lord, the physical features, my lord, undergo substantial changes? My lord, dispute only with respect
it
to
will-
northwest corner, dispute with respect to encroachment to the extent of 5 feet by 43 feet. My lord, based on the, my lord, the sketch,
according to you, whatever is there in the
topography
sketch,
has not been changed. Identity also not been
then
changed.
it is not a problem at all. Once the survey, when
Allah.
sketch is prepared, it will come to light. Why are you worried about it?
My lord, I will try to convince. Ink page number 174 for a moment kindly.
Please tell the court, what is the prejudice that is caused to you?
My lord, with a specific direction to be issued to the any court commissioner, my lord, to visit the spot on the very same day. And my lord, the measure
Then for
along with
that,
the,
take notice to the respondents.
please.
Notice to the respondent.
Till then, my lord, the impugned order, my lord, order passed
What
on
is
the,
there to say? I don't find any irregularity with that.
my lord, the commissioner report and sketch is part of the decree. The
Can't
same,
be, after
Ah.
26 years, it won't be the same. When the bailiff said that it is not executable, they are not able to understand. Court was perfectly right in
I will
passing
take
this
the hand
order.
summons also, my lord, kindly
But I'll
fix
not
some date,
state,
my lord.
the petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 14th of July. If the same is filed, listed on 15th.
Please, my lord.
Till number 7, P. Leeladhar.
Yes, sir. 2 weeks time minutes. Yes, sir. 2 weeks time minutes.
Why?
The impugned orders and also other annexes are Kannada minutes.
What is this writ petition about?
Lord's license is obtained by fraud and there's a contesting respondent also.
Notice to the respondents. AGA takes notice on behalf of
1, 2, 3, 4.
1 to 4.
Yes.
1 to 4, notice to fifth respondent.
Five.
Fifth respondent. List this matter after 3 weeks. Yes.
Till number 8, Puttraju CP.
No representation. List this matter in the month of September. Yes.
Till number 9,
Please, my lord, I appear for
Narayan.
petitioner. My lord, Annexure E, page 31 is the impugned order, which is the order passed on IA number, my lord, under
What is the suit for?
suit for declaration and injunction.
You are?
I am the defendant. I am the first defendant. This is the defendant writ petition.
What is IA?
Please, IA is, my lord, Annexure E, page 31.
Hmm.
Operative portion is at page 37. What happened is, my lord, under order 26 rule 9 application was allowed. But however, my lord, the court commissioner is appointed so as to ascertain the, who is under the possession. It is a settled position of law. In fact, it is, last time your lordship heard this matter.
Why is it adjourned?
Pardon?
Why
It
is
is only to serve some copies. My lord, may I?
What are they?
I'm laying off some judgment to say that, my lord, insofar as the appointment of court commissioner cannot be appointed for ascertain the, my lord, para,
After the evidence is completed.
after evidence is, though it is after evidence is completed, so ascertaining the possession cannot be with the court commissioner. My lord, may I rely upon para 9 of the first judgment.
Now let's read paragraph number 9 and then we'll go to the judgment.
Correct, correct. Impugned order. Impugned order, paragraph 9 is at page 37.
Please read.
It is, please, it is, my lord, I will read. Para 37, para 9, my lord. Having gone through all these oral as well as the documentary evidence, what it appears is the parties cannot brought actual truth of encroachment in the suit property. This oral and documentary evidence might be relevant for proving possession, having the title payment of taxes and utilization over the something that are appearing in this part. Therefore, in my considered opinion, in order to determine the alleged encroachment, if any, as alleged by the plaintiff, be ascertained through the court commission only, that to making local investigation, measuring parties of both parties, and in the absence of the same, the courts cannot come to a right conclusion on the basis of oral as well as documentary evidence, which is available on the record. The
DW1 has also
Yes,
admitted
yes,
during the
only,
course-
yes, DW1 has also admitted during the course of cross-examination that he has no objection to appoint of commission to measure the property. Thus, the appointment of court commission is absolutely, this is the only ground, my lord, the court has
What
certain.
else the court require?
Pardon?
What else the court require?
No, no, my
Plaintiff
lord,
wants-
kindly see,
plaintiff wants the
bare,
advocate
no, no, bare
commissioner.
admission of the
Not mere
witness.
admission. An IA is filed. Plaintiff wants the advocate commissioner to be appointed. Defendant says, please appoint. What else is required?
No, no, is a bare admission cannot override the provision of law. My lord, I may make a submission. So far as appointment of commissioner,
Going into all that, please tell the court, why did you admit?
my lord, in a cross-examination, in a vague admission cannot be taken, right, the provision of law and the settled position of law. So far as appointment,
every
so far as
admission-
appointment of commissioner, it is very well settled law, my lord, to ascertain the find out of the possession, court commission cannot be appointed.
The court didn't say that the advocate commission is appointed to know who is in possession of the property.
Correct, absolutely, that is, may I take your lordship kind attention to the operative portion of the order.
Yes.
The SS advocate appointed as court commissioner to local investigation of suit property, the commissioner shall measure the property of plaintiff, point out the alleged encroachment, if any, in the suit property. So far as encroachment question was not in the pleading. The pleading is, my lord, he is in possession, plaintiff is in possession. On contrary, it is denied by the defendant that defendant is possession. Even assuming, may I put it in this way, even the court commissioner says that the plaintiff is in possession or defendant is possession. Ultimately,
Will not look into
it
only
resulted in encroachment only. The
The-
what the
Court
finding?
commissioner's report is not conclusive. Court
No,
commissioner report is not binding
I
on the court.
absolutely agree. My lord, court commissioner
The court-
report is not a conclusive, but however,
It is a discretion
my
of the
lord,
court.
my lord, my respectful submission would be this, my lord. So far as appointment of court commissioner in respect of the finding out the possession, who is under the possession, it cannot be. It has to be adjudicated by the court only, by the oral and documentary evidence. The court commissioner cannot, may I
Yes, please
request
come to
your,
the judgment.
pardon?
Come to the judgment.
Please. My lord, first judgment, para 9.
Yes.
It is a settled position of law. I will read.
First judgment means which judgment?
Which, please, my lord, the first judgment is, my lord, between Ilango versus Kasturi,
Yes,
para 9.
yes.
In the case of Chinnathambi and others versus Anjali and so, it is held that thus it is accepted principles of law that an advocate commissioner should not be appointed to find out the possession of the property, which has to be adjudicated only by oral and documentary evidence.
This
Under
is an
such-
extraction
under-
from some other judgment, what you're reading.
No, it is Chinnathambi, extraction of Chinnathambi judgment. It is. So then, my lord, in this judgment also, last para, my lord, para 13.
Yes.
Para 13, taking into consideration of the facts and circumstances involved in this case and also decisions relied on by the learned counsel for the petitioner. This court is of the considered view that the impugned order appointing an advocate commissioner is unsustainable in law, and hence the same is liable to be set aside, and accordingly it is set aside. And then second judgment also, my lord,
Yes.
please. Para 4, my lord.
Which judgment?
Judgment is, my lord, Arihant Jain Society,
Para number?
para number 4.
Yes.
Para number 4. I have fortified my opinion on the basis of the judgment delivered by the Honorable Punjab and Haryana High Court so and so, wherein Honorable Punjab and Haryana High Court held that the possession question is to be determined by the court. Such a question cannot be left on the local commissioner. In another case also so and so, the Honorable Punjab and Haryana High Court held that local commissioner cannot be appointed to report as to which of the party is in possession of the house in dispute, because it would amount to delegate the power of court to determine the real issue in the case. Well, and so my respectful submission is, well, the commissioner has to be appointed to identify the property or location of the property or boundaries of the property. So far as possession, to ascertain who is under possession, it cannot be. It is a very well settled position of law.
Yes.
Please. Lord, I have other judgments also.
Just pass on.
Please, I will. Another 3 judgments I am passing over.
Yes.
Please. That is the judgment, my lord, Bongu Ramul versus Guddur Narendra Reddy, para 7. May I read, my lord? Para 7, my lord. In a suit for perpetual injunction, the court has to adjudicate as to who is in actual possession of the property as on the date of institution of the suit on the basis of oral and documentary evidence adduced by the parties, and the said function cannot be entrusted to the advocate commissioner. Now in this case also, my lord, evidence is led, evidence is over. The court, it is the, always, my lord, it is the principles of law that so far as possession is, it has to be adjudicated by the court only. The commissioner cannot be appointed.
Yes. Next.
Please. My lord, next judgment is my lord, Parepalli Satyanarayan versus
Which paragraph?
para 12, my lord.
Yes, please read.
Para 12.
Yes.
That is the citation number 5 I have written in the left side of the citation. Para 12, may I read?
Yes.
Please. Para 12, my lord, a commissioner cannot be appointed to find out as to who is in possession of the property, but he can be appointed to make local investigation to ascertain the facts or other material which are found in the property and to make a report in regard that matter of to the court. The order of the lower court was directing the commissioner to make local inspection of the suit premises, to break open the log provided that the petitioner is in occupation of the premises and to note down the physical features. The commissioner filed a report mentioning that the property was identified in the presence of both the parties and he broke open the lock and entered the suit premises and found some articles and furniture in the premises and noted the physical features. The commissioner did not mention that the suit premises was handed over to the plaintiff. Unless breaks open the lock, he will not be in a position to know the physical features of the Malgi from outside. Then my para 13, para 14 is also mirrored last para. Accordingly, the revision petition is dismissed not only on merits but also on the ground that it has become infructuous due to execution of warrant. My lord, next judgment is, my lord,
Yes.
please. My lord, Puttappa versus Ramappa. It's in fact the judgment is by the Karnataka High Court. Para 3, my lord.
One judgment you're relying on is
Pardon?
Himachal Pradesh, come to Himachal Pradesh judgment.
That judgment, my lord, I
Read
will,
paragraph number 15.
please. My lord, para 15, my lord,
Yes.
please. Para 15. In my considered view, primarily whenever any order is passed under Rule 9 of the Order 26 of Code of Civil Procedure, the satisfaction has to be the court as to whether local investigation for the purpose of elucidating any matter in dispute is necessary or not. This satisfaction cannot be of the plaintiff or defendant. The plaintiff or the defendant has to stand on its own legs, and provisions of Order 26 Rule 9 of the Code cannot be used to garner or gather evidence for them through the court process. This is exactly what has been held by the learned court below by way of the impugned order. The learned court has held, and rightly so, that onus is upon the plaintiff to prove their case, and the court cannot lend a helping hand and assist the plaintiff to prove their case. These findings returned by the learned judge, learned court below, cannot be said to be illegal, as they are in consonance with the spirit of law with regard to the interpretation of Order 26 Rule 9 of Civil Procedure Code. Plaintiff cannot be permitted to local commissioner appointed simply because they have not been able to lead cogent evidence to prove their case. That is not the intent of Order 26 Rule 9. Exactly, I am relying on this. So the court cannot appoint. Please,
Please come.
please.
Agreed with the orders passed in I number 11 in OS number 197 of 2019, dated 10 December 2025, by the Principal Civil Judge and JMFC Chanakere. The defendant is before this court. The respondent herein has filed a suit seeking
My submission would be this minute, that paragraph exactly applicable to this case, madam.
I'll record, you have relied on so many judgments.
Court commissioner, it's
The writ petition, the suit is filed seeking a declaration that the plaintiffs has absolute owners in possession and enjoyment of the southern portion of the suit scheduled property, to cancel the sale deed dated 9/11, 1966, to grant a permanent injunction by restraining the defendants from interfering with the suit scheduled property. The defendant has filed the written statement The defendant has denied the possession of the plaintiff in the suit. The present IA came to be filed by this plaintiff seeking appointment of an advocate commissioner. Stating that the plaintiff has filed the suit for declaration and and the defendant has filed the written statement that he is in possession of the suit scheduled property and further submitted that during the cross-examination of DW1, that is, he himself admitted the possession of the suit property to, he has admitted that an appointment of any advocate commissioner may be appointed. Hence, the present application is filed. It is stated that no harm will be caused to the defendant, that is IA number 11. The court has allowed the said application, observing that to substantiate the case of the plaintiff, he has filed, he has examined, he has filed 8 documents, that's exhibit P1 to P8. Defendant has placed 3 documents, exhibit D1 to D3. Having gone through all these oral as well as the documentary evidence, what appears is the parties cannot bring out the actual truth of encroachment in the suit scheduled property. This oral and documentary evidence might be relevant for providing the possession, having the title, payment of taxes, and visualization or something that are appearing in this part. Therefore, in the opinion of the court, in order to determine the alleged encroachment of any as alleged by the plaintiff, to ascertain through the court commissioner only by making local investigation, measuring properties of both parties, and in the absence of the same, the courts cannot come to the right conclusion on the basis of oral as well as documentary evidence which is available on record. DW1 has also admitted during the course of cross-examination that he has no objection for appointment of a commission and to measure the property. Thus, the appointment of the court commission is absolutely warranted and without which the court cannot come to right conclusion in that regard. Then the court has relied on a judgment passed in WP number 201274 of 2022 in case of Sadaksharappa versus the Commissioner City Municipal Council, Sindanur, wherein the High Court was pleased to issue certain guidelines for the cases like this on hand. In the light of the same, the court has allowed the IA and advocate is appointed as court commissioner to make local investigation of the suit scheduled property. The commissioner shall measure the property of the plaintiffs, point out the alleged encroachment if any in the suit scheduled property, including encroach road to it. Agreed thereby, the defendant is before this court. Learned counsel appearing for the petitioner defendant submits that though in a cross-examination, during the course of cross-examination, though it is admitted by the defendant that the court commissioner can be appointed, that cannot be the basis for the court to appoint the court commissioner. It is submitted that now the court commissioner is appointed to find out who is in possession of the property. Such an exercise is impermissible. In that regard, he has relied on several judgments. He has relied on a judgment of the Himachal Pradesh High Court in case of Ramnath and Naridhar versus Kuldeep Singh and others. He relied on paragraph number 10, 11, 12, 13, 14, and 15. Next, he relied on the judgment of the Andhra Pradesh High Court in case of Parepalli Satyanarayana versus Udukuri Minender Gout Marinder got reported in 2008, 1 ALD 461. He relied on paragraph number 12. Extract all that. Then he relied on another judgment of the Andhra Pradesh High Court in case of Bonguru Amalu versus Guduru Narendra Reddy. He relied on paragraph number 7. He relied on the judgment of the Madhya Pradesh High Court in case of Sapna versus Indore Municipal Corporation. He relied on paragraph number 9 and 10. Then Punjab and Haryana High Court in case of Arihant Jain Society versus Gyan Kaur, paragraph number 4. This is reported in 2000 Supreme PNH 1485. Then he relied on the Madras High Court judgment in case of Elango versus Kasturi. He relied on paragraph number 9. Relying on these judgments, it is submitted that the court cannot appoint an advocate commissioner to find out who is in occupation of the property, and submits that the order impugned is illegal, contrary to law, and the same needs to be set aside. Next paragraph. Having heard the counsel for the petitioner defendant peruse the material on record. The suit is not the important aspect in this case is the suit is not for injunction. Suit is for declaration, injunction, and also for cancellation of the sale deed. In this case, the entire evidence is completed. Then the court has appointed has recorded the reasons in the order and appointed the advocate commissioner to know whether there is any encroachment as alleged by the defendant. The court has also relied on the judgment of the High Court arising out of WP number 20124 of 2022 in case of Shadaksharappa referred supra, that how the guidelines are laid down when an advocate commissioner can be appointed. In this case, after the entire evidence is lettered, for the clarity of the court to adjudicate the dispute between the parties, the court has appointed the advocate commissioners to know about the encroachment. The judgment, in one of the judgment the petitioner has cited, that refers to a suit for injunction. A suit for injunction cannot be equated with a suit for declaration of title and injunction, which is a comprehensive suit. And in the judgment of the Punjab and in the Himachal Pradesh judgment, which the learned counsel for the petitioner has relied upon, the court has observed that the satisfaction has to be of the court as to whether local investigation for the purpose of elucidating any matter in dispute is necessary or not. The court, in the facts and circumstances, has felt that to understand to decide the dispute involved between the parties, this local inspection is very much required. Basing on this, any advocate commissioner's report is not conclusive in nature or is not binding on the court. The court will analyze the same basing on the other evidence that is let in by the parties. Basing on the advocate commissioner's report, the suit for a declaration of the court will not declare that somebody is owner of the property. So even on that count also, the judgments that are relied on by the learned counsel for the petitioner will not apply to the facts and circumstances of the case. In the considered opinion of the court, by analyzing the dispute between the parties and also considering the judgment of the court, has rightly passed an order, and this court finds no reasons to interfere. Accordingly dismissed.
So number 10, Puttur Padmavati for petitioner.
I'm appearing for the petitioner, my lord. In the connected matter, this court has already granted the stay regarding the double compensation, my lord.
Number
18995 of
same order in like
2026.
that, write on a paper and
Yes, ma'am.
yeah.
Then number 11,
Appear for petitioner. I
Only
made a
the-
representation on 7/5.
Figures will change. Look at it. Just the figures will change. Yes.
I made a representation on 7/5 to the Transport Commissioner about illegal operation and to give direction. My representation is still pending, no action is taken.
Who are you and what is?
I am
your-
a rival operator, my lord. And I have got a common route between Kolar to Bangalore and services are in operation without a permit.
It is under process, my lord. It will be considered, my lord, 4 weeks, my lord.
The present writ petition is filed seeking the following relief. Then counsel for the petitioner submits that with regard to flying of the flying of the vehicles without any permission, permit, he has given a representation to the respondents dated 13th, when is the date? 7/5/2026, and the respondents have failed to consider the same, which made the petitioner to come before this court. Next paragraph, and Leonard AGA, who is appearing on behalf, who takes notice on behalf of the first respondent,
Sole respondent.
on behalf of the respondent submits that. The said representation is under process and they'll consider the same within 4 weeks. Considering the next, considering there are.
On instructions.
Huh?
On instructions, my lord.
On instructions, he submits that, considering the, considering the submission of the Leonard AGA on instructions that they'll consider the representation within 4 weeks. This court is passing the following order. The writ petition is disposed of, directing the first respondent to consider the representation within a period of 4 weeks from the date of receipt of the representation dated 7/5/2026, within a period of 4 weeks from the date of receipt of the copy of the.
Obliged.
Number 12.
Same? Yes.
Cell number 13.
I prefer the petitioner in this case.
What?
My lord, in the execution proceedings, my lord, you are the objector filed an application under 21 rule that 97/99 in the March 2025.
Not considered.
Not considered, my lord, you have, both sides submitted their argument citations. Still, I is kept pending. Kindly, my lord, page number 57, my lord.
Present writ petition is filed saying the following prayer. Learned counsel for the petitioner submits that as an objector, he has filed an application under order 21 rule 97 in the month of March. And after hearing the arguments.
2025, my lord.
March 2025.
25.
25, even after the arguments are concluded, even till now, the orders are not
Please.
pronounced on the same. It is causing it causes lot of hardship to the petitioner. Next, having heard the counsel for the petitioner, considering the fact that an IA and order 21 rule 97 is filed in the year 2025 March, and till now the orders are not passed. This court is passing the following order. The writ petition is disposed of, directing the court, directing so and so to pass appropriate orders on the IA within 15 days. IA number
23 of 2024.
5.
25.
IA number 23 of 2025 within a period of 15 days from the date of receipt of the copy of the order.
Please.
This court is not, in the order itself, this court is not proposing to issue notice to the respondents at disposal of the cases in the interest.
Obliged.
14. Mohan.
Let's serial number 14 and 15 are same. Let's one IA number 1 and 2 has been challenged. Let's this is a suit filed by.
No,
This
we are
is a
looking at WP 19365.
yes.
It arises out of.
Out of IA number 1, Millets, which is filed under 39 rule 1 and 2 for not to interfere with the peaceful possession,
happened to
Millets.
that?
Millets, the expert, the emergent notice has been issued, Millets,
It
which
is
is at page number 46, Millet.
Returnable.
By 29/8/2026, Millets. Millets, the
Number?
crux of Millets,
Page number.
46, Millets.
No crux is required. I will ask the court to decide your case.
Millets,
Within
what has
1 week.
happened here, Millets? Millets, only 2 minutes, Millets. Please, Millets.
Even if I give you 1 hour also, but the result remains to be the same. I'm against passing an injunction order. What has to be done by the trial court by keeping the matter pending here? I will ask the court without whether the no summons are served on them or not. Within 1 week from the date of the order, they should consider your IA. That will serve the purpose.
At least till then
No,
status quo
no
may be.
till then, no till then.
Let's
This
please-
order is passed on 18/6. Till now, nothing has happened. In next 1 week also, nothing will
Let's
happen.
hear the fraud has been
Whatever
happened,
it is,
let's-
let the court decide. I'll not decide this. Please come. The present petition is filed. Agreed with the order dated 18/6/2026, whereby the court has issued summons to the defendants returnable by 29/8/2026 without passing any orders on the IA that is filed seeking ad interim injunction. Then counsel for the petitioner submits that a fraud is played by the defendants and the court, when an application is filed seeking injunction, ad interim injunction, ought to have considered the same on the merits of the matter without issuing notice to the, issuing suit summons to the respondents. He has relied on a judgment. There is an order in this fashion. You can take from the same order. Accordingly, this court is passing the following order. The trial court shall consider I number 1.
And 2, my lords.
Next matter is
Next
for
matter
two.
is 2.
Both in both the
Club.
matters. IA number 1, 2 is for what?
2 is for not to alienate, my lords.
IA number 1 and 2, both the matters. It's a common order in both. IA number 1 and 2. The court shall consider IA number 1 and 2 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact whether the summons are served on the defendants or not. Number 2, the petitioner can make an application to advance the matter.
Much obliged, my lords.
Cell number 16. Ignoru Vishwanath.
Here, my lord, the petitioner is the JDR, my lord. DHR filed the execution petition for settlement of claiming of amount of 9 lakhs rupees, which is check bounce case in earlier, my lord, settled in the Lok Adalat. In the payment of 5 lakhs, 6 lakhs already paid, my lord. Remaining 3 lakhs in the meanwhile, arrest warrant issued by the execution court, my lord. Impose any condition, I will pay the amount, my lord. So in the meanwhile, stay the execution of the order, my lord.
What is the amount now?
My lord, remaining 3 lakhs, it is there, my lord.
So when are you going to pay that?
My lord, the reason is that, my lord, apart from 3 lakhs, already 2 lakhs I paid, madam. Before the
That you
in
should
Lok
have brought
Adalat.
it to the notice of the court and you should have invited an order from the court.
But my lord,
No, we
there
cannot
no-
consider the fact that you have already paid 2 lakhs because there is nothing on record.
Yes, my lord. Only the remaining, as per record, only the remaining 3 lakhs it is there, my lord. But already I paid the 2 lakhs. Only the remaining exact, only the 1
Who
lakh.
will decide that? Whether you have paid the
It
2
is-
lakhs or not?
My lord, now condition to impose any amount for 1 lakh. I
Please
will,
understand, when there is nothing wrong with the order of the court, why should this court interfere?
my lord, yeah.
No, this
It
is
is
not.
possible, it's possible to going settlement, my lord. So that's
Not
that
settlement.
reason I
No,
request.
it is
with
like
the court.
settlement by staying
My
the
lord,
proceedings.
No, my lord, without issuing the notice, further
For
procedures.
contesting the matter, what for further notice you require?
My lord, trial execution court, it is erroneous order, my lord. Straight,
That's why, if you point out what is
that's
erroneous
why,
order,
my lord,
I will consider.
That's why I request this court
Where is
for,
that erroneous order? Let's read
my lord,
that order.
execution, it is in annexure G in page number
let's see.
25, my lord.
Yes, not 20, it's 29.
Yes, my lord, in annexure G, my lord. In earlier, I filed the writ petition, my lord. In writ petition, I'm challenging the attachment of movable, my lord. So that order in condition on honorable, this honorable court imposed the condition of deposit of 3 lakhs. I pay
We will not continue to do it.
My lord.
Because that is not the procedure. Every order passed by the.
In the
trial
meanwhile,
court,
without giving the opportunity and
What opportunity you require? When is the judgment?
that is, my lord, in 2022, my lord.
So till 2026 also, time is not sufficient.
In the meanwhile, my lord, only the remaining amount for as per recording.
Again, you're going back to the same story.
My lord, that's why I impose any
Advocate
condition.
for DHR present, file certificate copy of the orders passed by Honorable High Court of
Yes, my lord.
Karnataka.
That order, my lord.
Peruse that WB has
Yes.
been dismissed. Stay was vacated. JDR has not paid the balance amount. So
Yes.
again, once that petition is dismissed, another round now.
No, my lord.
Where is that order? Let me see.
That is, my lord,
dismissal order.
dismissal order, it is there, my lord. I have produced it.
Page number?
Annexure F, my lord. That
Page
is the
number.
page number 22, my lord. Annexure F.
Set aside the order of attachment of mobile dated 11/12. When the matter came up before this court passed the following. Learned counsel the petitioner. Petitioner would pay 2 lakhs on or before the next date of hearing. Relist this matter on 4/2 under the caption orders. Therefore, said order has not been complied with accordingly. So you were enjoying an order right from
No, my lord.
23.
May kindly in order sheet of the execution order, my lord. In page 36, my lord. I deposited the 3 lakhs amount, my
When
lord.
you deposited 3 lakhs?
That is, my lord, 2/1/2024, my lord. May kindly in order sheet 36 and 37. They also released that amount, my lord. They was released in 27/6/24.
No,
Yeah.
forget about 24. This interim order is passed on 21/1/2026. You said you will pay 2 lakhs. You have not paid.
In earlier that 3 lakhs amount I
Sorry,
deposit, my lord. Yes, I agree, my lord. Yes, I agree for that 2 lakhs.
Oh, how many times you will come to the court?
My lord, I need time, my lord.
No time.
My lord.
Court has given enough
My lord,
time to you.
that 2 lakhs amount I will pay, my lord. Please, may kindly.
That's all. Pay it by tomorrow.
Not
I will
tomorrow.
not- I will not
at
grant
least
time
1
like
week,
this.
1 week time may be granted, madam. I will pay, madam, please.
Then I will list this matter on next Thursday. By that time, if you don't.
Next Friday, madam.
Next Friday I will. By that time, if you don't pay the amount of this, whatever
Please,
it is,
please.
I will impose costs of 2 lakhs, another 2 lakhs. That I'm making it very clear. If you are ready for that, then take an order.
Please, my lord.
Please come. Learned counsel for the petitioner submits that an amount of rupees 3 lakhs is due and he is ready to pay the amount if a reasonable time is granted. And within 1 week from today, he is ready to pay an amount of rupees 2 lakhs. Considering the submission of the learned counsel, it is made it very clear that if, as undertaken by before this court, if the amount is not paid by the next date of hearing, an amount of rupees 2 lakhs, this court will impose costs of another 2 lakhs, and the party cannot be permitted to take cannot abuse the process of the court. Accordingly, this court is passing the following order. The order passed by the court dated, there shall be stay of all further proceedings pursuant to the order dated 10/6/2026, passed by the third additional civil judge and JMFC Kolar in execution case number 1 of 2022, on the condition that the petitioner shall deposit an amount of rupees 2 lakhs by Thursday. By Thursday, that is 9th of July. List this matter on 10th of July. And if the amount is not paid by that date, the consequences will follow.
Much.
Notice to the respondents, petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 9th of July.
Then
Yes.
number 17, Sachin BS.
Yes.
Section 10 application is rejected. I filed an application under section 10 in a regular appeal.
What are the suits?
Yes, please. Kindly have a look, page 9.
Oh.
Page 9 of my para 3.
Page 9.
Page 9, para 3. My lord spotted. There I have drawn the genealogical tree.
No, not the genealogical tree.
Plus for
What
better
are the suits?
Yes.
OS number?
Just OS number. First suit is OS number 45 of 2010, which was filed by, that is the reason, kindly compare genealogical tree, which was filed by Sadashiva, the son of first wife of Rama Madiwala. Kindly see, Rama Madiwala has got 2 wives, Kamala and Lakshmi. My lords, for first wife, my lord, Sadashiva and Chandravati are the children. Insofar the second wife is concerned, Kusuma, Shobha, Gauri and Dinesh are the children. My lords, the first suit was filed by Sadashiva as against his father Rama Madiwala and his mother Kamala and Chandravati, sister, for partition. That is 2010 suit.
Final decree is also passed on
Yes,
28/11/20.
yes, final decree is also passed.
Yes.
Against the final decree, Mr. Dinesh, kindly see the genealogical tree. Dinesh, the one of the son of the second wife of Rama Madiwala, has preferred an appeal.
He has not questioned the preliminary decree.
He has not questioned the.
He questioned the final decree.
Final decree.
He questioned the final decree by filing
First appeal.
what is the number?
That is RA number. This is a subject matter of list now.
RA number
Yes, RA number 17 of 2025.
17 of
2025. Yes.
So
Yes.
now till RA
Yes.
is decided, that has to be.
My subsequent suit was filed by Mr. Dinesh, now present petitioner, as against the first wife children and the second wife children also, with a prayer that my father has executed a will in my favor, declare me as an owner. First part of the prayer. Second part of the prayer, you declare that the judgment and decree of 2010 as not binding on me. Third prayer is not to for injunction. For injunction. This is what the.
This is not a
subsequent-
party to earlier proceedings.
I am not a party. Now I filed an RE.
What is this suit?
Which one? Manoj?
Dinesh filed a suit, you are
Yes.
saying.
Dinesh suit, which was filed subsequently, is OS number 48 of 2024.
25.
24.
25.
24.
24.
Yes. So in the RA, which was filed by me, I made an application. Since the subsequent suit is for a comprehensive relief there, till the disposal of that suit, please stay the proceedings in the RE. That application
You
is.
have questioned the final decree proceedings. Was there a stay?
Please, my lords.
You have questioned the final decree proceedings by
Correct.
filing an RA.
Yes.
In RA, you have a stay.
I have no stay. I have no stay.
So what cannot be achieved directly,
All
you are
that I
going
can
to
say
have
is,
it indirectly.
the object of section 10 is that in any event, if I succeed in
And in the
subsequent.
case of RA itself, you don't have a stay. When they can proceed with the execution proceedings, where is a question of granting stay of these suits? I can understand you have a stay.
My lords, I am seeking stay of the proceedings in RA till the disposal of the subsequent suit. That is my application.
That's what I understood. You want, RA is filed by you.
I filed my.
Don't pursue it. Anyhow, it doesn't matter.
That's all is my case. Nothing.
Please come. The presented petition is filed. Agreed with the orders passed in I number 6 in RA number 17 of 2025 dated 30th April 2026, whereby the trial court, whereby the appellate court has dismissed the application that's filed by the petitioner herein. Petitioner is the appellant before the trial court. Appellant before the petitioner is the appellant before the appellate court. The earlier OS number 45 of 2010 is filed seeking partition by some of the family members without making the petitioner herein as a party that came to be decreed on 19/2/2024. A final decree was passed on 28/11/2024. The petitioner herein has questioned the same by filing RA number 17 of 2020. Thereafter, he has filed instituted OS number 48 of 2024, seeking a declaration that the judgment and decree in the earlier proceedings is not binding on him, and also by virtue of a will executed by his father, he is owner of the properties, as the father, as by way of a will, has bequeathed the properties, has become the owner of the property. Now the present application is filed seeking to stay the appeal proceedings till the suit is decided. That came to be dismissed by order impugned. While dismissing the application, the court has observed that as per section 10, A reading of section 10 makes it clear that the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between parties whom they are one of, or they are any of them claiming litigating under the same title. But in the present case, the appellant filed a separate suit for relief of declaration invoice number 48 of 2024, but the respondent number 1 filed a suit invoice number 45 of 2010 for a relief of partition and separate position. The issue involved in the said suit is not directly an issue involved in the suit, invoice number 48 of 2024. On careful perusal of the record, admittedly the appeal is as a continuation of original suit. But in the present case, the appellant has not challenged the judgment and decree passed in voice number 45 of 2010, and he has challenged the order passed in FDP number 1 of 2015 before this court. Further, the issue involved in voice number 45 of 2010 and issue involved in voice number 48 of 2024 are not one and the same, and the original suit was disposed. Hence, there is no necessity to stay the further proceedings of this appeal till disposal of voice number 48 of 2024, and accordingly dismiss the application. Next para. Land counsel appearing for the petitioner submits that the second suit is the suit where that is voice number 48 of 2024. He has also sought a declaration that the judgment and decree is not binding on him, and also he has the issue. Also, he is relying on a will which is executed in favor of the petitioner by the father. The properties belongs to him. So unless and until that suit is decided, the proceedings in RA cannot be, RA has to be stayed. This aspect was not considered by the court, and only on the ground that the petition is seeking a different relief in the suit has dismissed the application. Anything? The application is submitted that the order impugn needs to be set aside. Next, for having the counsels on either side, where is the material on record? The original suit is of the year 45, is 45 of 2010. A preliminary decree, the suit was decreed on 19/2/2024. A final decree was passed on 28/11/2024. Admittedly, the petitioner herein has not questioned the preliminary decree, but he has questioned a final decree. When he has filed an appeal questioning the final decree, the court has not stayed the execution, but the court has not stayed any proceedings, or no interim order is passed in the appeal. Then he has filed after 4 years from the date of after that he has filed the present suit seeking different reliefs. The court was right in dismissing the application and observing and considering section 10 of the specific 10 of the CPC and the facts and circumstances of this case, and particularly the fact that the preliminary decree is not questioned. The court has rightly dismissed the application, and this court finds no reasons to interfere. Accordingly dismissed. Yes.
Cell number 17, 18, cell number 18,
Yes.
For petitioner, my lord,
Sampathye.
seeking expeditious disposal. Petitioner is a defined number 1 in his suit, my lord. The plaintiff obtained.
Which year is the suit?
My lord, sir, only an application, my lord. Expert
What is the IA?
My lord, IA number 1, my lord, filed by the plaintiff.
One of?
IA number 1, my lord. It's only numbered as 1, not one of.
Which year?
It was 2025. Expert injunction he has obtained. I entered appearance and sought to vacate that application.
When did you enter appearance?
On the next day, my lord, order was passed on 2/8/2025. Expert injunction order.
From that date is continued.
From that date is continued. Pleadings are completed. I filed return submission. Everything, my lord. The still, my lord, kept on adjourning, my lord, because plaintiff was seeking extension. And to hear on the application is gone.
Which code is this?
My lord, it's Bangalore only, my lord.
Please come. The presented petition is filed seeking the following prayer, and counsel for the petitioner submits that petition is a defendant in the suit, and the respondent here in the plaintiff had an ex parte injunction in his favor, and after entering appearance, the petitioner has filed the written statement, his objections, and even when the pleadings are complete, the court, without considering the IA number 1 of 2025, is continuously extending the ad interim injunction that is granted. Hence he is before this court, seeking a direction to the trial court to expeditiously dispose of I number 1 of 2025. Next, having heard the counsel for the petitioner, and considering the fact that this injunction was granted on 2/8/2025 and is continued till now. It is almost, even after more than 10 months, the same was not considered by the court. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the so-and-so to dispose of I number 1 of 2025 as expeditiously as possible, but not later than 1 month.
Please, great.
Number 19, C.N. Keshavamurthy.
For the petition in this case, my lord, I'm producing translated copy of the affidavit as directed, my lord.
Take that. What is this IA?
IA under Order 6 Rule 17 of CPC filed by the plaintiff rejected on technical grounds, my lord. Even trial court has not looked into the grounds reasons asserted in my affidavit.
It has dismissed.
Dismissed. With even the trial court has.
What is of which year?
Suit is of the year 2016 for declaration and permanent injunction against the defendant number 8 not to put up the construction. Thereafter, my application Order 39 Rule 1-2 was allowed by the trial court.
No.
And thereafter, he filed MFA.
Details are not
MFA
necessary.
pending up to 2025, my lord.
2000. What is the present stage?
Present stage is evidence is completed and survey report by the assistant director land record has been received by the trial court, and in the report,
No
my lord,
matter is posted for arguments.
final arguments, my lord.
At that time, you want to amend the plaint.
No, my lord. Immediately after filing up the report by the survey department.
That is after the entire evidence is concluded.
Because the encroachment area was specifically mentioned.
You can answer to my question.
Yes,
I
madam.
said after the entire evidence is completed.
Yes, madam.
When the report of the surveyor is pending, at that point of time, you file this IA.
Yes, madam.
Let's see your
Only
affidavit.
for possession in respect of the
Let's see your
particular
affidavit.
encroachment area, my lord.
Let's see the affidavit.
And there was injunction not to put up the construction by the defendant number 8. In spite of it, he has constructed during the pendency of the suit.
Come to-
Subsequent event, my lord. Affidavit, my lord. Shall I read? My lord. My lord, undisputedly, my lord.
Let me read it. Unless
I'll
and until I
read, my
read
lord.
it, there is no purpose.
Para 2, my lord. It's filed by the, I and other plaintiffs have filed this suit before some court seeking relief of declaration of rights and also a direct injunction order against the defendants. This root property originally belonged to
Where are you
Lakaya.
reading?
My lord,
Where are you reading?
affidavit to second paragraph.
There are no paragraphs in this.
They have not mentioned para number in
Page number, internal page 2.
page 1, my lord. Page 1.
Let's not read. This is all repetition of what you want
Yeah,
to say.
please, madam,
You can
please.
come to page number 3, second para.
Yes, my lord.
Yes.
In this suit, after considering the documents of both parties, this honorable court has issued an injunction order prohibiting the construction of any building on the suitable property. Thereafter, the 8th defendant filed an appeal in the High Court of Karnataka in MFA number 6109 of 2026 against the above said injunction order. In the said appeal, 8th defendant has filed an affidavit stating that if the plaintiff prove that the suitable property is encroached, he will demolish it at his own expense and hand it over to the plaintiffs. Later, while the defendant number 8 continued his illegal act and during pendency of the suit, the defendant has continued his illegal act and encroached land to the extent of 2 acres. That is 7.5 guntas in survey number 37/4, 8.5 guntas in survey number 37/5, 33 and half 33.5 guntas in survey number 37/6, 15.5 guntas in survey number 37/5. This is clearly seen in the report of the Code Commission dated 13/1/2026, submitted as per the order of this honorable court. It appears
Yes, I've seen. Come to the order.
subsequent event, my lord. Sir,
I've read the entire
please, madam.
affidavit.
Yes,
You
madam.
say that there is encroachment, it has to be removed.
Yes, madam.
As per the commission's report also, there is encroachment.
Yes, madam.
Hence, you want that amendment to be carried in the plaint.
Only for possession and removal of encroachment.
Yes. Now, please come to the impugned order.
Yes, my lord.
Page number?
66, my lord. Page number 66 of the impugned order. No reasons aside not made any reference regarding grounds urged by me, my lord. In page 2 of the order, my lord. In the affidavit, it is stated that plaintiff filed suit for declaration of permanent injunction in respect of social property. It is their specific case that defendants have got muted the kata in their names. Hence,
Please
filed.
come.
No reasons grounds aside, ma'am.
Then counsel for the petitioner submits that when an application is filed under Order 6 Rule 17, stating that the commissioner's report clearly states that the defendant has encroached the property of the plaintiff and made constructions, and when the petitioner wanted to amend the prayer by amend the pleadings by inserting the prayer that the said encroachments have to be removed and the petitioner has to be put in position, the court recover your position also you sought.
My lord.
What is the relief? It's only to remove the encroachments and
Yes, remove the encroachment by demolishing the constructed area presently.
by removing to remove the encroachments. It is submitted that the court, without even considering what is the amendment, in the light of the undertaking that is given by the defendant before the
Number 8.
High Court,
Defendant number 8.
defendant number 8 before the High Court in the MFA, the court has mechanically dismissed this application. Considering the submission, there should be stay of all further proceedings. So petition is permitted to take out hand summons on the counsel appearing for the respondent.
My
To
lord.
file a memo to that effect by 23rd.
My lord, a notice to defendant number 1 to 7 may be dispensed with their place ex parte and no
MO is
relief.
filed seeking dispensation of notice to
1 to
respondent
7 respondents.
as they remained ex parte before the trial court. The same is dispensed with at the risk of appellant. Notice to 8 to
8 I will take.
only 8.
8.
Notice to the 8 counsel appearing for the respondent before the trial court. Yes.
Number 20.
In all this, whenever I say notice in addition, hand summons.
Much obliged.
Yes.
Number 20. Rina or petitioner.
None appears. This is matter in the month of September. Is 21.
Till number 21. 21.
For the petition.
Yes.
My lord, this is a money recovery suit filed before the commercial court, my lord. The mandatory premeditation is not complied. What they do to mislead the registry is they say in the pleading that we have filed order 39-192 application. Since we are seeking urgent relief, non-shutter is not required. Mediation report is not required. That's what is pleaded in the plaint. And in the IA, my lord, the order 39-192 is a prayer, but since it's a money recovery suit, there's no property in question for injunction or restraining from transfer or alienation. Because the law is in when there is a mandatory premediation can be bypassed in case of urgency. That is when the property is being alienated, like trademarks and things like that. It's a position of law. So here they put order 39-192, but the prayer they seek is for attachment of bank account. And the court has passed an ex parte order of attachment of bank account and under the application filed order 39-192. So in substance, what has happened today is it's a money recovery suit, ex parte attachment of bank account being passed. And since it's order 7 suits, once I appear.
Let's see the order.
Yes, my lord. And another issue is once I appear, they file the summons for judgment since it's summary suit and I file my application for leave to defend. So now it's already for orders on leave to defend. So if the leave to defend is not granted, there is summary judgment itself is going to be passed. So in a way, it completely bypasses all the procedure.
Let's see. What is impugned now?
Yes,
Page number?
Where's the flag? What have we done, boss? Are you serious? Impugned order.
Where is impugned order?
Yes, my lord. Page number 61, my lords. 62 is the order, my lord. Where are the flags? What have we done? Page numbers, keep it handy. Open the soft copy of the index or something. And another thing, my lord, the impugned order, my lord, it's a non-speaking order because the court has to pass an order on saying that why there is urgency, why there is a requirement.
The order is passed on 15/12/2025.
Yes, my lord. So the reason being before your lordship, so this delay is, my lord, I filed an application for rejection of plaint because the law is clear that if the mandatory provision is not complete, the plaint has to be rejected.
Where is the order on that?
My lord, now what has happened is there are 4 IAs pending. The order IA number 1 is filed by them on 39-192, my lord. My IA number 2 was treated as objections to the IA number 1. And IA number 3 was rejection
Matter
of.
coming up before the trial court.
My lord, my matter is tomorrow for orders on all the 4 applications. Just let me bear with it for a moment. My lord. IA number 3, I filed for rejection of plaint. So I persuaded before the learned court that let orders be passed on IA number 1 to 3. Then the leave to defend has to be considered. But however, since they argued on leave to defend for summary judgment, it was posted for orders on IA number 1 to 4.
Whenever you remember, you will not question the orders. An order that's passed on 15/12/2025 cannot be, there is no urgency for it now.
My lord, the urgency that they are reserved for orders on IA number 1 to 4, my lord. Ideally should be reserved for orders on IA 1 to 3.
So you're anticipating something that, that IA 1 to 3 will not be in your favor, so you question this order now.
My lord, the question is if the trial court, for example, decides that IA number 4 leave to defend, I'm not granting.
No, why should we stay the proceedings is a question.
My lord, the mandatory compliance as per law has not been followed.
You were okay with it from the last 6 months?
My lord, because I filed an IA to recall that order, my lord, I filed an objection.
For it, why should we interfere it?
But however, my lord, all the IAs have been ordered together, my lord. It's for posted for orders
I
together.
will not grant stay in this matter, whatever, however, you may have, the merits of the matter.
Well, one indulgence if I seek from your lordships, my lord, at least lordships can direct the trial court to hear and dispose of IA number 1 to 3.
I can pass that order.
At least that much relief is required, my lord, because if 1 to 3 is heard and decided, then the IA number 4 is a separate issue.
Hey, this is what is a writ petition file.
Yes.
However, this court is not inclined to, pass orders for the reason that the already 3 IAs were pending, let there be decided.
Yes, my lord.
No,
After
you
that-
will lose the right to file a question this again. That is there. If you want that order to be passed, you will write, if you want to question this, you cannot.
Well, because if the IA number 4 is allowed, it will be anyway commercial appeal, my lord.
So that you can
will-
go through. So you have to, in a strict sense, you're foregoing your right to go question this order.
Well,
if you
another
dispose it
reason,
off
if I
now.
bring to your lordship's notice, my lord, I of course is a delay in filing this writ petition.
No, that's why what I am saying is,
Yes,
if
ma'am.
you want, I can adjourn this matter. You can take out hand summons. I'll give you a date when they also appear. I can pass orders. I can pass orders on the merits of the matter. I am on the point of interim order. I am not inclined to grant interim order on a order which is passed on 15/12/2025.
Yes, my lord. My lord, as far as this aspect is confirmed, I agree there is a delay, my lord. But however, my lord, if everybody in the country, my lord, who is filing money recovery suit, they can file order
It is
39192
on the merits.
and ask for attachment of bank account.
That's what I'm telling. I can pass an order on the merits of the matter.
Yes, my
What
lord.
you say, there is I can appreciate all that, but not for an interim order. On a final order. For finding a final order, presence of the respondent is necessary. So I can give you a week's time. If you can, serve the hand summons, I will take it up next week itself. But not an interim order in this.
My lord, in that way, may I request, my lord, the earlier submission made that orders can be passed on IA number 1 to 3 and liberty may be given as per the orders of I 1 to 3, my lord.
Let's not complicate it. What I do is, please come. When counsel, the petitioner is permitted to take out hand summons on the counsel appearing for the respondent to the trial court and shall file a memo to that effect by 9th of July. If the memo is filed, list the matter on 10th July.
Yes.
Number 22,
Obliged.
22 Puneet C for petitioner.
Petitioner, writ of mandamus seeking direction to dispose of the suit.
Which area is the suit?
2019 partition suit.
What is the urgency for a 2019 partition suit?
My lord, I'll submit, my lord, I'll take a specific contention before the trial court that suit schedule property is my self-acquired property. My lord, which I have purchased through a loan. My lord, I have.
What is this?
My lord,
What is this?
my lord, this is Ramnagara, please, my lord, Magadi code. My lord,
Ramnagara?
Magadi code. Magadi, please, my lord.
We can't pass it up.
My lord, the only thing is kindly see annexure D.
Whatever it is, I
My lord,
don't know.
my
What
lord,
are the pendency about?
the bank
matters?
the bank issued possession notice since I have not paid the EMIs. My lord,
Every litigant has his own problems. For the higher court to issuing a direction to the trial courts to dispose of the matters, we cannot grant any orders unless and until 2019, the civil suit, there must be so many.
only one submission, please. My lord,
Yes.
that the plaintiff is my son. And I am alive. He filed a suit
Then you
taking
file-
contention.
No,
My
you
lord,
will,
he's
you
a
will
minor.
stand on
My
a
lord,
better footing
my lord,
than anyone.
it's
because
a
he's your
matrimonial
son.
dispute between me and my wife. Hence, my lord, she filed a suit in my in the name of my sons, please. My lord, kindly see the
I
plaintiff.
can only grant you the relief provided I ask for a report what are the pending matters. And I think it is a futile exercise. Definitely there must be so many matters which are much older to this matter are pending on the file of Ramnagara court. If
Not
you want, I can
Ramnagara
call
court,
for a
madam.
report.
My lord, it is Taluk court, Magadi, please.
Yes, please come. The registrar judicial is directed to call for a report from the Principal Civil Judge and JMSC, Magdi, Ramnagaram. What are the pending cases? List this matter on Tuesday, Wednesday.
Lord, in preliminary hearing, please,
Huh?
Lord. In preliminary hearing.
First list.
Serial
Yes.
number 23, BC Sitaram Rao.
This is a petition filed by the plaintiff, suit for partition. In a suit for partition, the defendant files an application under Order 6 Rule 17 to add one property to the written statement schedule. That property was purchased in the year 1999 by the plaintiff, by this petitioner, in the name of the father. The father refused to return it back to him. So in 2008, an original suit for declaration was filed that has been decreed. Against that, there is an RFA pending. It becomes res sub judice. Even that was brought to the notice of the trial court. Yet, amendment has been allowed to add that property in the partition suit.
What happened? Your suit for declaration is decreed.
Decreed in my favor.
Who are the parties to that suit?
The father. Father passed away in the year 2022, so he is only prosecuting. The respondent number 2, who has made the application today, is the one who is contesting the.
They're only like the children are only two in number.
Please,
Please come. Where is that order?
Impugned order is at Annexure G, 103. It has been allowed solely on the ground, that it is pre-trial amendment. I've also produced the judgment of the.
Where is the? Let's see the findings.
That's findings, is at paragraph 12 and paragraph 13, page 113. It is material to note that the amendment to the pleadings may be allowed at any stage of the proceedings to determine the real controversy, to provide necessary.
So what all you're submitting before the court, where is that?
In my objection statement, I have stated, my objection
where it is recorded by the court?
It has not been recorded. Page number 101 is my objections.
Page number?
101. Paragraph number 12, my lords, in this also. It is submitted that the appeal RFA 454 of 2011 was filed in the year 2011 in the name of the plaintiff's father by his elder brother with an intention to grab my property. However, the father could not have given my property to the first son, that is defendant number 2 herein. It appears that taking advantage of his failing health and helplessness of the aged parents, defendant number 2 manipulated a will bequeath my self-acquired property belonging to the plaintiff. Even if the alleged will was created by the defendant number 2, it would not inure to his benefit, for the simple reason that the property in question was held to be my property in the suit, which was fully contested by the plaintiff's father and defendant number 2.
Then counsel for the petitioner. Plaintiff submits that the defendant number.
He was not the defendant there, my lords, in the trial.
In the suit.
In this suit, defendant number 2.
Defendant number 2 has filed an application seeking amendment of the written statement and to add the property which is subject matter of a suit for declaration as a joint family property. It is submitted that suit for declaration which is filed by the petitioner herein has been decreed, where the father is a party and the father has carried the matter in appeal, and during the pendency of the appeal he passed away, and the defendant number 2 is impleaded as a party to the appeal. In spite of bringing all these facts, the court has allowed the IA. This court has perused the order passed by the court, and there is no mention in the order with regard to this. Considering the same, stay of all further proceedings in so and so.
Stay of only the order.
Stay of all further proceedings pursuant to the order passed by the so and so.
Please.
Notice to the respondents. Petition is permitted to take out hand summons on the counsel appearing for the respondent, file a memo to that effect by 23rd. You should say notice and in addition by 23rd, and if the memo is not filed, the stay granted by this court stands vacated. Yes.
Serial number 24, Manikanta.
One submission, one submission in 22nd matter. My lordship has called for the report. It should be called from Magdi Court, please, my lord.
I said
Principal-
that only. Whatever is there in the cause title.
Please, my lord.
Yes.
Cell number 24, Manikanta.
It's a suit, it's writ for mandamus, my lords. It's a partition suit of the year 2010.
2010.
Yes, my lords.
Which court?
My lords, Arkal Good, my lords. Civil
Is
judge,
it pending?
my lords.
Why is it pending?
My lords, applications after application by plaintiff to bring on LRs. It takes years together.
How many defendants are there in the suit?
My lords, 34, my lords.
Huh?
34.
What will the court do?
My lords, evidence was already commenced in the year 2016.
What is
Thereafter-
the present stage?
My lords, it's still on bringing LRs to take steps. That is what it is, my lords.
No, even if I pass an order to bring the LRs, again objections,
That's
what
an
the
hour.
court can do?
At least, my lords, if a direction is there, my lords, at least it would,
How many years direction should be given?
that's 2027 by the end of 2027.
At 6 months, it's too early for this 40 respondent.
End of 27 minutes.
End of 27.
27.
The writ petition is filed seeking the following prayer. Then counsel for the petitioner submits a partition suit of the year 2010. And from the last 16 years, the suit is pending. It is submitted that considering the fact that it's a long pending case, there may be a direction to the trial court to dispose of the matter. Next, having with the counsel for the petitioner, this court has perused the documents placed before the court, and it appears that there are several respondents in this writ petition. Several respondents, there are a number of parties in this suit. Considering the same, this court is passing the following order. The writ petition is disposed of, requesting so-and-so court to dispose of the suit by as expeditiously as possible, but not later than December 2027.
Great.
Number 25, Diane and Murthy for
Kindly
petitioner.
pass over the matter,
Huh?
held up in another court,
Next,
senior,
pass
kindly
over.
pass.
Yes, next.
Cell number 26. 26, Angri Somshekar.
I accept notice for 1, 2, 3, my lord. Stay.
The learned AGA takes notice on behalf of respondent.
1, 2, 3, my lord.
Respondents 1 to 3.
4
No
to 6.
representation on behalf of the petitioner. This matter in the month of September.
Cell number 27, Siddhappa BM for petitioner.
So appearing for the petitioner.
Siddhappa.
Please, my lord, I am appearing for the petitioner.
Yes.
Lord, the respondent herein has filed the suit seeking for permanent injunction.
Yes.
On 27/8/2018, my lord. My lord, before my appearance, the trial court has allowed IA number 2 and granted temporary injunction on 8/2/2019, my lord. But after appearance, I have filed the written statement on 15/3/2019, my lord. Thereafterwards, my lord, on 8/7/2024, I have filed an application for vacating the interim order grant temporary injunction ex parte on 8/7/2024, which came to be numbered as IA number 7, my lord. On 9/7/2024 itself, the respondent herein has filed an application seeking police protection for the implementation of temporary injunction granted on 8/2/2019, my lord. Thereafterwards, my lord, on 18/3/2025, the respondent filed IA number 8, my lord. The trial court, by its order dated 23/3/2026, dismissed my IA number 7, filed for vacating interim order of injunction granted ex parte. My lord, I have filed MA before the senior civil judge, Chitradurga, MA 84 to 85 or 2026, and records have been called for in this case, my lord. On the date of 23/3/2000, when the madam, my IS7 is rejected, on that day, they moved the application which was pending more than 2 years to advance it to consider the police cell. That application came to be allowed on 24 itself. 24/4/2026 itself. Madam. That I have challenged before your lordship.
On what ground?
On the ground that, my lord, since more than 2 years, nothing has been happened. Only application passed on IA number 7, that is on 23/3/2026. 24th itself they moved and the order came to be passed on the same day.
Then what is
If
happening
really
to the
there was
MA that
no-
you
I
have
have-
filed?
MA
When your
85
MA
or
is coming up,
2026 is pending. My lord,
why is it pending? Why not? You have not filed any IA in that?
I have filed a stay, seeking for stay. The honorable senior civil judge called for records from the trial court. That is
When is it
pending
coming up?
consideration. Unless that is decided, my lord, now by virtue of the police cell, they will try to disperse as such.
No, when did you file the MA? Date of filing MA?
That is, my lord, in the month, the 23, within 1 month from date, my lord, in the April, I have filed it, my lord. Date I am not
So-
exactly, I am not available. Your lordship may at page 58. Page
Now
58
we
of
are
my
in
paper.
July. We are in July. You have to pursue that MA.
Well, I am pursuing, my meanwhile, this is the order passed by. I am pursuing.
This
They are
order is
taking
passed.
time there in MA. Your
That's
lordship
what
for
you
which,
should pursue the court where MA is pending.
may I draw your lordship's kind attention to page 58, my lord? Papers.
Yes.
Well, at 5/5/2006, the note is there in the order sheet of the trial court itself. That is MA 85 to 2026, dated 34/2026, the reference MA 2026, the file of the additional senior civil judge. There, my lord, there is called for, records have been called for, it is mentioned. This is noticed by the trial court itself.
No, it is called for from the last 3 months. It is pending that you have to pursue the matter. You can't ask this court to stay that order when your remedy is there.
I have allowed the remedy, but my lord, this order is, my lord, in coming in the way of consideration, and even if I succeed, this by that time they disperses me, my lord, this I will be put to greater hardship. Therefore, till then, till the disposal of this MA 10 up to this order may be stayed, my lord.
I will grant only 1 week time. You pursue that. I will not pass any order till MA is disposed. I will grant stay for a week. You pursue the MA court. If nothing is happening, I can't help it. It is submitted that agreed with an order of interim injunction. The petitioner has filed
Not
MA.
injunction,
and the
madam.
same is pending
Granting of
consideration.
police help, madam.
And in the meantime, the court has granted police protection for implementation of the order passed by the court.
Other
It is
implementation of the
submitted
order
that
dated
in the
8/2029.
MA, the court has called for the records. Admittedly, MA is filed in the month of April. Considering the submission of the land council that they are pursuing the MA, there shall be a direction there shall be stay of all further proceedings pursuant to the order impugned for a period of 10 days. That is till, what is today?
Today,
Till
my lord, this is
till 13th of July, and it is made clear that by such time the petitioner shall pursue the matter before the MA.
Please.
Notice to the respondents.
Impugned order, your lordship, for further proceedings not necessary.
That's what I said. The impugned order only. They shall be stay of all further proceedings.
Please,
Cell number 58.
Lord,
Nasim.
it is for the mandamus direction, Lord. An application is filed in the suit for partition by the third respondent, 13 and 1 and 2 of CPC, she has taken injunction before the trial court on 19/12/2025, saying that now the trial court passed an order saying that not to create third parties interest. I am the owner of the property. But immediately filed an application seeking
What is
to
this
vacate-
IA number?
IA number 1, my lord.
The writ petition is filed seeking the following prayer. Then counsel the petitioner submits that the plaintiff has obtained an ad interim injunction not to create third party rights
Please, madam, that is only
on
12/2025.
19/12/2025, and immediately the petitioner has entered, the petitioner defendant has entered appearance and filed his objections, and the written
Ab-
statement is also filed.
Application for vacating
The
also.
vacating is also filed, but till now, the court is continuously extending the interim order and but not hearing the matter, but not hearing the IA and passing orders. Next, considering the submission of the land comes to the petitioner, this court is passing the following order. The writ petition is disposed of, directing the trial court to consider IA number
IA number
one,
one.
filed IA number 1 of 2025,
Please.
within a period of 15 days from the date of receipt of the copy of the order.
Grateful.
29. Yes, Venkat Subbarao.
Petition.
Yes.
My lord, the first respondent who suffers an arbitral award, that questions it, my lord, award is passed on 6/3/2017.
6/3?
2017.
Hmm.
But after the award is passed, 2018, my lord, he goes before the regular civil court, my lord, puts forth all several contentions, my lord, files a civil suit. But after lapse of some time, my lord, he withdraws the suit for the reasons best known. My lord, thereafter, my lord, he goes before the commercial arbitration, so files a commercial arbitration suit, questioning, my lord, the award that was passed. But section 34, my lord, is very clear. My lord, the challenge to award, my lord, is 60 days. The court has got power to condone a delay of, my lord, 30 days, and not beyond that. A strict interpretation, my lord, is what, my lord, is contemplated. But however, my lord, in the year 2021, my lord, he files, my lord, the arbitration suit, questioning, my lord, the award of the year 2017. My lord, and the delay condemnation.
17 is questioned in 21.
Please, my lord.
Hmm.
My lord, the suit, my lord, is barred by time, my lord, because 34 does not permit, my lord, condonation of delay beyond 30 days. So, my lord, we were, in fact, court had raised, my lord, maintainability, that's ignored, my lord, and the suit itself came to be dismissed for non-prosecution, subsequently restored. My lord, we entered appearance, and my lord, we filed an application under order 7 rule 11A and D of CPC, stated that, my lord, my lord, in view of, my lord, the strict interpretation of limitation, my lord, suit will have to go, my lord, it shall not be maintainable. My lord, that application, my lord, though, my lord, the commercial court holds that it ought to have been filed on or before 2018. However, says that, my lord, is the issue regarding limitation is a question of fact and law. My lord, that is not so, my lord, in arbitration suits. Section 34 is of a strict interpretation.
Let's see the plaint.
Please. But page 42 is the earlier suit that was filed.
No,
But
the present suit.
64. '76 is the prayer. Set aside the impugned arbitration award dated 6/3/2017. Passed by defendant 3 to 7 being bad in law. Same is conflict with public policy. 76, my lords, will get, my lord, the prayer.
Call for then pertaining to the arbitration, set aside the impugned arbitration award dated 6/3/2017, being bad in law, conflict with public policy, to pay costs. And he doesn't say about anything. Why he has questioned it?
No, it's a separate application is filed seeking condonation of delay.
Where is that?
Yes.
That is ordered,
No, my lord, no, delay is not condoned.
not at condoned.
Not condoned. Yes.
Where is that?
My lord, page 79, my lord, annexure
Whether the
H.
court has the power to condone the delay?
No, my lord.
Then where is the condemnation delay petition?
Correct, my lord, it's filed. Therefore, my lord, we told, my lord, the commercial arbitration court, it cannot lie and it has to go on the threshold itself.
So let's come to the impugned order.
Please. My lord, reasons, my lord, will get at page 25, my lord. I'll read, my lord, paragraph 8 onwards, which would be relevant.
In fact, a decision of my lord was also cited, court concurs with it. The holds that my lord, it ought to have been filed. My lord,
Please come. When counsel the petitioner submits that the respondent herein has filed an appeal, commercial appeal, number 4 of 2021, questioning an award passed by the arbitrator dated
6/3/2017.
6/3/2017. As the said appeal is clearly barred by limitation, petition has filed an application under order 7/11D that came to be dismissed by order impugned, stating that by observing that it's a question of fact and law. Land counsel for the petitioner submits that in an arbitration appeal, commercial appeal, where the appeal is filed on the face of it, beyond after 5 years, after 4 years, that the court ought to have considered the same and ought not to have dismissed the IA, that it is a question of fact and law. Considering the submission, there shall be stay of all further proceedings. Notice to the respondents in addition, hand summons and a memo shall
May
be
I
filed.
seek dispensation to my lord, respondents 3 to 7, they were only
Memo
arbitrators.
is filed seeking dispensation of notice to 3 to 7. Dispense with at the risk of appellant. 1 and 2 notice and in addition, hand summons. And memo shall be filed by 23rd or else a stay granted by this court stands vacated.
Great.
Yes, next.
30, Nayanthara PG, professional.
Yes.
My lords, I appear for the petitioners in this matter. This particular matter forms a part of a large batch of over 40 matters, my lords, all of which pertain to land compensation given to landowners across whose lands the high tension line has been pulled. This honorable court in all such matters has granted stay of the award based on 50% deposit before this honorable court. The same may be considered, my lords. On the last second page of that order dated 12/11/2025 at item 4.
Who appears to the respondents?
Pardon me, my lord?
Who appears to the respondents?
The different landowners, my lords, before the district court, they have sought for
You are
compensation.
appearing for the
I'm appearing for the
Karnataka Power Transmission.
for the KPTCL, my lords.
Oh. What is the amount?
In this case, the amount is 1,11,355, my lords, but it varies in
50%
different.
of the amount.
Pardon me?
On condition of depositing 50% of the amount.
50% of that.
Land counsel to petitioner submits of the in connected matters. The coordinate benches of this court has passed interim orders where there was a direction to deposit. Stay was granted on condition of depositing 50% of the amount. And the petition has placed before the court the proceedings of the red petition number 35682 of 35682 of 2025. Considering the same, they shall be stay of all further proceedings pursuant to the order dated so and so on the condition that the petitioner shall deposit 50% of the amount within a period of 4 weeks.
Please,
from
my
the-
lord,
from the
and
date
it
of
may be
receipt of a
tagged
copy of
along
the
with those
order.
matters, my lord.
Tag along with WP so and so, WP 33682 of 2025 in batch.
If I may just mention also, same thing with item number 60 to 63, my lord.
60?
60, 61, 62 and 63.
1 minute.
In those cases, there is an
60.
office objection raised with regards to maintainability with respect to jurisdiction.
60?
60 all the way till 63, my lords. 4 other matters,
So,
60, 61.
60, 61, 62, 63. Office objection with regard to the maintainability is kept open.
Please, my lords.
In all those matters, office has raised objection. Yes.
Same order, my lords.
Same order.
Deeply obliged, my lords.
Cell number 31.
For the petitioner, my lord, week's time, my lord, is
For what?
my lord, is one more connected is next week is dated, my lord, is same arising suit, my lord, is impleading application.
What is the
that,
number?
my lord, is WP number
Write it and give it to the
9513
court officer, list along with so and so.
9513
Yes,
of
next.
25.
The 32.
32. Cell number 32.
My lords, yesterday I was led by a senior counsel, Mr. Rajesh Mahale. We had sought time to furnish a judgment of this honorable court with regards to criteria in which police protection ought to be granted. There are certain things. I'd like to rely on those judgments, my lord.
Take that.
One judgment. My lords, if I may, my lords, not take much of your time, my lords. Yesterday it was extensively argued.
Yes.
Para number 11, page number 12 may be relevant here, my lords.
Para number?
11, my lords.
Hmm.
Page number 12.
Hmm.
My lords, these are the conditions, my lords, that the trial court ought to have taken into consideration. The gist of it, this is, my lords, detailed reasoning had to be given for grant of police protection. And my lords, if I may just draw the attention to point number C, my lords, there. The trial court shall consider the effect of granting and non-granting of police protection. The trial court shall satisfy itself prima facie case is made out for grant of police protection based on pleadings and materials on record. My lords, in this point, my lords, one submission, no material has been produced, nothing has been, there's only an averment that I am allegedly trespassing there, my lords. There is nothing to prove that I have trespassed or even recording of finding that I am in possession. There is a...
My lord, may I have produced the NCR, please, my lord, even the impugned order also. The police, my lord, complaints, my lord, were being registered. The trial court has taken note of. And
My
I'm
lord,
producing, my lord, this, my lord, for a moment.
Let's read the order, not that NCR. Let's see.
my lords, the impugned order is at page number 14, my lords.
Yes.
The reasoning starts from page number 17, my lords.
Let's read.
Para number 8, my lords.
Yes.
That is where the reasoning starts, my lords. Further, it can be also seen that the plaintiff has approached the jurisdictional police station and they have also registered the complaint as NCR. The defendant number 4, my lords, has relied on judgment of Honorable High Court in writ petition number 51712. That is what is submitted before your lords, my lord. This court has gone through the said judgment. Moreover, in this case, the defendant have not preferred an appeal challenging the order of this court. When the order of this court is not challenged, then it is proper to order the implementation of order of this court on IA number 1. That is, my lords, the temporary injunction.
What do you say?
My lord, my respectful, kindly, my lord, see the page 19, the operative portion.
Hmm.
My lord, what the direction is issued. My lord, the jurisdictional police shall give police protection if the defendants or their men fails to obey the court order and cause obstruction for implementation of the order of this court on IA number 1 is concerned. For a moment, kindly appreciate the NCRs and the photographs, please, my lord, where first petition.
That is true. But where is that appreciation by the court?
My lord, the court, my lord, has taken into consideration, please, my lord, the NCR, please, my lord, and also the, my lord, the...
Where is the discussion?
My lord, discussion is at page 18 at the top, please, my lord, registered the complaint as NCR.
That's it, my lords.
It is a passing remark.
My lord,
The police, my lords, has told...
my lord, my respectful submission is that, please, my lord, he has executed a sale deed in my favor in the year 2009.
Let's not go into the facts of it. I'm not finding, I'm not at all going into any of the facts. He has not filed any, appeal against that order of injunction. That is a glaring aspect.
Please.
We are only on the point, the court has granted injunction. Court has granted police protection. What are the factors necessitated the court to grant injunction is the only thing.
My lord, the repeated, my lord, interference, the NCR.
Where did the court
my lord,
say
the
so?
NCRs, the court says, please, my lord, there is an NCR. Your lordship may kindly appreciate that there is an NCR non-cognizable report registered as against the petitioner is concerned. That is what, please, my lord, I am placing before the court. Pursuant to the, my lord, order of injunction, my lord, there were 2 complaints. My lord, I have produced
I think the court can as well record all that. You can't argue those things which are not part of the order.
My lord, these were part of record. These were produced at the time of the, my lord, the passing of the impugned order.
Did the court give any importance to that?
My lord, the court only, please, my lord, refers to NCR and also refers
The court
to that
only
since he has-
says, the court only says, I have granted injunction. They have not questioned again that order. So in the light of that, I will grant in the police protection.
Please.
One thing the court could have observed, this court has passed an order on so and so, so and so. continuously there is interference and disobedience of the orders of the court. So no appeal is filed.
Well, that would be at page 7, I mean, para 7, point number 1.
That is your case.
The plaintiff has,
That's your case.
my lord, it is only on.
So it happens when the reasons are not granted.
My lord,
this is what happens.
my lord, ultimately, please, my lord, what my submission, my lord, I follow your lordship's, what, my lord, just because, please, my lord, the observation as
To
point.
that, what is that tense here?
My lord, may I read this, please, my lord? My lord, it says, please, my lord, there's a repeated, my lord, interference pursuant to the order of injunction. My lord, page 6 of my document, my lord, is photographs. First petitioner.
What is this copy of the judgment in OS 128?
My lord, what has happened, please, my lord? One Giri Gowda, he filed a suit for partition. I was a party. Jayamma was also a party. My lord, he led in evidence as, my lord, in the place of Jayamma. He was a party to the proceedings is concerned. There was a specific issue raised. My lord, your lordship may kindly appreciate page 27 of my memo, page 27, additional issue dated.
Give him a copy of it.
I have given him. Page 27. Additional issue dated 18/11/2017. My lord, whether the defendant number proves that she is the bona fide purchaser of suit item number measuring to a 2 acre 30 guntas under sale deed dated 9/12/2009. My lord, to this sale deed, first petitioner is a party, my lord, as I already pointed out at page 6, my lord, his photograph is being reflected. And the observation, please, my lord, at page para 29 of the same. My lord, page, it commences from page 35, para 29. May I read, please, my lord?
Yes.
My lord, in this case, defendant number 1 has also not disputed the sale deed dated 9/12. Defendant number 1 is Jayamma, first petitioner's mother. Defendant number 1 in the present suit, my lord, is the first petitioner's mother. He is a party to it.
Yes.
While cross-examining the PW1, the counsel for defendant number 1 has vehemently put suggestion that defendant number 1 has sold item number 1 property to the extent of 2 acre 30 guntas in favor of defendant number 4, in my favor. After purchase, the defendant number 4 is in possession over the said property. And by considering the compromise petition and the admissions and suggestions of the defendant number 1, this court come to the conclusion that the item number 1 of the property to the extent
You
of
are
so and
defendant
so.
number 4.
Please, my lord.
You are
I am the defendant number. Kindly see the operative portion of the observation, my lord, at page 41. Page 41. Further, it is declared, my lord, in the last. Further, it is declared that the sale deed dated so and so obtained by defendant number 4 is valid. And the defendant number 1 is.
Judgment and decree is when?
My
Lord,
lord,
this is
this
on, please,
appeal
my
is
lord.
pending, my lords. I must point out.
My lord, this is on.
No, that's what yesterday you were saying suit is decreed and that was denied by the senior counsel.
My lords, there must have been a mistake in the direction. The appeal is
11/4/25.
No, that he said so. 11?
11/4/25. No doubt, please, my lord, he has challenged it in an appeal. There is no injunction stay order, my lord, to that extent is concerned.
No stay order.
No stay order. Subsequently, please, my lord, the first plaintiff, I mean his mother, she filed the suit for declaration, seeking for cancellation of the, my lord, sale deed is concerned. In that suit, she files an IA, my lord, seeking not to from alienation. That application is also being rejected, considering holding that, please, my lord, prima
Come to
facie.
your complaint. Where is your complaint?
My lord, my complaint would be at, please, my lord. My lord, page 57, my lord, this is in vernacular. But please, my lord, I have specifically stated 9/7/24, your lordship would find. Page 57, the NCR.
These photographs are fine.
First petitioners. Yes, please, my lord. First petitioners, my lord, your lordship may kindly see the photographs also at page 59. Your lordship may extreme left side. My lord, the person, my lord, who's, my lord, holding, my lord, the towel in the head. He is first petitioner Ramakrishna. Is repeatedly, my lord, is trying to interfere. My lord, your lordship may kindly peruse the next photograph, JCB. Is trying to interfere, repeated interference. And recently, my lord, page 60, if your lordship would see, the one person in the extreme light in the middle, the one who is, my lord, in the blue shirt, my lord, is threatening the petitioners, I mean the respondent herein, stating that if you interfere, please, my lord, he'll throw an acid. That is what, please, my lord, this photograph was taken in the police station. If you interfere, my lord, again, my lord, he says that, please, my lord, he'll throw an acid. And the respondent is concerned. Repeated interference, please, my lord.
My lord.
Firstly, please, my lord, there's a sale deed. Possession is delivered.
suffers a decree in OS 128 of
Sale
2000.
deed of the year 2007.
Please, my lord, sale deed of the year 2009. He wants to challenge it in the year 2021. After lapse of, please, my lord, 11 years, they say, please, my lord, that it is a fraud and it is, my lord, only a sham document is concerned. There is an injunction restraining him from interfering. If at all, please, my lord, he was agreed, he ought to have preferred an appeal in before the appellate court.
When was the injunction order?
My lord, that would be on, please, my lord. My lord, 9/7/2024. 9/7/2024, please, my lord. I could only, please, my lord, since, my lord, matter was yesterday, I could only place on, my lord, few of the NCRs. There are other few, my lord, the photographs, my lord, where my lord, I possibly, my lord, to establish that there is repeated interference. My lord, videographs. My lords, my only submission, my lords, I'll draw my lord's attention to my writ petition, page number 52, my lords. Other than saying, my lords, if I may, my lords, fourth paragraph, I submit his application for IA number 2, my lords, police protection. I submit that the defendants who are aggrieved by the order passed on IA number 1 have not preferred any appeal before the appellate court. The TI order granted by this honorable court is still in force against the defendants. In spite of the present, defendants have made any efforts to interfere with my peaceful possession over the suit scheduled property and to destroy the crops over the suit scheduled property by criminally trespassing, which are raised by me and apprehended the jurisdictional police and lodged a complaint against the defendants. But the jurisdictional police have issued an NCR and orally advised that since the matter is in civil nature, there is no specific direction to them to give police protection. My lords, if all these pictures were to be true and there, my lords, nothing comes out in the application or in the IA in this present suit, my lords. Averments taken in another suit of partition where, my lords, Jayamma, who is involved, is not even a party to my suit here. Jayamma is an alleged that there is an allegation saying Jayamma and the petitioner, one here in, my lords, have sold the property. May it be the discussion in the trial court with all the procedure of the trial court, my lords. As far as this is concerned, my lords, if all the pictures were to be true, there is nothing forthcoming on the record. Another pleading in another completely different case of partition, whereas this is for permanent injunction. A suit of this nature cannot be clubbed like this, my lord. If there was to be clubbed, it had to be heard together. That is not the case. This is a nature completely different. If all these pictures, there is no timestamp in that picture, there is nothing in that picture, my lords. A photograph of people standing together cannot be relied on for giving a mechanical police protection order. Those pictures relied on, my lords, can be taken anytime. There is no affidavit to an extent of that. A memo is placed before your lords and seeking police protection of a completely
So
different.
this is part of the IA, not the memo before this court.
Not in this IA. This is not in this IA.
My lord, it is produced. NCR.
As a memo, probably later on, my
As
lords.
my lord, as
It is not in the, my lords. Their application lasts only there without, my lords. In fact, their suit also they've not relied on any document. My lords, I can take my lords to the suit, but that would be waste of court's time.
Please come. Agreed with the orders.
And declaration suit is different, my lords. There are an
No,
appeal is
I'm not going into all that. You only argued.
yes, my lords, exactly. My lords, my learned friend had bought in all of this.
On an application filed by the plaintiff under 151 CPC dated 16th March 2026 by the additional civil judge and JMFC Kunigal. The defendant is before this court. The respondent herein has filed a suit for bare injunction, has filed a suit for bare injunction. In the said suit on 9/7/2024, an order of injunction, interim injunction is granted whereby the defendants are restrained from interfering with the petitioner's peaceful possession and enjoyment of the property. It is the case of the plaintiff that the property, he has acquired title to the property. She acquired title to the property by purchasing the same by a registered sale deed dated
9/12/2009.
9/12/2009. The defendant has not preferred any appeal against has not questioned that order of temporary, the petitioner herein, who is the defendant in the suit, has not questioned the said order of temporary injunction. Thereafter, the present application came to be filed seeking police protection. It is a case of the plaintiff that in spite of an order passed by the court, the respondent defendants are continuously interfering with the petitioner's peaceful possession and enjoyment of the property. And in that regard, they have given a complaint and the complaints were not registered.
No, it was not registered. They've issued NCR stating that
The
what about your remedy
NCRs were
before?
issued saying that as a matter is, it's a civil in nature and the matter is pending, it is sub judice. They'll not interfere with the same. Then the petitioner is constrained to come before the court. It is stated that along with the IA, they have filed the photographs to show the interference by the defendants. The court by order impugned, next part, the court by order impugned had allowed the application. While allowing the application, the court has observed that it can also be seen that the plaintiff has approached the jurisdictional police station and they have also registered the complaint as NCR. The defendant number 4 has relied on judgment of the Honorable High Court in WP number 5172 of 2019. This court has gone through the said judgment. Moreover, in this case, the defendants have not prepared any appeal while challenging the order of the court. When the order of this court has not been challenged, then it is proper to order for implementation of order of the court on I number 1. Further, the court observed that if the proper protection is not provided, she'll be put to irreparable loss and injury, and the order of this court would become fruitless. Hence, the court is of the opinion that it is just and necessary to give protection of police protection police protection for proper implementation of the orders of the court dated 9/7/2024. Accordingly, allowed the petition. Next para. Land counsel appearing for the petitioner defendant submits that the order that is passed by the court is bereft of reasons, and he relies on an order passed by the coordinate bench of this court, which was also relied on before the trial court in case of Sri Balakrishna KP and another versus KP Puttaraju and others arising out of WP number 51712 of 2019. He relied on paragraph number
11.
Please extract paragraph number 11. Relying on this, it is submitted that the order that is passed by the court is without any consideration, and the same is liable to be set aside. Land counsel appearing for the respondent plaintiff submits that the sale deed is dated 9/12/2009. Earlier, OS number 128 of 2008 is filed by who are the plaintiffs in that?
Malad Giri Gowda, Malad siblings of Jayamma.
Huh?
Siblings of Jayamma.
My uncle.
Who is your vendor?
Malad, my vendor is first defendant.
In the said suit, the first defendant has sold the property to the petitioner, and the siblings of the vendor of the plaintiff has filed the suit for partition.
Please, Malad.
Yes.
Has filed the suit for partition. In the said suit for partition, court has given a finding that the sale deed dated 9/12/2009 obtained by defendant number 4 is valid, and defendant number 4 is the absolute owner of survey number 146 to the extent of 2 acres 30 guntas. And accordingly, it is submitted that the said sale deed is held to be valid. Against that, an appeal is filed and the same is pending consultation. It is a submission that no interim orders are passed in the pending RA. Land counsel further submits that when there is continuous interference and they have come to the site with bulldozer to
To put a trench.
To put a trench. At that time, they approached the police, and the police have not registered the complaint in the light of the fact, as the matter is sub judice. It is submitted that the court has considered the NCR, and and considering the said NCR and the conduct of the plaintiff, conduct of the defendant as has passed an order, it is submitted that if in a high-handed manner, if there is disposition and interference, unless the police protection is granted, the order of the court, we will not be able to enjoy the fruits of the same. And it is submitted that the court has rightly passed an order and there are no grounds to interfere. Next, having heard the counsels on either side, there is a material on record. The plaintiff has filed a suit for bare injunction. In that, an order of injunction was granted on 9/7/2024. Correct? On 9/7/2024. And it is also an admitted fact that from 9/7/2024 till now, the said interim injunction is subsisting and the plaintiff and the defendant has not questioned the same. The only ground of attack on the impugned order by the plaintiff, by the defendant petitioner is that it has failed to discuss about what is the interference by the defendant and which necessitated the court to pass an order granting police protection. Relying on the judgment, it is submitted that the judgment in WP number 51712 of 2019 that the court had failed to record the reasons. This court has perused the order and also the judgment that is passed by the coordinate bench of this court. No doubt, in so many words, the reasons are not recorded in the order. The NCR and the IA that is filed clearly makes out that there is an interference by the defendant. The defendant, having not questioned without even questioning an order of injunction from the last 2 years, comes up before the court questioning an order of injunction that is passed. If in this manner, if the defendant starts violating the orders passed, if the party starts disobeying the orders of the court, and the court, and when the matter is before the court, just on the ground that a particular reason is not mentioned in the order, if this order is set aside, then the orders passed by the court will remain to be paper orders, and people will lose the confidence on the justice delivery system. In the facts and circumstances, considering the NCR, the earlier suits that were filed, and where the suits that were filed, this court is of the view that the order impugned passed by the court requires no interference in the hands of this court, accordingly dismissed.
My lords, pending IA is also there, my lords, for appointment of court commissioner, that may also be.
Which one?
There, my lords, we have filed an IA for appointment of court commissioner to explain.
In the light of the orders passed, all IAs are closed.
Sure.
Section 33, PL for petitioner.
Lord, in a suit filed by the first respondent against me, my lord, seeking specific performance. At the fag end of the suit, that suit has a very checkered history, comes to this honorable court more than 5-6 times. Finally, my lord,
You
more
are the
than.
plaintiff or the defendant?
My lord, I am the defendant number 1 against whom the main relief was sought of specific performance of an agreement of sale. My lord, the suit makes, my lord, tours to this honorable court on several number of times, goes to honorable Supreme Court also. Finally, my lord, there are directions issued by this honorable court on more than one occasion that expeditiously the
which year?
Suit is of the year 2024.
Why for 2024 suit so many directions?
I will tell my lord the reason for that, as there is a mortal hurry. More than twice, my lord, we came, and my lord, I don't want to, my lord, say it in so many words, but there is something going on there which is not very great. We sought the transfer of the court also, which was in fact allowed by the honorable, my lord, principal court. Then, my lord, it was set aside by this honorable court, and the matter was continued before the same honorable judge. There are 2 suits, one filed against me by an agreement holder, where, my lord, the agreement holder says that the property has to be, my lord, sold over to him. There is a second suit filed by an impleaded defendant in my suit, my lord, which I believe my learned friend appears, where he claims that I have already sold the property to them under a sale deed.
Therefore, my lord, he gets implemented and he has a different, my lord, independent suit complaining of interference. That's his suit is only for injunction.
For declaration.
My suit is for, my lord, his suit is for only injunction.
And the other suit is for specific performance.
Other suit is for specific. My lord, both the suits gets clubbed and, my lord, evidence was being led. Because there are directions by this honorable court, though we made barren attempts to, my lord, change the honorable court, we were not successful. We concluded the trial. The trial gets concluded and the matter was to be argued. The plaintiff in my suit would come and file an application, my lord, seeking the substituted, my lord, alternative prayer as available under the Specific Relief Act, which was never sought before. And, my lord, we object, saying that, of course, an amendment can be prayed at any time. That is the settled position of law, but not in this case. Number one. Number two, if an an alternative prayer is allowed to be added now, what should happen to Order 2, Rule 2, which prohibits that if you have not asked for all the reliefs which you are entitled at once, without the leave of the court, you can't ask it later. The learned judge, my lord, would simply mechanically allow the prayer and say, please amend the plaint now, when the matter is about to be concluded. And amended plaint is filed, we are asked to file a written statement. We say, no, we have challenged it before this honorable court. Please don't proceed with the matter because you have given the luxury of time. In spite of that, the court is proceeding. Precisely, my lord, I am now challenging an amendment granted.
This is before which court?
This is before, my lord, the City Civil Court, CCH2, Bangalore.
Bangalore Court 2024 suit expeditious disposal.
Twice. And, my lord, in fact, God forbid, my lord, this should not be happening like this. For some reasons, my lord, I don't want to disclose it. My lord, being a senior member of the bar, my lord, I have limitations. My lord, judicial discipline stops me by making statements. I don't want to say in so many words. There is something wrong. That's the reason, my lord, I said there is a checkered history to the suit. Now it is the same, my lord, Leonard.
No, but what happens is, there are so many matters pending before
Yes.
the City Civil Court.
We were never in a hurry.
No, suits of, no, whether the parties are in a hurry or not, but High Court cannot tell them to dispose of a 24 suit. What is the hurry for that? And why should, whoever comes to the High Court, we keep on telling the courts to dispose of the matters. What will happen to the matters that are pending from 10, 11, 12?
In fact, my lord, the Honorable Supreme, your lordships rightly remarked it. The Honorable Supreme Court, while reconsidering Asian resurfacing, said generally the constitutional courts will never issue such directions.
I think you relied on the judgment.
I relied on the judgment. Your lordship said generally. My lord, I said generally. Now your lordships may kindly see my learned friend is in caveat, and now my learned friend, my lord, is not, should not have been. 1 second, sir. 1 second. Let me complete, sir. I beg you, please. Now my learned friend appears for an impleaded defendant in my case, and this relief which is allowed is not in favor of his client. It is allowed in favor of, my lord, defendant plaintiff. Now I am defendant number 1, my lord, who is the main party in the suit. Now my precise prayer before this honorable court is, this amendment should not have been allowed. Now, my lord, if they wanted, my lord, anybody who is suing for specific performance decree should have a basic knowledge, my lord, because the law says you have to ask for an alternative prayer, which you have not asked. That means you have intentionally skipped that prayer. My lord, what should happen to Order 2, Rule 2? Kindly, my lord, see, your lordships knows this, but my lord, for my satisfaction, may I just read Order 2, Rule 2, my lord, sub Rule 3.
Yes.
My lord, which says, Order 2, Rule 2, sub Rule 3, my lord, says, so, my lord, Order 2, Rule 2 says, suit to include the whole claim. Every suit shall include whole of the claim.
What is the law on that now?
Yes. Now, my lord, what should happen to this law?
No, what are the judgments governing that?
There are so many judgments, my lord. Once, my lord, the law itself directly reads.
Problem is there will be always judgments on the other side.
In fact, my lord, I checked it. I checked it. There is nothing, my lord, that would create, my lord, something contrary to Order 2, Rule 2, sub Rule 3.
With regard to the Specific Relief Act and the alternative prayer.
Exactly. Now, my lord, in the alternative prayer, my lord, I would say this.
On that, there is no law.
On that, my lord, I couldn't find anything. But in a suit for specific relief, my lord, your lordships are aware that it is normal, my lord, procedure, normal pleading that as a matter of abundant caution, my lord, an alternative relief is asked. Because, my lord, granting a decree of specific relief, my lord, is the discretion of the court. Even if I prove it to the hilt, my lord, the agreement, still the honorable court to meet the equity say, I am not going to decree the suit, I will guarantee the alternative prayer. So the one who walks into the court should have that, my lord, conscious, my lord, preparedness to seek for an alternative. You don't seek it. Now, at the end of the suit, you are not amending the case. You are asking for something more which you have not asked in the beginning, and Order 2 Rule 2, my lord, stops it. If you have not asked it, you cannot, and if you want to ask it something later without the leave of the court, you cannot.
Let's see what is the reasoning given by the court.
Nothing, my lord, your lord, my lord simply says amendment could be allowed at any time. That's the reason I am allowing. My lord, there is no quarrel on that. Amendment could be allowed, but not granting an additional prayer.
What is the amount paid in this, according to the plaintiff?
According to, my lord, according to the plaintiff, they have paid me 70 crore rupees. And the case of my learned friend is that in the meanwhile, I have sold them the land for which they never pay the sale consideration. They never pay the sale consideration, still say that I have a sale deed. My lord, of course, this suit has a checkered history. We have, my lord, we in fact expressed, my lord, serious, my lord, doubts about the way in which, my lord, the honorable bench was dealing with the matter. The honorable civil court was dealing with the matter. We were not satisfied. We went before, my lord, the principal court, and the principal court agreed with our case. But for some reasons, my lord, this honorable court in a civil revision felt that the suit should be sent back. We were happy with that, my lord. Now, I don't want to say anything about that. We will see, we will hit the end of the case. Now, my lord, at the end of the case, it is this very court that records more than, my lord, several times that there is direction. I am not going to stop the trial. I am going to be expedient in this matter. And that is this very court, my lord, now at the fag end of the case, allows an amendment, grants an additional prayer. Now, my lord, if an additional prayer, my lord, how I am prejudiced, my lord, in 2 words, I will say. Now, my lord, if now, my lord, now, if, my lord, the suit goes, and if they have not sought for an alternative prayer,
I have to return 70 crores.
I know I need not. My lord, I would take advantage of this. I would take advantage of this. My lord, Order 2 Rule 2, my lord, is kept very consciously by the lawmakers. Now, my lord, I will take advantage of that. Now, if you allow this, tomorrow, if the suit is not, my lord, suit is dismissed and alternative prayer is granted, my lord, for what good reason I am taxed of 70 crore rupees, which my case is that it's not towards the sale consideration.
Please come. Yes, what do you say?
I am for the caveat, I am not affected by this application, my lord. My only objection is to stay. For the reason I will just mention, I will pass on the judgment of this honorable court in the CRP specifically. The reason the trial court is going at a fast pace is not that there is something wrong, my lord. There is no need to insinuate anything against the judge. In an MFA before this honorable court, all the parties stood and said that yes, we will cooperate to dispose of the matter within 1 year if status quo is maintained. And all the parties agreed, and then the court passed a direction.
You might agree.
Yes,
you might agree. What is the hurry for the court?
My lord,
Why should the court?
My lord, the High Court accepted.
Your 24 suit. What is the urgency for it? Both of you might be ready, but the court will not be ready.
Yes, my lord, but the High Court accepted that and passed a direction to dispose within 1 year. After which it was not disposed because of plaintiff. 50,000 cost was imposed on the plaintiff and another 6 months extension was given. Subsequently, another 3 months extension is given in this CRP, which ends on July 27. The extension repeatedly it has been extended because I have invested a large amount of money. Plaintiff has invested a large amount of money. Defendant has taken money from both the petitioner here has taken different money from both of us. Executed an agreement of sale in my favor and then executed an agreement of sale in favor of the plaintiff.
Then the plaintiff would have been more vigilant in pleading his case.
My lord, I have a sale deed now. I am the owner of the property. I am not able to enjoy the property.
Why did you accept for this clubbing of the matters? You would have pursued your matter as a suit for
Lord,
bare injunction.
In the injunction, the court suggested in the MFA that yes, we will club it together and we will dispose of within 1 year. You maintain status quo. I accepted that because the suggestion was by all the parties and the court suggested it. It was accepted. There is no insinuation necessary against the trial.
No, let's not go into all that.
Trial court is not going.
I am only on the point. Why
Yes.
should a 24 for the suit be given priority? I am only on that.
Yes, I understand, but the parties have accepted. I accepted a status.
You will
quo.
accept. Parties want a
But that was the
disposal, but
suggestion
the
of
court
this
has
honorable
so many other works to do than only looking at your case repeatedly and passing orders.
My lord, that was a suggestion by this honorable court, my lord,
Please
in
come.
an MFA.
The Land Sine Council.
The proceedings may not be stayed is my only.
I will stay. The Land Council appearing for the
27th it will expire.
Then let it be. Let the learned judge for passing this order ask the court for extension of time what we can do. Land Council appearing for Land Sine Council appearing for the petitioner submits that. At the fag end of the trial, an application is filed under Order 6 Rule 17 by the plaintiff seeking the alternative prayer of refund of the money. It is submitted that this would change, this would cause a lot of prejudice to the defendant. And this court, the trial court has failed to appreciate the same. And why this prayer is not sought at the earliest point of time was also not stated. Plain counsel appearing for the caveator in the other suit, which is clubbed along with this suit, submits that there is a direction by this court to dispose of the matter expeditiously, and that time will expire
Expire
by
on 27th July.
27 July 2026. This is a suit of the year 2024. No doubt there is an order by this court to expeditiously dispose of the matter. But at the fag end, the court has passed an order. When this court finds, when the same is assailed before the court, this court has to look at the legality or otherwise of the order passed by the court. In that view of the matter, they shall be stay of all further proceedings pursuant to the order dated so and so. This matter on 3rd of August. The petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 23rd of July, or else a stay granted by this court stands vacated.
Greatly obliged.
So number 34, Balraj VR for petitioner.
For the petitioner, my lords.
Yes.
The petitioner was the objector before the trial court, my lords. There was an execution proceedings which has been filed by the respondent number 1 against the respondent number 2 based on the judgment and decree passed in OS number 1761/2.
What happened to your application?
My lord, that application was pending, but the dismissed for non-prosecution on 9/1/2026. On the same day, an application was filed for restoration. After filing an objection filed by the respondent, that application has been dismissed only on the ground that the memorandum of facts filed by the petitioner counsel. Please, notes. The art portion.
All, he is the only respondent.
Yes, yes. The respondent number 2 is the respondent number 2 is a formal party, my lords. The JDR before
So
the
we can
trial.
dispose it off. Where is the, no, I'll hear you.
Yeah,
I
yeah.
said,
My lord, I have no objection.
Uh.
It may be allowed on cost. My only submission is, let there be a timeline because it's an execution
Objection.
proceeding and he's the objector. I'm the
the
decree
application,
holder,
we will
it's a
say-
specific
we'll say,
performance.
Let the, his application be decided as expeditiously as possible.
The obstructor application. Yes, my lord, that is all I'm seeking.
Yes.
Some on cost it may be allowed, my lord, because he's been taking repeated adjournments. That's the reason.
They also
When
filed
was-
On the
application.
last hearing day,
When was the application filed by him?
please.
Application filed.
From what the order sheet, my lord, what I can gather is, on 22nd of November, on cost, my lord, he was granted an adjournment. And that was posted to 9th of January.
In the 2023 application was filed, my lords.
An application under our 21 rules.
21 rule
It is
97.
not decided till 2026.
Till 20. But meanwhile, they have also filed.
Inquiry also has not started. On the last hearing date, he never appeared. That is the reason the court dismissed it.
Meanwhile, they have
My
also filed
humble submission is that the direction,
Cost.
500 rupees was imposed. That wouldn't hurt my learned.
Leave it to my lords. Anyway, ready to cooperate with the.
Some terms, and my lord, some direction, my lord, it's executive.
Yes, of course.
I am
it
agree,
has
my
to
lord.
be.
I am agree.
Page
Some-
number?
Well, the operative portion of the order, my lords, page number 24, my lords. Operative portion of the order is at page number 26, starts from page number 24, my lords. The reason is para 7, my lords, page number 25.
No, the court says you have to file a miscellaneous.
On the same day, application filed, my lords. On the same day. But in
Miscellaneous
the recent
petition under
judgment, my
order
lords,
9, rule 9 CPC.
Technicality, my lord, I would not oppose because the main issue will stagnate. If this is allowed, he'll again seek to
Correct.
this thing, block that.
The agreed with the order passed in I number, passed in IA filed under section 151 CPC, dated 9/1/2026. And execution case number 64 of 2022 dated 12/6/2026 by which court?
Fourth additional senior civil judge, my lords.
Where?
Bangalore Rural District, Bangalore.
Fourth additional senior civil judge, Bangalore. The petitioner obstructor is before this court. In the execution petition, the petitioner herein filed an application under 21 Rule 97 that came to be dismissed for non-prosecution on
9/1/2026.
on 9/1/2026. Immediately, the petitioner has filed the instant petition that came to be dismissed by order impugned, wherein the court has observed that the decree holder counsel submitted that application ought to have been filed under Order 9 Rule 9 CPC, since the applicant has sought for recalling the order of dismissal of application for non-prosecution. The court observes that in this regard, the obstructor counsel has not submitted anything, but it is to be noted that obstructor petition in the present case is filed with obstructor under Order 21 Rule 97/99 to 101 CPC, seeking to declare the applicant as absolute owner of the suit scheduled property and to declare that the decree notice number 1761 of 2016 is obtained by fraud. Since the said obstruction petition is dismissed for non-prosecution, the obstruction has to file a miscellaneous petition under Order 9 Rule 9 CPC, seeking to set aside the order and accordingly dismiss the petition. Shall I record your submission that you have no objection or no?
Please, that's
Then counsel appearing for the respondent submits that. In fact, the execution is pending from 2022. This IA is filed in the year 2023 and the same is not considered. And as the petitioner is repeatedly taking time, the court has on the last occasion in the matter, as such, the court has dismissed it for non-prosecution. It is submitted that the petitioner is interested in the disposal of the respondent is interested in the disposal of the matter. The application may be allowed on cause. There may be a direction to the trial court to dispose of the application in an expeditious manner. Next, for having other counsels on either side, there is a material on record. Order 21 Rule 97 application is filed in the year 2023 and the execution is of the year 2022. So far, the same is pending consideration before the court. In those circumstances, going for the technicalities and for filing a miscellaneous petition on those grounds, this court is not inclined to dismiss the petition. Considering the fact that right from 23, the petitioner is taking time, this court deems it appropriate to allow this application on cause. Accordingly, this court is passing the following order. The order dated so and so is set aside and an application filed with the petitioner to set aside the order dated
9/1/2026
is allowed and on the cost of on the condition that he shall pay cost of rupees 5,000. Next para, number 2, the application shall be filed under Order 21 Rule 97 by the petitioner shall be considered within a period of
3 months.
within a period of 3 months from the date of receipt of the copy of the order. Number 3, if the petitioner shall not seek unnecessary adjournment, even if the petitioner does not cooperate with the matter, still the court shall proceed and decide the application on the merits of it in accordance with law.
Please. 3 months from the next hearing date, my lord. 18/7 is the next
18/7.
hearing day.
Next, from 18/7/20.
3 months. Give him some time.
Still number 35, Govind Raja T for petitioner,
30.
35, for admission, 35.
Yes.
And for petition, my lord, the dispute in OS 66/1991 was decreed. And in that case, this petitioner was the first defendant, second defendant, and his mother, Madhema, was the first defendant. Unfortunately, the summons was not served upon the petitioner. He was residing at Bangalore. He was working at Minerva
What is the
factory.
SARIS CRP?
CR for restoration of the original suit, OS 366 for 1991. And that suit, that application which we have filed before the trial court was dismissed. Agreed by
Where is the order included?
order.
Come to the reasoning part.
The findings given by the first appellate court that the petitioner filed the suit in OS page number 32, my lord.
It is filed after lapse of 20 years, 7 months.
20 years, 7 months. 6,781 days, if you correctly calculate it.
What is the reason for this delay?
Please, my lord, he was already submitted that the second defendant, my lord, that is the petitioner, he was residing at Bangalore. Since more than 20 years he was here, he was working in a factory.
What happened to the suit summons?
And therefore, the summons was sent to his native place. And the summons was taken as refused by him, though he was residing at, admittedly, in the evidence it has come up.
How come you have come to know about this?
Oh, I was not residing there. The
No,
address
how
given.
did you come to know? Come to your affidavit. Let's see your affidavit. Filed in support of the application to set aside the.
We are supporting that at the
Where is
time
that?
of.
Let me look at it.
At the time of, he was not there. The summons which was
No,
supposed.
I want to look at that application. Where is it? Page number.
Page number, please, ma'am. The ground itself which we have enlightened before some before.
You have not filed all those material before this court. No.
In para number.
With 20 years of delay, you cannot come up with these kind of papers. You have to file all the material on before this court. Where is that application, affidavit in support of your Section 5 of the Limitation Act?
Section 5, which we have filed it in the trial court itself.
That you have to file along with this. Otherwise,
we will file it in
this
next.
is matter after 2 weeks. The petitioners will place all the material before this court.
Number 36. Lakshmipati VM for petitioner. 36.
No representation less in the month of September. Yes, 37.
37. Balraj JC.
Copy of the petition, my lords. Matters posted before Lok Adalat, my lords.
Huh?
On 11/7, the matter is posted before the Lok Adalat
On?
11/7. So kindly.
This matter on the month of August, on 5th of August. Yes, 38.
Number 38. Shiva Kumar V.
No representation in the month of September. Yes,
Number
39.
39.
Same order.
Till number 40. Text.
I need to produce some more documents. This is my suit for rejection. Rejection of suit was, application for rejection of suit was dismissed. I have come in revision against that. Some more documents I need to produce.
Just in
Could
the
it
month
be
of September.
16 or 17 particularly? I need to.
Short date will not be possible. If you want, it will go a long date because there are so many matters. Listen,
Any
the month of
date be given.
August 18th. Yes, 41.
42.
Please.
41.
Till number 41.
In this, I'm appearing for the respondent, my lords. Landlord and tenant, this thing. Landlord's petition, suit. for
They've agreed
rejectment
to
has been
settle the
rejected.
matter, my lord.
And we have filed a memo.
1 minute, what is that?
They've agreed, the parties have agreed to settle.
Settle.
If it may be posted for Lok Adalat on 11/7.
On 11th?
11th, my lord.
It is submitted by both the parties that they are interested to settle the matter. This is matter, this is what is mentioned yesterday. The parties, the matter, the registries are to place a matter before the Lok Adalat.
Great.
Yes.
Till number 42.
I appeal for the petitioner, my lord.
42.
What's the correspondent? 2 weeks of an adjournment, my lord. Senior had an
No entry order in this.
We will file an objection until that.
Place this matter in the month of August, September, not August.
43.
At the request of non-counsel for the petitioner. 43.
43.
Much obliged.
Yes.
Originally, the petitioner is the third defendant
Hmm.
before the trial court. Swami.
Hmm.
The plaintiff has filed a suit for arrears of rent, damages, and specifically prayer of eviction as against this defendant number 3. Uh, Plaintiff, defendant, respondent 1 is the owner of the property. He has entered service agreement with defendant number 1 and 2, the respondent 2 and 3 herein, and authorized them to sublet the property. In turn, he has.
Please come to your application.
Yes, Your Worship.
Where is it?
Yes, Your Worship. My impugned application is in page number 74. 74, Annexure G, Order 7, Rule 11A. Since the plaintiff in the plaint has not accrued or demonstrated any cause of action as against contesting defendant number 3, it is respectfully prayed to reject the plaint as against this defendant number 3. My contention in the application and as well as in the written statement is that I am not the direct party in contract.
Let me just look at the affidavit.
Pardon?
Let me just look at the affidavit.
Affidavit? Affidavit, sir. Yes, Your Worship. Yes, Your Worship. Relevant portions, Swami. I state that I am the contesting defendant number 3 in the above suit. Being conversant with the facts of the case, I am swearing so and so. Second para, Swami. I have taken the scheduled property on lease by entering into rental agreement with defendant number 1. Para 3, I state that by virtue of rental agreement, I have paid a sum of rupees 17 lakh to the defendant number 1 as interest-free security deposit. I further state that as per clause number 4 of the rental agreement, the said sum of rupees 17 lakh shall be refundable to me at the time of surrender of the scheduled property. Para 5, period of rental agreement, I state that after a lapse of the period of rental agreement, I am intending to vacate the property subject to refund of interest-free security deposit. However, defendant was absconding. 6, I state that by virtue of service agreement dated 9/11/2009 entered between the plaintiff and defendant number 1, plaintiff has authorized the defendant number 1 to sublet the property. That clause number 9 of the service agreement is carried there. Accordingly, defendant number 1 shall be competent to sublet the property in favor of the third parties. That is clause number 9 of the service agreement. Para 7, Swami, I state that I am in physical possession and occupation of the scheduled property by virtue.
Seen that, please come to the impugned order.
Pardon?
Please come to the impugned order.
Yes,
Which
Your
page it
Yes,
is?
yes, Your Worship. Impugned page number 18 to 28. Swami.
Yes.
18 to 28.
Para number 9. Please
Para
come
number
to para
9.
9.
Evidently, the suit is filed by the plaintiff against defendant number 1 to 3, and defendant number 3 is the contesting defendant in this matter. When the relief is sought against all the 3 defendants in the plaint, kindly this word may be, kindly sentence may be noted. When the relief is sought against all the 3 defendants in the plaint, it is the vehement argument of the learned counsel for the plaintiff that the plaintiff cannot be rejected in part in support of the argument so and so. He has relied on so and so judgments. Subsequently, para 10 discuss, give the reasoning about it is not possible to partially reject the plaint. And para 11, well, 13 relevant portions, 13 from below 5th line. Therefore, on the facts and circumstances of the case and on the basis of the settled position of law, it is clear that the suit which is brought by the plaintiff cannot be rejected on the basis of the pleadings of defendant number 3. This is the wrong reasoning. If your lordship permits, I will go through with the averments of the plaint and the documents in support of the plaint. When there is a tribal issue, the plaint cannot be rejected in the initial stage. Further, the plaintiff has brought the suit against defendant number 1 to 3, seeking the relief of eviction. Kindly, this point may be kindly, lordship may observe with the prayer in the prayer C, Swami. Prayer C of the plaint. Prayer C of the plaint is direct the defendant number 3 to vacate the scheduled property. It is in page number 36, Swami. Page number 36 of the plaint compilation. 36. Direct the defendant number 3 to vacate the scheduled property with immediate effect and to hand over the vacant possession of the to the plaintiff. However, the contrary reasoning given here is seeking the relief of eviction from 1 to 3. This is the reasoning given by the learned trial judge.
Plaintiff has filed a suit against defendants 1 to 3.
Yes, yes.
You are defendant number 1.
Yes, I am defendant number 3.
Defendant number 3.
Yes.
According to you, there is no cause of action against you and the plaint has to be rejected.
Yes, sir.
Court said in the light of the settled law, the plaint cannot be rejected
Yes, sir.
partially.
Yes.
What is your submission? on
Yes,
that?
my respectful submission, if the
Supported by judgment.
judgment is.
Yes, we'll see after lunch.
Yes, sir.
Because of the interim order granted by the Honorable Court, it may be kindly be taken, the public works has been started. That's why you may, serial number 84 may be kindly be taken at, the urgency is there.
No, but nobody has mentioned in the morning.
Morning, your lordship, normally, it's back, sorry, my lord, it's back. Serial number 84. If the whole project is stopped from last 2 years, the public was laying up.
We will see. Let the advocate on record mention it on Monday. We'll see.
My lord. Then your lordship may kindly, on Monday at least, date may be to be in the first list.
Please, what the senior
urgency,
counsels have to
in
understand.
fact, my lord, the whole project.
No, I understand.
Kindly understand
The seniors also have to understand the
APTC.
difficulty of the court. If I start entertaining the mentions at 1:30. No, please understand, 1:30, then everybody starts. It's difficult for the court.
we are-
No, there is a procedure adopted by the court that I will not hear any mentions at 1:30. So either it is senior counsel or otherwise, I will not hear.
Serial number 103 is withdraw from.
That also I will not hear. I will hear the mentions
Can
only.
I, so you may know the, what exactly when it is, we met maybe.
Sir, that there in the cause list. In the cause list, it is printed. I will hear the mentions at only 10:30. I'm hearing it.
Yes, I do agree with your lordship. Can is it at least on Monday, at least, my lord?
Well, yes, Monday, let them mention it. I will take it up
My
on
lord,
2:30.
today morning some interrupt was going on. Therefore, your lordship cannot take up our.
Conveyed to this court.
But then what to do? If advocates are not
Yes, yes.
understanding
We are-
what is happening, item number 2, somebody wants to mention, and
Yes,
we will
yes.
not let anybody.
It's fault on
And this
our part.
mentioning goes from 10:45 till
We are
11:15
apologizing
it was
for
going
that.
on.
We are apologizing.
It's fault on our part. Someone interrupted. Morning, serial number 2, you was not supposed to mention. Because of it, my lords.
That is the reason, your
We,
lordship.
we,
Seri-
we understand, my lords, the pressure of the court also, and your lordship is following a procedure, permitting mentioning at 10:30. Yeah.
No, every matter wherever you say your urgency, I'm taking up at
Yes, my lord.
2:30.
Yes.
No.
In spite of accommodating all that, the court, the advocates
Really
also have to
good.
cooperate with the
But only today, my lords.
Some
someone
interpretation.
interrupted, Your lordship did not.
Yes, what is it?
Serial number 105, there is some urgency, my lord.
What is that?
The KPTCL is putting up an electric tower without following the due process. I have informed the other side. It was a fresh matter. He said this petition.
2:30, yes.
Serial number 2, your lordship.
Serial number 103, withdraw the petition.
103.
Yes, my lord.
That you can make it 2:30. Well, I'll call it 10. Yes, what is
Serial
your
number
matter?
Can I
2.
mention on Monday, my lord?
Which is your matter?
That is serial number 84.
Yes, 84 in the first list on Monday.
Serial number 2, your lordship. The eviction suit has been filed by the
Till
plaintiff.
number 2 of which list?
Second list, your lordship.
Huh.
The urgency is this, your lordship. Eviction judgment is passed against me. Last Monday was the last date. On that day, this court
Matter in the first list on Monday.
at the top of the list.
Huh?
This two serial number 1. Tomorrow it has been set out for the auction sale.
Yes, that also at.
My lords, list to
serial
serial number 15, my lords. It is slated for hearing on IA before the trial court tomorrow. Tomorrow, my lords. My lords, I have.
Section 5.
My lords, 2025, my lords, there's an interim order of status quo in my favor, my lords. My lords, the state is the party. It's a representative suit, my lords. May my IA for stay be considered today, my lords.
You said there is a stay.
My lords, there is an interim of status quo order, my lords, but they're going ahead in hearing Order 7, Rule 11 application tomorrow, my lords. It may kindly be considered.
What is the connection? Let the court hear it. Why should we stay?
My lords, it will become infructuous, my lords. If
No,
the,
what is questioned before this court?
my lords, it's a representative suit to protect Gomar lands filed by the
So that the court will not stop.
My lords, the court has ordered a status quo, my lords. Now what has,
Correct.
please, my lords,
That has to be independently. Order 7, Rule 11 to any day the court has to hear.
please, my lords, if it were to hear the order of this on,
Order is passed. If order is passed, you'll come here. Then that time we will hear the
my lords, the
matter.
writ petition will become infructuous, my lords, if Order 7, Rule 11 is
What is
considered.
the writ petition before this court now?
My lords, to challenging the 39, 1 and 2 was rejected, my lords.
My lord,
My lord, may I
serial,
make a submission?
serial number
This is
27, lord.
Serial number 18, there is an urgency in the matter, my lord. There's a 13 crore execution petition filed and which has been stayed, though no order has been passed by the court.
When did you file the writ petition?
I filed the writ petition, I am the respondent, my lord. They have filed the writ petition in March and an order has been passed, interim order has been passed. I filed an application, there's an urgency in the matter.
There are
At
so
least-
many vacate petitions. Yours is not an exception. Yes.
My lord.
106, yesterday's matter, that excise matter wherein your lordships directed the government to, is listed today at 106, my lords.
Yes.
Serial number 27, lordship, list number 2.
I'll take every matter, whoever stands
No,
up,
no,
I'll take,
no.
I'll start
My
taking
my
the
lord,
matter.
one submission. Tomorrow arguments are there. So that's why kindly take up.
When is that writ petition filed?
2025, sir. My lord, writ petition.
Matter, it is continuing, let it continue.
Ma-
No problem.
Stay not continue.
Madam, list number 2, Monday release.
కంటిన్యూ చేస్తాం అంటే తీసుకుంటాం కంటిన్యూ
Madam,
చేస్తాం
serial number 2.
ಏನು ಕೇಳಲ್ಲ
Madam, list number 2 ಯಾವಾಗ ಇದು ಮಾಡ್ತೀರಿ?
ಮೆನ್ಷನಿಂಗ್
ಹೇಳಿದ್ದೆ ಯಾಕೆ mention?
Serial number 2.
List number 2, list number
List 2, serial number 2, Monday ಗೆ first list.
Madam, Monday ಅದು first list ಗೆ ಹಾಕ್ತಾರೆ.
ಅದೇನು ಹೇಳಿಲ್ಲ ಇವ್ರೆ ಅದೇನು ಹೇಳಿಲ್ಲ ಇವ್ರೆ ಮಂಡೇಗೂ ಹೇಳಿಲ್ಲ ಮೇಡಮು ಅದೇ ಕರೆಕ್ಟ್ ಇವತ್ತು ಕೇಳಾಯ್ತು ಇಟ್ ಈಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಇವರ್ ರಿಕ್ವೆಸ್ಟ್ ಇಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಇವ್ರೆ ಕರೆಕ್ಟ್ ರಿಕ್ವೆಸ್ಟ್ ಇಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಬೈ ದ ಕೋರ್ಟ್ ಅಂಡ್ ಮಂಡೇಗೂ ಹಾಕಿ ಅಂತ ಹೇಳಿಲ್ಲ ಮಂಡೇಗೆ ಅದರ್ 2 ಮ್ಯಾಟರ್ಸ್ ಹೇಳಿದ್ರಲ್ಲ ಮೇಡಮ್ ನಿಮ್ದು ಹೇಳಿಲ್ಲ ಇವ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ
ಮೇಡಮ್ ಇದು serial number 2 ಮಧ್ಯಾಹ್ನ ಕಳಿಸ್ತೀರಾ?
You are
Your Lordship, a small indulgence with regard to list 1, serial number 86. I request if the matter can be taken up today by any time by 4 or 4:30. Yesterday, this matter was listed in list 2 and then advanced to list 1 upon a request.
I will not hear these many mentions. I already had enough for today. Call the list.
List number 1.
Serial number 103, my Lordship.
Take that memo.
Paper petitioner. 103 minutes.
It is submitted that the suit itself is withdrawn and hence nothing suffices for consideration this memo in this petition. Accordingly, memo is taken on record. Dismissed as withdrawn. Huh? Take that. It is, a memo is filed stating the matter is settled between the parties. As the petitioner wants to withdraw the petition, accordingly dismissed as withdrawn. Yes.
43, Vinayak VS.
Yes, sir. I am forwarding the citation.
Do that.
At note D is only relevant. I have mentioned in the pencil in the top also. Para 25 and para 30. My case is I have no para 25, para 30, para 6.
Read para 25.
Para 25. Sir.
Yes.
The stand taken by the appellant who has filed the application for the rejection of the plaint is sustainable and acceptable. We have already adverted to the governments in the plaint and we have held that the plaint has not shown a complete cause of action.
I want you to show me a judgment where that the partly plaint can be rejected.
Some
partly plaint can
partly,
be rejected.
yes, Your Lordship. The para 29, sorry. We have gone through the facts in that decision and the material placed for rejection of the plaint in the case on hand. We are satisfied that the principles of the said decision do not apply to the facts of the present case, where the appellant first defendant is not seeking rejection of the plaint in part. On the other hand, the first defendant has prayed for rejection of the plaint as a whole for the reason that it does not disclose a cause of action.
That is not your case.
No, my case is my plaint as against D3, plaint has to be rejected as a whole. That is my prayer.
That is not called as a whole, as the plaintiff, defendant number 3 as a whole.
Because contesting defendant number 3, my defense before the court is there is no privity contract between
Answer
plaintiff.
to your submission is there in paragraph number 29 itself.
Yes, Your Lordship.
That is contrary to your case.
No, Your Lordship. That's why para 6 may be kindly. Para 6 may be kindly.
Look at para 29, Mr. Counsel. Please
Yes, Your
read
Lordship.
it.
Yes,
Don't read it to apply it to the facts of your case, how it suits you. Please read it what is said by the Supreme Court.
Yes, yes.
Read it.
Kindly, before that, para 6, kindly for a moment, sorry. Kindly for a moment, para 6. Para 6. The learned single judge of the High Court rejected the plaint insofar as the first defendant is concerned and directed that suit can be proceeded against the second defendant. The application bearing number so and so filed by the respondent plaintiff for interim injunction and amendment of the plaint were also rejected by the learned single judge. So here, in the first appellate court before the High Court, the plaint as against defendant number 1 was being rejected, for which challenging the said judgment, the appellant has approached the Honorable Supreme Court, and the reasoning while allowing the said application in para 29 and para 25. It is the specific reasoning given by the Honorable Apex Court that there is no privity of contract between the plaintiff and defendant number 1. As well as in my case on hand also, my respectful submission to this Honorable Court is that there is no privity of contract between plaintiff and defendant number 3. It is between the service agreement entered between the plaintiff and defendant number 1 and 2, for which subsequently defendant number 1 and 2 entered a rent agreement with me. So your eviction possession was given by the plaintiff to the defendant number 1, not defendant number 3. That is my humble submission. If your lordship permits, even for a moment,
How defendant number 1 has given possession to you?
Pardon?
Defendant number 1 has delivered possession to you.
Yes.
What is the basis for defendant number 1 to give the possession?
On the basis of the service agreement entered between
If the
plaintiff and
service agreement between the defendant, plaintiff and the defendant is cancelled, what will happen?
not cancelled. That's why.
That is what he is seeking. If it is cancelled, what will happen?
Yeah. For that also I have answers. If your lordship permits, I would like to draw your lordship kind attention to the relevant portion of the service agreement, if your lordship permits. There are 21 page 64 of the compilation.
Yes.
The first party is plaintiff, Swami, may terminate the agreement if the second party defaults the payment as agreed for a period exceeding 60 days from the date of due.
You're reading page number?
Page number 64, Swami.
64, which clause?
21C, 21C below. 21C, Swami. The first party may terminate the agreement if the second party defaults the payment as agreed for a period exceeding 60 days from the date of due. So now it has to be read together with the plaint averments, Swami. Plaint averments, kindly, your lordship may go to kindly page number 32, Swami. 32.
Yes.
So our service agreement is agreement entered in the month of November 2020, para 13. The plaintiff submits that from February 21 to October 21, the plaintiff has sent several emails to defendant number 1 on various dates requesting, para 10, sorry, para 10, the plaintiff submits that after subletting the said scheduled property and after taking huge lease amount of rupees 17 lakh, the defendant number 1 and 2 has paid rent regularly for 2 months and thereafter started defaulting. So only from up to February 2021, the defendant number 1 and 2 paid the rent to the plaintiff. So according to 21C, it will terminate only by giving the notice immediately within 60 days from the date of default. But that was not made in para 13. Now it is to be relevant. Para 13. So he has given but even after repeated requests, the plaintiff does not receive any response except from email dated 7/7/2021. So now after 2021 and in the month of April 2022, he has issued the notice. Defendant number plaintiff has issued the notice to the defendant number 1.
We'll hear this some other day.
When such being the case,
We'll hear this case some other day.
because the matter is posted for the before the trial
What will
court on
happen
Monday.
now?
Only.
Let the call. We will decide this application. This is matter on 12th of August.
Swami, because the stage is set for the cross-examination of plaintiff. Swami.
Nothing will happen in one.
Because they have paid the
I'm not
cost
convinced.
also. Swami.
We'll
Levied the cost.
44.
That the petition. Well, a defendant's revision petition. Well, the present petition arises like this, Millard. His property, suit scheduled properties were acquired by the grandfather of the petitioner and the respondents hearing. Millard, it was his self-acquired property. He executed a registered will. Millard, I have produced the documents, the Lordship had 2 volumes, on 19/8/1975, bequeathing the properties owned by him to his 3 children, excluding the father of the respondent for the succession. My lord, kindly see, my lord, the page 38 of the paper book, volume 1, my lord, I have produced. Put up, sir, Garrett volume.
First, tell me what is the suit for?
Now, on the base of this will, my lord, the uncle of the petitioner filed a suit in the year 1987. OS number, my lord, 10,363 of 19.
Present suit, what is the present suit?
Present
sir?
suit, my lord, in respect of the very same matter, the suit is decreed in the year 2005.
Yes.
The respondents were party to the suit. My lord, they file a miscellaneous petition in the suit which is decreed in the year 2005. They file a second suit claiming that these properties were not part of the earlier suit and therefore they seek
So
for
that's why please
partition.
come to your application under order 7 rule 11.
Yes, your lordship, in volume 2, I have produced, my lord. In fact, even this main petition also I have filed. Kindly see the application which is filed, my lord. This page 95, my lord.
95 of which volume?
My lord, the first, the paper, the revision petition. My lord, para 3, 4.
First of all, please come to the prayer. What is this an order 7 rule?
Yeah, order 7 rule 11 application. Right, prayer para 3, your lordship's minute, page 96 minute.
Yes.
I submit that the above suit is liable to be rejected as there is no cause of action for filing the above suit. As pointed out earlier, the Madhava Krishnaya executed a will, excluded his self-acquired properties, including the suit scheduled property from inheritance. As a consequence thereof, said will, 3 children of Madhava Krishnaya have taken the scheduled property way back in the year 1978. Partition was completed among 3 children of Dr. Madhava Krishnaya. Therefore, there is no cause of action to file the above suit. As such, the above suit is liable to be rejected. I submit that the above suit is also liable to be rejected on ground of limitation. Admittedly, Dr. Madhava Krishnaya died 1970, that's I find it. Thereafter, the partition was partition among the children of late Madhava Krishnaya.
What is the relationship of the plaintiffs with this Madhava Krishnaya?
Please, will.
Relationship of the plaintiffs?
Grandchildren. The
And
petitioner is the grand. We are also the grandchildren. They are also the grandchildren. 3 children, 1970. From the year 1978, the plaintiffs have not made their any claim at any point up earlier. I further submit that admittedly on account of the so and so. Then your lordship, a kindly para 5 is important. I submit that the uncle of the plaintiff and these respondent M. Nagraj filed OS number 10,363 of 87. In the said suit will was set up. The suit property was not included by the uncle in view of the fact that the suit scheduled property was given to 3 children by Dr. Madhava Krishnaya. Therefore, the suit is hopelessly barred by law of petition. After more than 48 years, the suit for partition and separate is not maintainable, and as the same is required to be rejected. I submitted even though the said judgment and decree became final, the share of our father was not given. Therefore, our father filed FDP at 25,006 before the so and so court. In the said final proceeding, the plaintiffs were adhered as the respond number 3, 4, and 5. The learned so and so additional civil judge Bangalore disposed of the FDP 2500 and drew the final decree 25 so and so in terms of the report of the commissioner. Accordingly, the possession of the respective site had its own. This is basically, two things were raised in the application. Suit was filed in the year 1987 based on the will. Will was contested by the respondent's father, stating that that will is not validly executed. The court comes to the conclusion that the will is validly executed. That will clearly states that the property owned by him shall go to his 3 children, not to the father of the respondents. And it also says whatever I remember I have included, all the residuary properties will go to his 3 children other than the respondent's father. And that decree has become final. And final decree proceedings were initiated. Final decree proceedings disposed of. After 29 years of the disposal of the suit, almost after 40 years of the death of.
What is the case of the plaintiff?
Case of the plaintiff is, they plead that the suit was filed. They say this was not part of these 3 properties were not included in the partition suit earlier, therefore they are entitled
Have
to.
they filed the judgment and decree along with the suit?
Yes, they have filed, my lord. They have filed and I have produced the same thing, my lord. Is
So
virtually a.
Please come to the order
Yeah,
of
please,
the court.
the plaint governments, your lordship.
No,
may
no, please
kindly
come
see.
to the order of the court.
Yes, order of the court, my lord. Kindly see the order of the court. Para 4, my lord. Para 4, page 32, my lord. The appellant, who is the defendant number 26, has shown to the affidavit, my lord, this thing is considered. Your lordship, may kindly the reasoning given, my lord. Page 36, my lord, whether there exists sufficient ground to reject the plaint on the ground, there is no cause of action for the plaintiff. The same is hit by res judicata. Very suit filed is barred by law of limitation. Plaintiffs have not paid the court fees. My lord, your lordships may kindly come to paragraph. The para 14, the contentions are this. Para 16, my lord, is the reasons, my lord. Page 39.
Please read.
Yes. It is a fact that earlier suit filed in 10,683, the same was decreed, even final dictates drawn. It is a contention of the plaintiff. They had filed a miscellaneous petition 2153 of 2014, seeking restoration of OS number 10,363 of 87, on the ground that the suit has been proceeded ex parte against the plaintiff. It is not seriously disputed about the pendency of the miscellaneous petition. Under these circumstances, the pending disposal of miscellaneous petition, defendant cannot contend that the judgment and decree passed in the suit attained a finality. Further, it is well settled law that the issue
What
regarding
happened to that miscellaneous application?
Please, ma'am.
Miscellaneous petition.
My lord, after 14 years, my lord, they file a miscellaneous petition in 10,363 of 87, saying that they have not been served the notice in that court. My lord, we have produced the wakalat in those cases, my lord.
What is the stage now?
My lord, stage is now, my lord, that is for the argument stage there, my lord. Now they are required to lead evidence inquiry. So now they simultaneously move the matter. One, they go before the court with a miscellaneous petition saying that please set aside that the judgment and the preliminary decree passed. And at the same time, they filed the second suit. But after almost 40 years of the death of D.R. Madhav Krishnaya, almost after 20 years of the preliminary decree passed by the court. But on the face of it, on the basis of the pleading, I am not asking to look into the written statement document and their own averments in the plain states, they admit the suit was filed by their uncle in the year 1987. Their father was a defendant. He filed the written statement, contested the suit. But the court held that, that the will has been proved. Once the will is proved, the filing of the second suit on the basis that they...
Please read para number 18.
18, please. As already discussed about judgment and decree challenge in miscellaneous petition on the ground that suit was proceeded at present ex parte. As such, based on the judgment in OS number 10,063, now at the initial stage, the court cannot conclude as the will in earlier proceeding is proved. Plaintiffs have no right interest virtually setting aside the judgment, which is now coming to the point of limitation. The plaintiff have sought for their share suit property. It is settled law that one co-sharer cannot sell the share of other co-sharer without his consent. Further, as to whether sale of the property for legal necessity or family necessity has to be decided after full-fledged trial. Alienation a partner by a co-sharer not binding another co-sharer who is not a party to the CAD, he is entitled to get his share in the suit scheduled property on proving that he has got the undivided interest in the suit scheduled property. As such, in order to decide, all these fact trial is necessary. Then 20 minutes say, so far as the court fee, I will not go into that court fees. Now, this finding on the face of it, merely because miscellaneous petition is filed by the very same persons who participated in the proceedings. Miscellaneous petition, according to me, we filed our objection is maintainable only when an ex parte decree is passed. May I draw my lord's attention to the earlier judgment, preliminary decree. They were party to the proceeding. They engaged the services of an advocate. It's not an ex parte judgment, preliminary decree passed by the court.
1 minute, what is?
My lords, I filed this entire plaint only on the basis that one property has been left out and it is not part of the will. Neither in the previous suit as contended, OS 10363 of 1987, the suit is included. Will properties, the suit is not included. My lords, may
So
kindly.
as per the will, whatever the properties that are not part of the will, all the other three sons will have right over the property, but not your father. That is the will.
That is the will.
That is the finding in the earlier suit.
Yes, my lords, and that as there is a miscellaneous pending on it by stating that I've been placed ex parte, I have not contested the matter, I have not filed my written statement. So please restore this suit based on it.
How can you pursue
My
no,
lords.
You pursue that and this.
Yes, my lords, may kindly come to page 158 of their paper book. They have in their sale deed accepted that this property is excluded. My lords, may kindly come to page 158 of the paper
That
book.
property is not part of the suit. There is no dispute on that. But as per the will, whichever of the properties which are not part of that will all fall to the share of
The
other
will is
three
forced,
sons,
my lords.
The
It
other
is-
three sons,
yes.
but not to your father.
Yes, I am
So-
excluded from the property as per the, from all the properties as per the will.
That finding has attained finality.
That finding has not attained finality because I've already filed a miscellaneous and I'm contesting on that point.
Unless now it is like this. You want the court to adjudicate with regard to the properties in this suit, and at the same time you file a miscellaneous in the other case, and you want the court to set aside that judgment and decree.
No, I have
Where
already
there are
sought
findings
for,
against you.
but this property, which is part of this suit scheduled property, is not part of the miscellaneous or any of the proceedings. In fact, they themselves have stated that this is excluded in the property. Now they cannot come and say it is not part of the property. They cannot approbate and reprobate. They themselves in their sale deed have stated that this property is excluded. My lords, may kindly come to page 158, which
This
is their
not
sale
a-
deed.
This is not the property as per the will.
This
These
is not the
property are
property.
not the part of the properties
not
of
part-
the will.
is not part of the
But
will.
what the will says, whatever are the other properties remaining, which are not part of the will be shared between the three sons, excluding this son.
There may be a residuary clause as such in the will. What about the admission?
Finding given by the court. There is a finding in that regard.
There is a finding in the regard in the original OS 2363 of 1987, which we were not parties to.
You have filed a
Subsequent,
miscellaneous.
I have filed a miscellaneous. However, my lords may kindly see their sale deed. They have stated that this property is not part of the will. Now they cannot come and say.
Your
My
lordship,
lords may kindly have their own sale deed, which is part of the plaint. I have produced it in my plaint as
factually
documents.
incorrect, my lord.
My lords
She
may
has
kindly
produced-
see.
She
It
has
is not
produced a will.
factually
Your lordship
incorrect.
may kindly see the will I have produced just for the court, my lord.
My lords, it's also
Kindly
not a
see the
ground
will.
for
My lord,
order
volume 1,
7
my
to
lord,
11.
page, 1 second, one second. I'll just clarify the doubts of the court, that's all. This is will.
Come to the finding of the court in the OS.
Yes, my lord. That's kindly see the issue number 1, my lord, it's your lordship. Volume 1, your lordship may kindly see page. The issue framed by the court is, my lord, at page 58, my lord.
58.
Yes. Your lordship had, my lord, whether the plaintiff proves that Madhava Krishnaya executed a registered will dated
58.
18/8/1975. My lord,
You are referring to
my
58.
lord, I have filed the documents, my lord, along with the plain documents. Volume 1 of that document. Page in the top. Yes. Whether the plaintiff proves that Madhava Krishnaya executed a registered will dated 18/8/1975, bequeath the property to the plaintiff and the defendants in the manner stated in the will. My lord, that will, my lord, the answer is in the next page, affirmative. Para 9 is the, my lord, the very extensive reason given by the court, my lord, that the various disputes were taken, this thing, my lord.
No, apart from the will, whatever the other properties with regard to that, what is the finding?
My lord, that finding, my lord, your lordship may kindly come to the will itself, my lord, page 49 in that page, my lord. My lord,
what
first
is
I
the-
will take your
what is the
lordship, page
finding of the
38.
court?
Yeah.
What is the finding of the court with regard
Finding,
to
my lord,
that?
that the will is proved. Therefore, my lord, the will includes the properties which have been excluded. That's the reason I want to draw the attention of the court, my lord, two
Court
paras
has
in the
not
will.
discussed about that in the.
Yes. My lord, now, once the will is proved, my lord, where there is a categorical will, where it says, my lord, I will just
I'm
read, my lord.
asking whether the court has discussed about the will, what are the clauses of it in the
My
this
lord, each of the
judgment?
clauses are not discussed, but
Yes.
the will said, my lord, the will is proved. That finding has attained a finality. Those two paragraphs
What are they? Come to that.
Yes, my lord, that is the para 12, my lord, para 12, my lord, page 68. Keeping in mind if P1 is produced, there is a clear mention of P1. There is a reason as to why the second son of Madhava Krishnaya is not given any properties under the will. Exhibit P1 explains about the properties acquired by Madhava Krishnaya in the name of daughters and the share they held and got transferred in his name. The learned counsel for the plaintiff relies on Millet. Then paragraph 14 Millet, page 70 Millet. Similar is the situation in the present case where though the advocate whose office the will was prepared is not examined, the attesting witness is examined as PW2. In the present case also, the testator dies in the year 1978 after 3 years of the execution of the will. PW2 is the stenotypist who attested P1. PW2 deposes about Madhava Krishna executing a will as per P1. He also identifies the LTM of Madhava Krishna on each page of P1 as well as his known signature along with the signature other attesting. On perusal of the cross-examination of PW2, nothing much elicited to discredit the version of PW2. In the entire cross-examination of PW2, not even a suggestion is made to the witness that LTM found in exhibit P1 is not that of Madhava Krishnaya, nor suggestion that of LTM was obtained fraudulently is made. PW2 state that the Madhava Krishnaya walked from the car to the advocate's office. PW2 also state that the will was
Para
read over.
16, page number 75.
Yes, please. Yeah. Hence, following the decision, we consider the fact that the defense taken by the defendants are inconsistent. If defendant number 2 contends, this is the one the father of the exhibit P1 is fabricated, defendant 7 and 8 totally do not deny the LTM of Madhava Krishnaya. Defendant number 3 in the proceeding before the Honorable Court has accepted the execution of the will executed by the father and the same denies the will so and so. But in this case, defendant number 2 is the father of the respondent and the plaintiff.
My lords, may kindly note that defendant number 3 who has denied the will in this suit is the petitioners before my lords.
Yes. Please come to that will.
Will is at page, your lordship may kindly count I have produced, page 38, only 2 paragraphs. Your lordship, para 3, my second son, your lordship got it. M. Madhusudanan is conducting himself in a manner which is not befitting his position. He is openly insulting me, quarreling with me. He is at least least cooperative with me. He is very adamant. I am very much dissatisfied with his conduct, behavior. Of course, he is possessed sufficient movable, immovable property which are sufficient for him to lead a comfortable life. Besides, his wife, Srimati Leela, has also acquired considerable asset from the father. Therefore, I have decided not to bequeath any of my properties detailed in A, B, said here and there to my second son, Madhusudan. He is not entitled to any share in any of the properties. It is my desire that my alone take my son, my name. Yeah, so name is alone should be involved. Then next page, then he gives the even in respect of other properties only to his 3 sons. The next page is the important second parameter. I have detailed the properties, page 40, second para. I have detailed the properties which I own best of my reconciliation. If any property belonging to me other than these mentioned in this will are omitted, such property shall be shared equally by my above 3 sons, Krishnamurti, Yam Nagraj and Manohar. So this will is proved. Now having participated, your lordship may kindly see the petitioner here in my lord, kindly come to page 50, my lord. The cost title of the suit, my lord.
50 of which papers?
It's the same paper book. This is OS number 10,363 of 87. But in this case, my lord, second defendant, first is M. Krishnamurthy, second is M. Madhusudanan. Since this is by LR, Srimati so and so, then my lord, here your lordships will find Srimati Arati so and so, Kiran, and my lord, son of all the LRs have been brought on record. Then the father of the defendants, plaintiff, my lord, filed a written statement, contested that will, and that has been rejected. My lord, after 9 years, the miscellaneous petition is filed. My lord, for 11 years, they don't comply the office objection of miscellaneous. In 2024, we are served with a notice. And apart from filing the miscellaneous petition and serving after 20 years, they filed the present suit, my lord. The present suit, my lord, on the face of it is a gross abuse of the process of the court.
This will is also part of the plain documents?
Yes, my lord. And this, this is exhibit P1 produced before the court, my lord. In fact, in the plain, they make an averments of the suit. I'm not pleading beyond the pleadings of the plaintiff.
No.
Yeah.
I'm asking, is this will filed along with the plain documents?
Please, sir, please.
Will.
Will was filed along with the plaintiff.
Yes.
Plaint of this suit?
Yes, yes, yes. So therefore, my lord, the trial court goes beyond the pleadings and says whether it is a matter, my lord, on the basis of admitted facts, my lord, succession was thrown open in the year 1978. 87 suit was filed. 2005 preliminary decree is done. My lord, that preliminary decree is implemented in the final decree proceedings. Court commissioner was appointed. And then, my lord, the balance properties, my lord, other children have taken way back in the year 1978. They want to go back in the year 2024 on the basis of this, my lord, Article 110, my lord. When there is an exclusion, 12 years is the period. Now, on the basis of their own pleadings, my lord, is barred by limitation. My lord, if there is any evidence is required, my lord, that is a matter. But the very important factor is, my lord, the matter which has already been concluded by an inter-party judgment, can another suit be filed, whether there is a cause of action for the second suit, my lord, that's what the issue we raised, my lord. Therefore, it is a gross abuse of the process of the court, my respect to sir.
My lords, if I may be allowed to submit, most of the miscellaneous are factually wrong. The second part, I'm not touching on the miscellaneous because that is not the subject matter of this. The other important aspect is, my lords, that they themselves have stated that 73 is excluded from the will. There is no FDP filed with respect to 73. The will or does not include 73.
Important point in this, and repeatedly you're arguing on the same point. Whatever are the properties that belong to the grandfather, he said you are not entitled to any of the properties. He is not giving any properties to you.
Yes.
And in the will, there are certain properties. Any of the other properties which do not form part of this will, all those properties will be shared by my other 3 sons is the will. That will is proved.
It has not attained finality, but it is proved as per the judgment.
If it has not attained finality, that will be decided in the miscellaneous.
Yes, very
petition.
well. However,
how can you file a separate suit?
My lords, because they have not filed it in the FDP. They have gotten the same property by way of a compromise with respect to another suit. So it is not that this is part of or they have executed the will, and as per the will, they have obtained the property. They have filed it against one of the other uncles and obtained a compromise decree and obtained this 73 suit, which is the suit scheduled property.
Forget about all that.
So that they themselves have stated.
To what the court is asking you.
My lords, the will may state so, but the conduct is separate. The conduct itself is stating that this does not form part of the will. My lords may kindly come to this page number because my lords will clearly see their conduct on as to how the suit is not included. 158 of the same paper book, my lords, with the plaint. If I may be allowed to read. Whereas D.R. Madhava Krishna had executed a will dated 18/8/1975 and registered as document number so and so in the office of Basavankudi, all his properties in favor of 3 sons, Krishnamurti, Nagaraj and Manohar, and the area admeasuring so and so, and the said property, which is the suit schedule property, was specifically excluded by D.R. Madhava Krishnaya in his will. Refer to above. D.R. Madhava Krishnaya died on 1978. This is what they say on the sale deed, that says that they have excluded this
What should happen
property.
to the excluded properties?
Excluded property has to go interstate. There are 8 kids. D.R. Madhavi Krishnaya has 8 kids. Only 3 sons are getting it right now. They've excluded all the other rest of the parties. If it is not part of the will, if it is not part of the OS, and if it is not part of the FDP that is arising out of the preliminary decree, 73 has to be divided as per interstate. And none of these submissions are in Order 7 rule. If they want, they can file an application for maintainability on the suit. With respect to Order 7 Rule 11, the court has clearly held there is a cause of action. Limitation is a mixed question of law. Res judicata again requires inquiry. If there is so much of a dispute, then it might as well go for trial.
Third is out. Next.
Please.
Cell number 45.
Yes. Papers are served.
Yes, yes. No, my lords. We didn't receive any.
Then counsel the petition is directed to serve the papers on the
copies, my
curator.
lord. I have an acknowledgement.
Yes, this is matter next week.
Please,
Cell number 46. Haji Salim.
Offering petitioner, my lord.
I appear for
The trial court issued attachment delivery warrant, my lord.
Huh?
Trial court issued attachment delivery warrant against the petitioner.
Your lordship, last occasion,
No,
when the
no,
matter came up before my lord.
1 minute.
Yes, yes.
This is a,
Suit for ejectment, my lord.
so what happened now? Attachment order.
Attachment warrant is issued by trial court.
So what is to be done now?
Your lordship directed him to pay the rents. And also,
He impugned order.
and he took time, my lord, on that day, he took time
My
to
lord,
make
my
the
lord.
payment. Now he is coming
Impugnment
with
order
this.
is there, page number 25, my lord. Only the order is ejectment of the suit stolen property. Not mention any rent pay. No.
So that's why you will not pay anything.
No, I will pay rent.
What rent you will pay?
My security deposit 2 lakh rupees with respondent, my lord. Then I will continue to rent to pay.
How much?
Huh?
What is the amount? What is the-
14,000 per month.
And what about the rents during the pendency of the suit?
Pendants
He
on the suit
himself
already
admitted
2
that
lakh, 2 lakh.
from the date of filing of the suit, he has not paid, he has admitted in the cross examination.
How much it comes to?
8,12,000.
8 lakhs.
8,12,000. My lord, my lord. Page number
And
32,
Supreme Court says, my lord,
If
in.
you're ready to pay the amounts, then we'll think about it.
I will pay till
No, he
October
want to squat on the
2024.
property.
Say,
Yes.
please allow him to speak.
Yes.
Yes.
Page number 32, my lord. I will produce the rent receipt paid by the petitioner. October 2024 till October 2024, the petitioner has paid to rent to the respondent, my lord. Then
Then for the next 2 years, how much the
to
amount
2
will
lakh
be?
rupees, 2 lakh rupees with respondent, my lord. 2 lakh rupees, 20 months rents.
Why should even if assuming that security deposit is there,
Hmm.
why should we exclude it? Security deposit will be given when you vacate the property.
I will pay the rent continue, my lord.
So that the arrears, what about the arrears?
Impugnant order is no arrears is a
I'll hear
discussion.
the matter and dispose it off. Ultimately, it will be dismissing your writ petition.
Page number 24, my lord. To page number 24, impugnant order.
Arrears, how much you're saying? 8 lakhs.
8 lakhs 12,000.
If you're
No such order, my lord.
ready to pay 4 lakhs, I'll grant it.
No such order, my lord. I will pay rent till 2024.
Then I'll hear the matter, argue. I'll pass final orders today itself.
Page number 24, my lord. Impugnant order.
Yes,
Page number 23, my lord.
yes.
Para number 18, my lord. Coming to the aspect of the rent, plaintiff contended that defendant is not regular in payment of rent.
Part of the judgment and read it. And once I complete reading it, I'll pass orders. I'm making it very clear. You have only 2 options. Either you accept the order that's going to be passed by the court, or if you're ready to pay the amount, on that condition, I'll grant an interim order.
The impugnant order is not regarding for payment of, he is asking for.
That's fine. Then if it is not about it, I'll read it. It's a very short order. I can pass orders today itself. Why should we keep it pending by granting an interim order? Argue. Or if you want some other day, I'll adjourn it to some other day. But I'll not grant interim
Till
order.
that, kindly be interim order be granted, my lord.
No.
Otherwise, CRP is infectious, my lord.
Then argue. Then argue.
Page number 23, my lord.
Yes.
Coming to the aspects of the rent, plaintiff contended that
Come
the
to para 14 of the order.
reasons, my lord. Point number 1, the above suit is filed for relief of eviction of defendants from the suitable property. The subject matter of the suit is all that piece and parcel of first floor comprised in premises bearing number 82, Nairupuram, Timaya Road, Bangalore, consisting of 2 bedroom, 1 attached bathroom, 1 common bedroom, hall, kitchen, and residential house property. The suit itself is filed through a GPA holder by name S.A. Amir Ahmad. He is said to be GPA holder of the Mohammed Nizamuddin, who is said to be owner of the suitable property. To show that GPA holder is a competent person to prosecute the above case, the GPA holder himself entered witness box and got examined as PW1. He has produced exhibit P1 to P5 documents in which the certified copy of GPA produced at exhibit P4. It shows that original owner Mohammed Nizamuddin has given a GPA to one S.A. Amir Ahmad, who is PW1 herein on 30/7/2011 in favor of the suit schedule property, perform all acts relating to said property. The reason for GPA is that he will be in Dubai and will not be in possession to look after and manage the suitable property. As per the said document, the GPA holder is permitted to represent interest of the original owner before any statutory or legal bodies as per clause 3. Therefore, PW1 is a competent person to prosecute the matter. Hence, objection regarding his competency to prosecute the matter has to be rejected. Para number 18, kindly be read.
Yes.
Coming to the aspect of the rent, plaintiff contended that the defendant is not regular in payment in rent. The same is not denied by defendant by contesting the case, while the second defendant contended that he is irregular in payment of the rent to the property, has produced several rent receipts in his evidence. Those receipts are disputed by the plaintiff, stating that they are created, but the fact remains that according to plaintiff, regular rent is not paid. In this suit, he has not sought for recovery of rent, only prayer for eviction of defendant along with mean profit is sought. Therefore, this court cannot grant the relief of arrears of rent, as it is not claimed as a relief in the suit. The part of, according to plaintiff, advance of rupees 2 lakh, which is in his hand, is already set off towards arrears of rent. In that view of the matter, this court is of the opinion that plaintiff cannot claim arrears of rent from the hands of defendants herein. Second defendant has not sought for recovery of advance amount from the plaintiff by way of counter claim. Therefore, though he is contended that he is entitled for recovery of 2 lakh from the hands of plaintiff. The said relief cannot be granted in this suit. Several suggestions made in the cross-examination, which is denied by each other, but on the basis of the documentary evidence, plaintiff has proved his case.
What is this finding of the court?
That is also,
It has to be set aside, this order.
yes. And also I filed a review petition as I submitted to my lord last occasion.
No application of mine, no, what is this?
There are judgments of the Supreme Court that the mean profits has to be ordered.
No, where is the discussion? How are you entitled for eviction? No finding on that. When you have let out the property, what has happened? Why this eviction order is passed?
Yes.
We'll set aside this order.
Yes,
We'll set aside this order and demand the matter back to the court.
with the direction to pay the arrears, my lord.
No,
Otherwise, what will
For
happen?
asking it, you can't.
No, because admitted. What I am asking is admitted.
Who stopped you from asking it? The present writ petition is filed. Present CRP is filed. Agreed with orders passed in SC number 644 of 2024, dated 26th March 2026, whereby the suit filed by the suit is decreed. And it is entitled that the plaintiff is, it is held that the plaintiff is entitled for the vacant portion of the suit scheduled property from the hands of the defendants. Defendants are directed to vacate and hand over the vacant portion of the suit scheduled property within 60 days from the date of the order, failing which the plaintiff is entitled to recover possession in accordance with law. The respondent herein has filed a suit for ejectment, directing the defendant to quit, to vacate and deliver the vacant portion of the scheduled premises and for mean profits for unlawful possession by the defendant and also for costs of the suit. The court has passed an order a judgment passing into, running into 19 paragraphs. At paragraph 14, 15, 16, 17 and 19 are is the reasoning part. Para 14 and 15, 16, 17, the court dealt with the facts of the case. At paragraph number 18 and 19, there's a discussion that the court has decreed the suit. Paragraph number 18 and 19, the court records that coming to the aspect of rent, plaintiff, the court records as follows, this extracted, paragraph number 18 and 19. And accordingly, the suit is decreed. Then counsel for the plaintiff, then counsel for the respondent petitioner herein, the tenant petitioner herein submits that the court has failed to consider any of the contentions that are raised by the any of the contentions that are raised by the tenant, and the court has decreed the suit without, and the order is bereft of reasons, and on the ground the order impugned needs to be set aside. Then counsel appearing for the respondent plaintiff submits that the court has failed to grant the arrears of rent, which as admittedly the respondent is not, the petitioner is not, petitioner tenant is not paying the same. And he submitted that the court has rightly allowed the, has decreed the suit and ordered for eviction of the tenant. It is submitted that in respect of for arrears of rent, and on that findings, already they filed a review, and the review is pending consideration before the court. Next, for having other counsels on either side, there is a material non-record. When the petitioner has filed a suit for eviction, when the respondent has filed a suit for eviction, by order impugned, the court has passed a judgment and decree. The court is surprised in the manner in which the suit is decreed. Absolutely no reasonings are forthcoming from the order why the plaintiff is entitled for a judgment and decree, and the court has to fail to record any of the reasons. This order on the face of it as without any reasons, and same needs to be set aside. Accordingly, the order impugnated so and so is set aside, and the matter is remanded back to the trial court. Both the parties are at liberty.
Within 1 month, my lord.
Both the parties are at liberty to advance their arguments, and thereafter the court shall pass appropriate orders within and this whole exercise shall be completed within a period of 3 months from the date of receipt of the copy of the order. Yes.
Number 47 for orders matter. Joseph Anthony.
Right. Here for the petitioner in this matter.
Yes.
Lord, insofar as respond number 8, Lord, we can dispense with notice to them because
What about R1?
R1, Lord, notice will have to be served because he's the original plaintiff. She's the.
No, but I was surprised yesterday 2019 suit is pending here with the stay.
Yes, it is.
R1 has expired, my lord, on 2017 itself.
Huh?
R1 has expired.
Expired?
Yes, my lord. She has expired on in the year 2017 itself.
Order was passed in 2018 and the 19 order was passed.
By the time you file the CRP itself is no more is what is up.
Yes, she's
No, but
no
then
more.
they were not brought on record there in the trial court.
Let's see what is the order impugned.
Please.
And whether if the court finds that there is no point in the
Of course.
petition, then no notice is
No
required.
notice is required. That is true.
Yes, what is the order?
Lord, it's a rejection of applications to reject the plaint.
Huh.
I'll tell you also what the issue is. There's a suit for partition filed. There are 2 sets of sale deeds. One sale deeds are in the year 2001, and therefore suit is for partition of a joint family property. May I just pass on Lord one family tree to your lordship? I'll just explain. It's easier to explain with this. Yeah.
Yes.
My lord kindly sees this is according to the plaint, my lord. Entirely according to the plaint. Muniappa died, my lord, according to them, Muniappa was the owner of the property and the property devolved on him. And his wife is Muniamma. She died on 22/9/2002. He had, my lord, 4 children. Gauramma, my lord, is the mother of the plaintiffs. She admittedly died in June 2005. 24th of June 2005. Their children then filed the suit for partition with respect to certain properties which has come as ancestral property of Muniappa. That is the claim. By the time they filed the suit, in the year 2001, the Schedule A property had been sold. The Schedule B property, we do not know what that property is, because if your lordships look at the schedule, there's no schedule. There's no property itself described. It only says east, west, north, south. There's no property described. I don't know which property that is. But the issue here, my lord, is if she passed away in the year 2005 and the amendment to the Hindu Succession Act came in September of 2005, then the succession never opened up in that sense, and therefore she does not have any right. If she does not have any right on the date of her passing, then the children can't have any right, nor can they make a claim saying it's co-partiality, because when she died, the right did not exist. That's the sum and substance of it. But that is the issue, my lord. And I show you also directly, my lord, Supreme Court in Vinita's case has answered this question, saying that the co-parcina must be alive on the date of coming into force of Section 6 of amendment to Section 6 of the Hindu Succession Act. That's the daughter must be alive. That's what the co-parcina in this case.
Let's see
Yes,
the order of the court.
Order of the yes.
He died in the year 1954.
Yes, that is Muniappa died, and his wife or widow died in the year 2002. Mother of the plaintiff died in June 2005. These 3 facts are clear.
Where is the finding?
My lord kindly comes to page 18. I'm sorry, page 39, internal page 18. In this case, it says para 10. In this case, admittedly, Muniappa, the father of defendant number 1 to 3, died in the year 1954. His wife or widow died in the year 2002. Mother of the plaintiff died in the year June 2005. This much is clear, my lord. On perusal of the written statement of the defendants, they have admitted the suit property is ancestral, devolved on Muniappa from his maternal uncle Nanjareddy, who had no issues. Counsel for defendant number 4 and 5 argued present suit is barred by limitation as per pleadings in the plaint. In this regard, counsel pointed out that Muniappa died in 54 when succession opened. Thereafter, Muniamma died in 2002. Mother of the plaintiff died in June 2005, and the present suit is filed in the year 2002. Therefore, it is barred by limitation. In view of the said argument, I have carefully perused the plaint evidence. In para 8 to 12 of the plaint, plaintiffs have clearly pleaded that so far there is no partition. Suit property remains joint property, and they came to know about efforts by defendant 1 to 3 to sell the suit property in the year 2012. Immediately, they got issued legal notice in 2012, and in spite of the legal notice, they got registered sale deed in 3/5/2012. But in the present case, plaintiffs have challenged the sale deeds dated 10/4/2001, 6/9/2001, the release deed dated 15/11/2007, and the sale deed dated 3/5/2012. I may pause here for a minute. All sale deeds of 2001 are gone because they are covered by the amendment. Plaintiffs have clearly pleaded they came to know about the previous sale deeds in 2012, and they are claiming share through female legal heir. Same is to be considered. It's well settled position of law. Issue relating to limit mixed question of law and fact. Then para 11. On perusal of plaint evidence, plaintiffs have claimed 1/4 share that is equal share along with defendants 1 to 3 on the basis that they being the children of deceased sister of defendant 1 to 3, they are the joint family members, and suit schedule property is a joint family property. Counsel for defendant 4 and 5 has relied on the decisions which are to the effect female legal heir are not co-parceners. They are entitled to share only when the male members seek co-partition or at partition by the co-parcens. In this regard, they relied on decision in Ramaka's case. On perusal, said decision dispute in the case is identical to the facts and circumstances of the present case. As in the said case, Karta of the family died in the year 45. Succession was opened. Suit of partition filed in the year 1976. Said decision rendered in the appeals.
Judgments in this regard.
My lord, I'll just show you also one direct judgment of the Supreme Court. My lord, in Vinita's case. Vinita Sharma's case, which has answered this issue.
Take that.
Can I humbly request, my lord, to come to para 80, my lord, because this is what was there in Prakash versus Poolvati, the earlier judgment which said that both the father, the male member, as well as the female member must be alive at the same time. Para 80.
Yes.
A finding has been recorded in Prakash versus Poolvati that the rights under the substituted section 6 accrue to living daughters or living co-partners as on 9/9/2005, irrespective of when such daughters are born. May I pause here for a minute? The finding at that time, as Lordship may recollect, was both the male member as well as the female member, both must be alive. So the male member has passed away also, the female member will not get a right, was the understanding in Prakash. We find that the attention of court was not drawn to the aspect as to how a co-parsoner is created. It is not necessary to form a co-parsonary or to become a co-parsoner that a predecessor co-parsoner should be alive. Relevant is birth within degrees of co-parsonary to which it extends. Survivorship is a mode of succession, not that of formation of the co-parsonary. Hence, we respectfully find ourselves unable to agree with the concept of living co-parsoner as laid down in Prakash versus Purvati. In our opinion, the daughters should be living on 9/9/2005. That, my lord, is the position in law. And if she was alive on 9/9/2005, then, my lord, she would have been entitled to a share. Then the children could have made a claim for the share.
No, she died when?
June 2005. That is an admitted position.
Hmm.
And therefore, when survivorship never opened for her in that sense, then she can never make a claim with respect to the property. That's the issue, which is why I said, I do not know this passing away, because even in the suit, she was not made.
What do you say about that?
Lord, that issue is also diluted by judgment of the coordinated bench of this honorable court, my lord.
Supreme Court judgment be diluted.
They have relied on the same judgment, my lord.
No,
And
but
they
you
said,
can't, how can,
my lord, the only issue is this, my lord.
let's see.
Please.
What is that? How
Only
it is
take two
diluted?
paragraphs of the same, lordship may kindness. I request lordship, my lord, to kindly come to page number 19, my lord. 19.
Page number 19.
19, please, 19. Start with para B, the apex court. They're relying on the same Vinita Sharma's case.
Hmm.
The apex court in the case of Vinita Sharma has clearly opined that daughter has to be treated as a co-parsoner at par and right is by birth. Therefore, what can be inferred from the dictum laid down by the apex court in the judgment cited supra is that even if daughter is not alive when 2005 amendment to the Hindu Succession Act was passed, her legal heirs cannot be deprived the benefit of 2005 amendment. The apex court unequivocally stated that a daughter should be treated as a co-parsoner with equal rights by birth. As the right is by birth and not by dint of inheritance, it is irrelevant that a co-parsoner whose daughter is conferred with birth right is alive or not. Further, therefore, even if a daughter passed away before the 2005 amendment to the Hindu Succession Act, her legal heirs cannot be denied the benefits of the amendment. The court affirmed that the daughter's right, being inherent from birth, is comparable to that of a son, irrespective of the timing in relation to the enactment of the act. If a daughter who died before 2005 has surviving legal heirs, they could potentially enjoy the equal rights conferred by the amendment on ancestral properties. Denying equal rights to legal heirs in this context may not only be considered discriminatory, but could also be subject to legal challenges. It goes against the constitutional principles of equality and non-discrimination enshrined in the Indian Constitution. Courts, when interpreting and applying the law, often strike to uphold those fundamental principles and may intervene to ensure the rights of the individuals, irrespective of gender, are protected and upheld. By refusing the benefits granted to the similarly situated heirs of sons, it undermines the fundamental principle of equality before the law. To elaborate further, the judgment in the case of Vinita Sharma effectively removes the temporal restriction associated with 2005 amendment to the Hindu Succession Act. It recognizes the rights of the daughters and the legal heirs in ancestral property, regardless of whether the daughter predeceased the father before or after the amendment. This retrospective application ensures that the principles of equality and non-discrimination.
No, this is all whatever the learned judge has observed.
Please.
Is from the judgment.
Yes.
That we have to read it from the judgment.
Yes.
So please show it.
But the paragraph which learned senior read, that was quoting the early decision in Prakash versus Pulvati's.
No, this entire judgment, whatever now you have read,
Please,
is basing on Vinita Sharma's
Yes,
case.
Vinita Sharma's
That is,
case.
Vinita Sharma is before us.
Yes,
Please read from Vinita Sharma. Where did the Supreme Court said so many things?
May I request in the same judgment,
Yes.
page 77?
This judgment?
Please, the judgment which learned senior.
Yes.
So there are two relevant
Para
paragraphs.
number 11, I think it's 77.
77.
Thus, we hold that according to section.
There are two relevant portions in this based on which the judgment is written. May only request for a short password. I'll just answer this. Only two paragraphs, please. Now, because I'll assist the lordship.
No, if there is an issue, my lordship will have to consider it. I
Yes,
have to
yes,
either take steps.
I'll
If my
definitely
girlfriend can take, let us know who the other.
You appear for them. You have this
Your brother,
R1.
yes, No, my lord. I appear for the plaintiffs in the case.
I know if you can tell us who the legal representatives are, we'll bring them on record. So
No,
it's one for final
as far as
answer.
my information is concerned, she has no legal heirs.
Why then it's
That's the problem. She expired during the pendency of the proceedings, and my information is that instructions are that she has no legal heir. So that ends the matter.
very well.
And I'll only assess lordship on these two paragraphs from the Vinita Sharma.
Yes.
Please.
Your lordship may have it on Monday or Tuesday. I have
Please,
some-
lordship may have it on Monday.
Difficulty for the court is I can't take up the matters repeatedly.
Any
because
date
of
that your
the
lordship
kind of
considers
matters that
I'm
are
sorry,
pending.
but I unfortunately have a matter at 4 o'clock before that. That's why.
Let's just matter on,
Whenever
in
it's
the
convenient.
meantime, what about this R8 memo is filed?
Memo we filed.
Memo is filed. File the memo. A memo is filed, second dispensation of notice to R8.
Yes.
Dispensed with. It is submitted by the learned counsel the petition that R1 is no more. Learned counsel appearing for the respondent plaintiff submits that as per his instructions. R1 is not having any hair.
Yes, that's what the instruction.
No having no legal hairs.
Therefore, your lordship may dispense with notice on the basis of submission, Lord, because that will put an end to it.
That's my instruction, but.
No, I know.
But anyhow, you are the plaintiff is before the court. Rejection of the plaintiff. Hence we cannot.
Hence, no further
keep it
steps is
that-
required.
no,
We'll keep it that, please.
Keep it like that, and let's this matter on 27th of July.
Right.
Please.
Interim order speech.
Interim order earlier granted is extended. All 2:30 matters at 4 o'clock. I have to raise by 4:40.
Cell number 10, cell number 48.
For the petitioner in this
Maintainability of
case, my lords.
CRP.
My lords, we will file with RFA, my lords, it may be disposed with liberty of filing RFA.
How can you
It's a
file
correct-
it then? How are you filing CRP for a RFA? Office has raised objection with regard to maintainability. RFA where it has to be filed? Before this court?
yes, ma'am.
This court only? The memo is filed. You want to withdraw or you want
I
to
want to
convert it?
I want to withdraw with the liberty of filing. RFA.
The office has raised an objection with regard to maintainability. In view of section 115 of the CPC and comes to the petitioner, submits that instead of filing a RFA, they have filed this CRP and seeks the liberty to withdraw this petition with the liberty to file a appropriate petition accordingly. The CRP is dismissed as withdrawn with the liberty to file appropriate application within a period of 2 weeks from the date of receipt of the copy of the order. Yes, 49.
Cell number 49 disposed. 40, 50. 50 Arjun Santosh.
The office objections regarding more than one IA challenge. It's a joint order.
What are these orders?
It's an application filed by section 5 of limitation. As I filed an application under order 7 rule 11. So when the lower court had passed the order, the lower court had passed a joint order. That is why the same was challenged.
What is the section 5?
Section 5 of limitation act. So my lord, this matter is regarding for Power Grid Corporation. We have electrical lines drawn across. It's regarding the compensation.
No, order 7 rule 11, it's a separate application.
Yeah, we have filed order 7 rule 11. They have a delay of 32 years. So they had filed a section 5.
So it has to be two separated petitions.
The order, lord,
Maybe, but you have to file, you restrict this writ petition to one order and one IA. On the other IA, you file another
order,
petition.
lord, the order is a joint order. That is why.
Still, you have to
Lord,
file
in other matters, Lord has already issued notice.
No, in other matters, what I said is, in the connected matters.
Connected matters. Lord.
Show where is that order?
It is petition 7964 of 26, 7996, all 4 matters, the batch of 13 matters. All matters, the lower court had issued this joint order for both applications.
Have I passed the
Yes,
order?
my lord, you have already issued notice in four matters.
Keeping the issue of.
Yes, that you are already, the objections, office objections were overridden by this honorable court. I can say
it is
7964.
submitted the corrected matters, office objections or overruled. Notice to the respondents. Yes.
Cell number 51.
Same matter, my lord. Mr. Blair.
52. 52.
52.
Take notice for the
Cell number 52.
respondent. I'll take notice.
52.
Please.
What is this? Maintainability or
Your order 7 has been dismissed, my lord.
order 7 rule 11 dismissed.
Please.
The office has raised objection with regard to maintainability as the order impugned is dismissal of an application filed under order 7/11. Office objection is sustained and the petitioner shall convert this into a CRP within a period of 2 weeks from today. For statistical purposes, the petition is
53,
disposed of.
Rupesh B. 53, Rupesh B.
No representation on behalf of the petitioner. This is matter in the month of September. 54.
54, Ajay Kumar.
Notice to R1 and R3 returned with postal share unclaimed amounts to deemed service of notice.
Yes, my lords.
Yes.
There's a short writ petition whereas my lords, the trial court without giving a
So
speaking
if
order.
R3 notices are completed then?
I have all the
Process is
notices has
complete.
been completed. My lords, the short writ petition, I'm seeking
Millards,
at
I'm
R4.
appearing for R4, Millards. Kindly pass over, Millards. Senior is stuck in another court.
There is no R4 in this case.
There is.
Huh?
There's R4 in this case.
Then you said notices are served?
Notice has been served on the on R4.
Oh, yes, for some hit test for R4.
Yes.
Yes, Millards.
You have an interim order?
I have the interim order.
Interim order earlier granted is extended.
Millards,
This is
kindly
Martin.
pass over, Millards. Short
Month of
date.
August.
Number 55,
List it on
For the
3rd
petitioner,
of
my
August.
number 55, Archana Mukti.
My lords, office objection is that, my lords, plaintiff number 6, why plaintiff number 6 is not made as a party, my lords? My lords, she has expired in the year 2013, my lords. That's why I have not made party in this writ petition. So kindly
No.
overrule the office objection, my lords.
As when what is that, what is the impugned order in this?
My lords, giving police protection is challenged in this petition, my lords.
So in that, while that order is passed, she is alive?
No, my
As per-
lords. No, my lords.
Then why the office is raising the objection? Where is that order?
Here, my lords, office has raised.
Come to the
objection.
plaint.
Please, my lords. My lords, one submission, my lords, have, so far as granting injunction order, my lords, have filed the writ petition, my lords. Kindly it may be called along with writ petition 25348, my
Along with
lords.
so and so. Yes, next.
Along with the sale number 50.
My lords, kindly date may be given, my lords.
List along with so and so on 29th of July.
Sale number 56,
Lords,
Shiva
I
Kumar.
make on submission, my lords. Before the trial court, they are not giving any time and they are trying to dispose us, my lords. I am in the
You can argue
position.
this matter independently then.
I am in the position,
List
my
on
lords.
14th.
Much obliged.
Sale number 56, Shiva
No
Kumar B.
representation list in the month of September.
Sale
Yes,
number
56.
57, T. Sheshgiri Rao.
I represent respondents. I have not received the copy. Yesterday, I requested the other side to serve the copy of the petition.
They've served or not served?
No, not served.
My apologies if there's been an email sent, I'll just hand over him another one. It has been sent electronically to his mail. But if you want
Yesterday
a
was asking
physical,
for a copy.
I'll tender it. Minutes.
Yes, list this matter after on 15th
May I
of
request
July.
this minutes for one moment?
Yes.
Minutes, it's in the orders because your lordships pointed out yesterday there are two prayers. My lordship would remember. So I have already filed a memo minutes restricting it to the application filed.
Office objections
Let it be listed in fresh matters on
office
Monday,
objections
minutes, so
or
that we
overruled.
can.
List this matter for preliminary hearing on Monday.
I'm great.
Yes. And by the time, if you don't serve the papers
I'll-
on it,
I'll serve- I
I'll
will
dismiss
serve.
it on the ground. Already 3 times it is coming up in the list. 58.
Why don't you serve?
Petitioner will, office subject, we have challenged the two orders.
What are
One
those two IAs?
Two As, well, as a common order passed by the trial.
What are the IAs?
One for the, not to interfere or peaceful position of the said property, not to create third party rights for the suit scheduled property.
If if one is granted, one, you have to file two.
I will restrict to one, my lord. Order
It is
39
submitted
one,
that
two.
then counts to the petitioner, submitted with the counts to the petitioner that they're restricting the prayer to I number
1.
I number 1. You shall carry the necessary corrections. List this matter on Tuesday in the first list for preliminary hearing.
In the meanwhile, they are interfering and also they are.
Doesn't matter.
Serial
Yes.
number 59.
Really,
Syed Khalil Pasha.
they are interfering our peaceful position, my lord.
It will, nothing will happen. Yes.
Serial number 59.
Monday, my lord, Monday.
Monday, there are so many matters, it will not reach even if I give you.
Much obvious.
Yes, 59.
59.
Two application, my lord. One application for reopen, my lord. Another application, my lord, recall. Same.
Office
for fi-
objection with regard to the maintained
For
milk
filing
is
written statement.
overruled. Huh?
For filing written, only 9 days delay is there, my lord, with regard to filing written statement. Tomorrow, final argument is posted, my lord.
Come to the impugned order. Where is it?
Yes, my lord. Page number, my lord. Page number 16, my lord. Page number 15, my lord.
Delay is 9 days.
Delay 120 days, my lord.
9 days delay.
9 days delay.
When counsel for the petitioner submits that the court has refused to take the written statement on record as the written statement is filed after 129 days in the light of the amendment. It is submitted that the coordinate bench of this court has stated the operation of the amended provision. Hence, they shall be considering the same. They shall be stay of all further proceeding. Notice and summons and memo shall be filed by 23rd or else the stay granted by this court stands vacated. Yes, next.
Serial number 60 to 63 ordered. Serial number 64. H. Devendrappa. Serial number 64.
But there is an order to make payment by the BBMP, as against which they have approached this honorable court. We have established our case, we have made accounts. The court came to the conclusion.
There is no representation on behalf of the petitioner. List this matter in the month of September.
Not too long a date, he is aged also. But almost
Not
it is
respondent.
20 years, not have been in this litigation.
65. 64.
20 years, my
I
lord.
am not granting interim order. I am not extending the interim order.
Please, my
Yes.
lord. Lords may say that interim order is not extended.
There is no representation on behalf of the petitioner. This court is not extending the interim order.
Serial number 65. Sutindra S.A.
Kannada depositions are there.
What is the CRP?
This is earlier application is filed, but I have no objection for fixing any early. But other side, in fact, the application is filed by the respondents. They themselves are not present.
I am for my lord appearing for respondent number 6. Actually, we are supporting the petitioner because the respondent number 6 scheduled property has been included in this. And reality is that his scheduled property is
CRP
different.
1702 2017. Who appears?
In
170 CRP. You are for the petitioner? CRP 170.
Yes, we are appearing in CRP 432 of 2023.
And my lord in
Same
CRP
case, in the next CRP.
I am
number
appearing for
124.
respondent number 5, my lord.
My lord,
I
in
number-
CRP number 184 and 185, I am appearing for the petitioner. Some notices have been served, but some parties are showing unserved. So we will take the steps.
170 of 207. I number 1 of 24 is filed seeking for taking out notice by way of substituted service in respect of R4 and R5. Accordingly, IA is allowed.
Taking on
Petition.
or before 17/7, 31/7.
Yes. And next in the same one, in that CRP 170, the cause title shall be amended by the next date of hearing.
All these
Then
CRPs arising
65.3.
from same order.
Same common judgment.
65.3.
Yes.
A week's 2 weeks time is granted for taking steps in respect of audit, or else CRP shall stand dismissed.
65.4 also.
Furnishing of process in respect of R7, R9, 11, 14, 16 within a week. or else the writ petition shall stand, the CRP shall stand dismissed against the said respondents. Office objections shall be complied with within 2 weeks, this also. Or else, even on that ground, the writ petition shall stand dismissed. Then office objections with regard to I number, raised on IA number 2 of 24 shall be complied with, or else IA 2 of 2024 shall stand dismissed. Next, 65.4. Steps shall be taken in respect of R10. The process shall be paid in respect of R8, R9, 11, 13, 16, 18. First, 18, same default order. Then in, yes, list is matters on 9th of September. Interim order located if it is there in extent.
Then
Yes,
number
66.
66. Raghunath Reddy or
Please.
That I have already ordered. Yes, next.
Cell number
Lordship,
66.
Lordship in CRP 185/24, with due respect to this honorable court, I am appearing on behalf of B.V. Venkatarama Setti. I was instructed from my client to file a fresh wakalat along with the NOC. I request to this honorable court, I may be.
Whatever you want to do. For that,
My
the
lord.
court don't have to say anything. Yes, call the
Cell
matter.
number 66. Raghunath Reddy.
Notice.
Number 67.
Notices are, yes,
But condemnation of delay is the IA number.
that's why notice.
Cell number 67.
Notice.
Cell number
68
68.
notice. 9 notice.
9.
70. Yes, 70.
Cell number 70.
Petitioner, my lords.
Hmm.
My lords, the IA is filed, my lords, by the LRs of the defendant, my lords. Defendant died during the pendency of the suit, my lords.
When he
And
died.
in the month of August 2025, my lords. The death certificate is produced at page number,
No, this is arising out of which order?
rejection of 7 to 11, my lords.
So before the
Trial court defendant is not, LRs of the defendant is not made a party, my lords.
no, you should implead yourself there.
This, my lords.
You should implead yourself there.
Yesterday they have filed the application, my lords. The plaintiff has
Let
filed.
it be done. We'll see. Yes, this is matter after 2 weeks.
My apologies.
Cell number 20.
But 66, my lord, the respondent is already on record. You
It's already appearing.
Please.
66.
Wakalat has been filed.
Chandrasekhar L.
My apologies.
List is matter in the first list tomorrow.
Highly great.
It's in the list, same list tomorrow. No,
Great.
no representation on behalf of the respondent. Yes.
Much obliged.
71. A.V. Gangadharappa.
No representation in the month of September. Yes.
72.
72 notice.
My lords, there is a warrant in fact issued by the trial court.
But there is a CRP, there is a delay in a delay petition.
Delay of
will
5
not-
days. My only request is, my lords, the warrant, if I could just place,
I cannot. You have come up with a delay.
I understand. The warrant is for attachment of movables. But in fact, the case of the
Have you
plaintiff,
not contested the matter?
my lords,
Have you not contested the matter?
I have, my lords.
Then why did you come with a delay to the court?
My lords, the problem was they are senior citizens. They were not in town. In fact, the daughter was due to deliver, which I've stated in my affidavit. My only request is, my lords, let them not precipitate because they could come any moment, my lords, because notice was also not issued to me in the execution proceedings. A warrant was directly issued, my lords.
Let's see.
Please, I should place that before my lords, please. That's the warrant, my lords. I was not even given a chance to show sufficient cause in the
When was
execution
the,
proceedings.
when was the
17th
judgment and decree?
Judgment and decree was passed on the 6th of February, my lords.
Hmm.
17/6, that is after I filed CRP, they filed their execution proceedings.
You are aware of the judgment and decree on
Please,
6th February?
my lords, definitely.
Then there was no, you could have come to the court much earlier.
During the vacations, I wanted to, my lords, but the problem is the petitioners are senior citizens. They were in Bombay, their
You
daughter
could
was
come
due
now
to
to the court being a senior citizen.
my lords. There
No,
is.
that is not.
After my lords,
Can't take advantage of all this.
definitely not. My lords, if I could just demonstrate as to what the case is.
If you don't question that, they will file the execution.
My apologies, my lords.
Give the file.
My lords, this is a petition, this is a dispute which arises out of tenancy. I am the landlord, my lords. The suit filed by, suit was filed by the tenant. My lords, if I could take my lords through the dates, the rental agreement was entered into on 18th of August 2021. There was a deposit of 3,30,000 that was made, my lords. The first term was for a period of 11 months. Thereafter, the 11 months was extended. During the second term, my lords, the
Then,
petitioner.
will grant stay only on condition.
Please.
There is an amount of rupees 1,30,000.
That is my lords, what the trial court has looked. Trial court has not mentioned that it is an earnest deposit, which in fact the plaintiff admits in his cross examination.
To understand, more or less, it is like a recovery suit.
Please, my
Recovery
lords.
suit, we will not go into the
I
merits
shall
of the
deposit
matter.
it before your lordships, my lords, in this court, my lords. I shall do that.
How much?
My lords, the decree is, my lords, to the tune of rupees 1,30,000, my lords. My
Half
lords,
of it.
50%, my lords.
petitioner, the land counsel, the petitioner submits that the court has failed to consider the case of the petitioner in the light of the settled law and directed to and passed an order to require a sum of rupees 1,30,000. It is submitted that the petitions are senior citizens. Hence, there is a delay of 5 days in filing the appeal. Though generally, this court will not interfere with, will not pass an order where there is a delay, considering the fact that these are the senior citizens. This court, accordingly, this court is passing the following order. The judgment and decree dated 6th, there shall be stay of all further proceedings. Judgment decree in SC number 30 of 2024 dated 6th February 2026 on the condition that the petition shall deposit 50% of the amount. That is, I'll say the amount,
75,000.
an amount of rupees 60,000, an amount of rupees 60,000 within a period of 4 weeks from the date of receipt of the copy of the order.
Gratefulness.
To the respondents.
Obliged.
And the petition is permitted to take court hand summons on the counsel appearing before the executing court and file a memo to that effect by 23rd of July, or else a stay granted with this court stands.
Great. Obliged.
Urgency mentioned matter, cell number 105.
In the 73 also notice.
73 notice.
75.
Then I'll not be taking up the list.
My lord, 74, my lord. 74 adjournment needed, my lord. In 74, my lord, there are 2 cases already disposed of, filed by the claimants for enhancement, and 2 more appeals was filed by the appellant for negligence aspect, my lord. We recall the order to dispose all 4 matters together, my lord. We will file one memo on Monday, my lord. Kindly, all 4 matters may be disposed of.
It should be taken up when?
74, my lord.
When it should be
Monday,
taken?
my lord, we will file
Monday.
withdrawal memo.
Yes, this matters on Monday. Yes, call the mentioned matters.
My lords, only one.
105, my lords.
List to serial number 8, my lords, that correction was there, my lords.
Why you are not mentioned in the morning?
We did, my lords. In fact, it was told it will be taken up on top of what we didn't want to.
Anyway, it has not come up. How will it?
Come today.
It's come today, my lord. Where is it on
List
the top
2,
of the list?
it is not come on the list 2, serial number 8.
Hey, if it is not come, then no, you should have asked.
Sorry for that, please, my lords.
Take out that file also. Yes.
Please, my lords.
What is this number?
105, my lords.
There is the counsel for the respondent in
Lords,
105.
he is in video conference, my lords. Mr. H.V. Devraj.
Yes, Mr. Devraj.
Hello, sir. H.V. Devraj, sir.
Lords, petition itself could be disposed of in an
Restrained from erecting the electric towers as well as passing of tension wire over and above the petition property.
Lords,
Authority to remove the pit dug in the petition.
in an identical situation, my lords, the coordinate bench of this honorable court has directed, follow due process and then they have to follow the procedure prescribed under Indian Telegraph Act, my lords. It will be this
Are you
petition.
anticipating that they will not do it?
No, they will not do because without taking any permission.
Yes, Mr. Devraj.
That I represent respondent.
Yes.
As my kindly.
I'll dispose of saying that as per the provisions of the Indian Telegraphic Act, you follow, you can lay the lines.
They will have to follow the procedure.
Not
Till
that
then
I
they will not
represent the I represent for the respondent.
Yes, I understand that.
Not that I have already approached before the district magistrate. Yesterday I have filed the petition. Removal of obstructions. Till disposal of the matter that it can be disposed of writ petition after obtaining permission can execute the work.
But
After giving opportunity
that
to the
is all, my
petition.
lords. That is the reason. They have to first approach. Now they have dug the pit without even
Already
approach.
filed the petition yesterday,
My
my
lord,
lord,
it's already
16.
due process.
Yes, sir. The presented petition is filed. Sing the following prayer. Then council, it's a case of the petitioner that petitioner is absolute owner of the total extent of land measuring 8 acres situated in survey number 113/1, 113/2, 113/3, 114/1, 114/2, 114/3 of Kalipura village, Angala Hobli, Budlupet Taluk, Chamrajnagar district. It is a grievance of the petitioner that, oh, 2, 3 petitioners are there. Petition number 1 is the owner, then petition number 2 is the absolute owner of the land measuring 2 acres 25 hectares situated in survey number 76 of Devarahalli village, Angala Hobli, Budlupet Taluk. What is that? Chanrajnagar district.
Chamrajnagar.
Chamrajnagar district. It is a grievance of the petitioner that the respondents in the process of installing high tension 66 kV electric line connecting Anga substation of Kanegala station. They are setting up the electric towers in the properties of the petitioners at 2 places, and also the high tension electric lines are passing over the scheduled properties. It is a grievance of the petitioner that they are not following the due process. Then counsel appearing for the petitioner submits that if the respondents wants to lay the lines, they have to follow the procedure as contemplated under the Indian Telegraphic Act. And also there is a circular by the central government. There is what is that circular? Some SOP is there.
Devaraju sir. For appointment of compensation, that payment of compensation with regard to the circular which are provided. That's so far as the removal.
And also the time and also the guidelines issued by the
central government.
By the central government from time to time. It is submitted that without following the same, the respondents are laying the high tension lines and also have dug the land for laying the towers.
My lord, they'll have to follow the guidelines which is at Annexure G, my lord. Technical specification for detailed surveying by using modern survey.
That all that we have availed, but only under 16(1) removal of
Annexure G,
request to approach before district magistrate.
57 minutes. This is the NRSA, National Remote Sensing Agency. Google. This is the.
No, apart from there are new things also have come latest. The land council appearing for the respondents, Mr. Devaraju, H.V. Devaraju submits that they've already approached the deputy commissioner and they've already filed an application. It is submitted that they will obtain the necessary orders and then only they will proceed with the correct.
Yes, clerk. After obtaining permission, that remove obstructions under 16(1).
Then only after obtaining the necessary permission, they'll proceed with laying of the lines oblique towers. Next, for considering the submission of the learned council for the respondent and also considering the arguments of the land council for the petitioner. As they have already filed an application before the deputy commissioner under the Telegraphic Act, the respondents are directed to follow the due process. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the respondents to follow the procedure under the Telegraphic Act as well the circulars guidelines issued by the state and central government in this regard.
Till then, not till then not to precipitate.
Till then, the respondents cannot proceed without following the due process.
Grateful.
Much.
Number 106.
My lord, I appear for the petitioner in this matter.
My lords,
This matter.
with respect to DC has the power or not, my lords, I produce the document.
Take that.
The annexure A and B, which is produced by the petitioner herein, are the renewal license, my lord. This is the original license wherein the DC has power to
License
grant.
was suspended or cancelled in accordance, where do you get that? In accordance with the provisions of section,
29 of the Act.
who has
Excise Act.
granted this is
It is
deputy
granted by
Deputy
excise
Commissioner.
DC. My lord, that is what my learned friend is getting confused. My lord, this judgment is
According
straighter.
to him, what he's saying is, license was granted by the deputy commissioner excise.
Excise. He has to cancel it.
Excise.
This is granted by Deputy Commissioner. Rule 5, my lords, Rule 5 and Rule 5A. The document which is
Kindly look
produced
into
is.
the license. Your lordships may kindly look
This is
into.
your license?
No, no, this is not my license.
Srimati G.V. Jayalakshmi.
It is their license, my lords. Alida Nodi, sir.
My lord, this was initially. Now it is the.
That is
the
grant of
latest.
license.
My lords,
That's
may
the
kindly
simple rule, my lords.
initiate-
Rule 5 and Rule 5A, my lords.
No,
5 is about grant of license.
Let us hear him.
My lords may kindly see annexure A. May
No, your submission yesterday was,
please.
he read section 729, read with rule 5 of the rules.
Please.
What you said was, the license granting authority, in my case, the license is granted by the deputy commissioner excise, but not deputy commissioner. So now he has placed the license before this court.
My
It
lords
is
may-
granted by the deputy commissioner.
May I take your
Yes.
lordships to? My lord, initially the license will be granted by the deputy commissioner. Thereafter, my lord, so far as section 7 is concerned, it is the power, delegation power, which is now delegated to the deputy commissioner.
When
of
was it
excise.
delegated?
My lord, it was, that's the reason, my lord, I said it is purely covered by the judgment of this honorable court.
No, let's not go into all
Please.
those judgments. It's on a very, very simple issue.
Please.
Now, this is when this license is granted to you.
My lord, 2016, this is first time they are giving it to me. My lord, may kindly for a
This
moment, annexure A, page 13, may kindly be.
30th June 2015 was a license granted to you.
Now, my lords may kindly look into page 13, my lord, annexure A. Page 13. 14 may kindly be looked into, my lord. This is the license. in Form CL9.
Yes.
On the bottom, Nagarajappa so and so, Deputy Commissioner of Excise. Bengaluru Urban District, this is valid up to 2030.
That grant of license is different. A renewal of license is different. This is the renewed license which they are showing, my lords, under Rule 5A. What I'm demonstrating to my lords is under Rule 5 of the IMFL rules. That is all, my lords. And the word is authority granting the license. Now, if you see the conditions, my lord, which is imposed in condition number 5, section 29 clearly mentions, my lords. So the annexure G, which is passed in this case, is to be rightly held, my lords. It's passed by the DC itself.
In fact, my lord, what happens is,
There is some point in what he says. It requires hearing.
No interim should be granted, my lords.
it may be taken up on Monday in first list, my lord.
Monday, and don't mention again on Monday. Wherever it is, it will be heard. Monday
It may be
in the
taken
first
for,
list.
because from last 1 month, my lord, we are unable to operate.
But you have to understand, I've already heard it 2 times. Monday it will come.
Monday, first
Wherever
list.
in the list, first list it will come. But I will not again out of turn will take up. Yes.
List 2, serial number 1, Mohammed Naziruddin.
I appear for the petition.
Yes.
Your lordship, kindly go to page 45, my lord.
What is the order?
The order rejecting my application
Hmm.
without any reasoning,
What is the
without
application?
application under section 2 and 3 of the Partition Act. Preemption, right of preemption was exercised, invoked by the LRs of first respondent. My lord, kindly appreciate, out of 10 shares
Please come to the order. I'll understand from the order.
to partition, yes. Your lordship, kindly go to page 34, my lord.
Yes.
Your lordship, para 20, the learned judge only says it appears from the orders so and so, dated so and so, even before the said proceeding. The learned counsel for LRs of first respondent has took very same contention that no inquiry on the said date has been held by this court in spite of there being a specific direction in RFA number so and so. The said contention of LRs of first respondent herein is answered by the Honorable High Court of Karnataka, holding that said contention was considered, reiterating para 76 and 77 of the judgment in RFA number so and so. Therefore, there is no merit in the said contention of the learned counsel for the LRs of first respondent.
So please come to that order which the court is referring.
Order is only,
WP number 15176
yes,
and this RFA number 1479 of 2012.
that orders is also there, my lord.
Where is it? Take that.
There.
Page number? There is a relevant finding.
Yes, my lord. Your lordship, the relevant para at page 154, my lord, internal page 54.
Page 182.
Please. Para 76, my lord. In this connection, final decree proceedings are not made optional to the parties. On the other hand, there was definite direction of the court to conduct final decree proceeding in order to adjudicate the particular point. In this connection, there was no alternative except to conduct final decree proceeding for the trial court and also to the party to participate therein to adjudicate the matter. In this connection, it is not a remand, but it is a process wherein this court ordered the trial court to deal with and dispose of the matter pertaining to the sale
One
deeds.
minute. Now, counsel for the respondent.
Please, ma'am.
In this order, this is RFA number 1479.
Yes, ma'am.
Where is the discussion that this court, the trial court is referring?
Lord, my lord can kindly take para 71, page 51. ma'am.
71?
Para 71, page 51.
Uh,
My lord, my learned friend is agitating that certain sale deeds which were executed by the parties were
No,
binding
now-
on the parties.
Now he wants to purchase the shares in the, or whatever it is from the partnership.
Certainly.
Now, if that is the case, the court has to decide
No, no.
whether he's entitled for that or not.
Certainly. My lord, earlier they had filed a writ petition challenging the court commissioner's report itself. If my lord, we permit me to file this writ petition order, which was passed on 10th December 2025. My learned friend has not produced it. Therein, they conceded before this honorable court that if they be permitted to participate in auction along with other parties, then they are satisfied.
Oh, that is all.
That is
That was
totally
the point.
different, my lord.
But why the court doesn't even discuss about how they are not entitled?
Not the original side.
Going
court has-
on extracting one paragraph from RFA, one paragraph.
That was only because my learned friend had argued saying that sale deeds are not binding, sale deeds are.
Let's see.
Please, my lord, may I kindly take this judgment of this court. My lord, page 17, my lord, para 9,
Para.
9, my lord.
Page?
Page 17, 17.
Hmm.
Paran, I do not find any illegality or irregularity in the said order, which is passed taking into consideration the order passed by this court in RFA 1479 of 2012. It is not in dispute that as on the date when the order of impugned was passed, no application was filed under section 2 and 3 of Partition Act by any of the parties. This court in RFA 1479, taking into consideration that the court commissioner in his report had stated that the suit scheduled property cannot be divided, had directed the trial court to work out means for suitable alternative as per law and complete the final decree proceedings. The trial court, having rejected the objections of the petitioners for court commissioner's report dated 14/8/2009, for the reasons assigned in this order, impugned has partly accepted the court commissioner's report subject to certain conditions. Perusal of the conditions would go to show that in the impugned order, the trial court has permitted the parties to participate in public auction subject to certain conditions. Though in condition number 1, it is mentioned that petitioners are permitted to participate in the auction sale along with public, and first preference should be given to the petitioner subject to obtaining prior leave of the court within the stipulated period on or before the next hearing of the day. Learned counsel for respondents fairly submit that it was a mistake committed by the trial court after having observed in the operative portion of the order that all parties are at liberty to participate in public auction. They submit that condition 1 in the order impugned may be suitably modified and all parties in FDP 3 of 2006 may be permitted to participate in auction sale. If such order is passed, even the grievance of the petitioners that no orders have been passed on this application filed under section 2 and 3 of Partition Act can be taken care of. Accordingly, the following order. The writ is dismissed, confirming the order passed by the trial court, accepting the commissioner's report dated 14/8/2009, subject to condition. However, condition 1 is modified and the same shall read as follows. Both the parties are permitted to participate in auction sale along with public.
What is this? First preference should be given to the parties subject to obtaining prior leave of the court.
No, that was the order passed by the trial court in the first instance. That was challenged because
No, what is this condition? What does it, what the court?
they should seek permission from the court that they are ready and willing to participate in the auction. If they are seek permission before the court under section 2 and 3 of the Partition Act, court will grant permission. Obviously, this is only a formality. Court will grant permission.
So what is this application?
Now, this application is section 2 and 3 of Partition.
Then where is the finding of the
Lord,
court?
as on the order passed by this honorable court, there was stay of proceedings. Lord, in 2020.
So, in the light of this order passed by the court.
Certainly, they are entitled to participate in public auction. They don't want to do so. My learned friend is claiming preemption right, saying that he wants to purchase only petitioner's right.
Being a party to this, how can he ask for that?
That's what they should ask.
Section 3 of the Partition Act kindly take.
No, that we will read the section 2 and 3, what it says. What is this order and what is the undertaking before the court?
No, we are not, it is not the undertaking, my lord, and moreover, that proceeding is totally different. Now, at that time, your lordship put me correctly. At that time, there was no application as such was filed under section 2 and 3 of the Partition Act. Partition Act, your lordship kindly see, no orders as such was passed by the trial court as on the date of disposing of that.
When you have said before the court that you will participate in the public auction.
No, why? Because your lordship kindly appreciate what the section 3 says. Out of 10 shares, my lord, 9 shares belongs to me. Only 1 share they want to take enmity to put the property into auction. Only 1 share has to be purchased. That has to be decided by the court.
That factual position.
So we will do one thing. We'll do one thing. I'll ask the trial. I'll set aside this order. I will ask the trial court to deal with their application
in light of
the light of this order
please,
also.
Please
come. Agreed with the orders passed on IA number 1. In what is this IA?
IA is filed.
Your lordship will get at page 45, my lord. Page 45.
IA 2 and 3 of Partition.
No, there is no number to the IA. That is what I was asking.
IA number is not been given.
Agreed with an order passed on an application under section 2 and 3 of the Partnership Act in FDP number 3 of 2026 before the City Civil and Session Judge at Bangalore, dated
yes
6th April 2000.
6th April 2026. You are the?
I am for the first LRs of first respondent.
The respondent, the LRs of the first respondent before the FDP court is before this court. They have filed this application. The petition herein has filed an application stating that they are the LRs of the first respondent, and they are preparing and they are prepared and offer to purchase the share of the petitioner at a valuation which is which is asking as per the valuation in the sale. and they sought permission of the court to purchase a share of the petitioner in the FDP that came to be dismissed by order impugned. While dismissing the order, while dismissing the IA, the court has observed and recorded about an order in WP number 15176 of 2020 about order passed in RFI number 1479 of 2012 and observes that therefore there is no merit in the contention of the counsel for the LRs of the first respondent and accordingly dismissed. When counsel appearing for the petitioner submits that the court has failed to record any reasons why the petitioner is not entitled for a relief and why petition is not entitled for relief as per section 2 and 3 of the Partnership Act and recording irrelevant reasons, the court has dismissed the IA. Next paragraph. When counsel appearing for the respondent?
23, caveat R 23, please.
No, before the FDP.
FDP court, please, will not.
First petition.
I'm not.
No, then
I am for.
to dispose it of other respondents' presence.
No, they are not because they are not filed.
File a memo.
They
My lord,
don't
I have entered.
dispense to them.
File a memo.
Yes, I will file it.
Memo is.
My lords, I
in the
have
doc.
entered appearance for respondent 4, 5, 6 in 20, my lords.
They are not,
Five.
they are not the petitioners.
4, 5.
6 and 20.
Respondent 4, 5, 6,
6
20.
and 20.
And they are not necessary parties.
R9 in the trial court.
Here,
Here 23rd respondent.
23. So, on behalf of
23.
23 caveat is filed. So and so appeared for 4, 5, 6 and 20. And for the remaining other respondents.
Notice
give a-
maybe, I will file memo.
Memo
But
is
the
filed
R1 is represented by Mr. Jagdish.
R1 is also represented.
Who is
The
the petitioner
remaining
before the court?
other persons look at it. Whatever the remaining number, they will give the memo dispensed with. When counsel appearing for respondent number 23 submits that the earlier, the petitioner has not brought to the notice of the court an order passed by a coordinate bench in WP number 15176 of 2020, wherein between the very same parties, wherein the petitioners have questioned an order dated 5/12/2020 passed in FDP number 3 of 2026. The said writ petition is disposed of.
No, it was dismissed, please.
Court has dismissed
Please confirm
said
the
writ
trial court.
petition holding that the court do not find any illegality or irregularity in the order which is passed, taking into consideration the order passed by the court in RFA number 1479 of 2012. It is not in dispute that as on the date when the order impugned was passed, no application was filed under section 2 and 3 of the Partition Act by any of the parties. The court in RFA number 1479 of 2012, considering the commissioner's report, has held that the property cannot be divided and directed the trial court to work out means for suitable alternative as per law and complete the final decree proceedings. The court further observes that perusal of the conditions would go to show that in the impugned order, the trial court has permitted the parties to participate in the public auction subject to certain conditions. And accordingly, the court has dismissed the writ petition. However, it is observed that the both parties are permitted to participate in the auction sale along with public, and first preference should be given to the parties subject to obtaining prior leave of the court within the stipulated period on or before the next date of hearing. It is submitted with the land counsel that in the light of the same, they can always participate in the auction and also have the first preference, and there is no illegality with the order impugned. Next paragraph. Having heard the responses on either side, there is a material on record. The petitioner has filed an application under section 2 and 3 of the Partnership Act. When he has filed the application, how the petitioner and the facts and circumstances cannot have the relief is not entitled for a relief under the said provisions, the court should have given a reasoned order, but unfortunately, except referring to a writ petition under proceedings under the RFA, no other findings are forthcoming from the order. It is a contention of the land counsel for the petitioner that the property that is going to be sold is only one portion, whereas the 9 portions are with the petitioner.
Which is
In-
denied by me.
No, it is
It
true.
is a petitioner's case.
I am in
It's only
possession
one
of the
portion
property.
and 9 portions are with the petitioner. The same is denied by the counsel for the respondent, be that as it may. When an application is filed, the court has to consider the same in its proper perspective and should pass a reasoned order. A reasoned order considering the case of the respective parties. Why there should have been a finding why the petitioner is not entitled to have a preferential right with regard to the said properties. In those circumstances, this court is passing the following order. The order impugned dated so and so, passed by so and so, is set aside, and the matter is remanded back to the court, and the court shall consider the order, consider the application filed by the petitioners in the light of the orders passed by this a coordinate bench of this court in WP number 15176 of 2020. Next paragraph. The whole exercise shall be completed within a period of
1 week is sufficient.
within a period of 1 week from the date of receipt of the copy of the order.
Please.
Yes.
And my only, the observation of the writ petition, earlier writ petition and RFA should not be taken into consideration while considering application.
I said independently it has to. Why?
Yeah,
That is between the
otherwise
same
again,
parties,
they
sir.
will refer the
No,
same.
no, I said why you are not entitled for that preemption should be
Ah,
an finding.
That is true.
That will serve the purpose. Yes.
May I make one, sir? In this way, other matter, my lord.
Which other matter?
46, a date may be fixed for.
No. That is, you have whatever.
I will keep informed.
Huh?
I will inform the other side.
No. You have mentioned one matter, it is done.
Oh, great.
Yes.
For the petitioner.
Legal number 4 has to be called. These are yesterday in the morning we were submitted, but in the end of the time, that was not.
Anyhow, what is this matter?
Number 8.
I'm for the petitioner, my lord. My lord, in that.
My lords, the order,
Actually, in the flat.
Let me look at the order. Where is the order?
order, my lords,
24 June 26, my lord.
Just wait.
Number 4.
order, my lords,
Yes.
serial number 3,
Ah.
the flat number 1702, it should be.
1 minute. It should be
02.
not 1.
All the other places it has come as 02.
Oh,
Only at this place it has gone as 01.
yes.
One, my lords, and second thing, my lords, that 5, item number 5,
Uh-huh.
your lordships are dictating, our tenants are already continuing.
Oh.
And they will undertake not to alienate the same. That word got missed out, please,
Oh.
my lords.
No, my lord, what?
Whereas in respect of,
submission, madam.
1 minute, the keys have to be handed over to in the respect of the other apartments, the tenants are already continuing and they shall not alienate.
That's all.
My lord, my submission is there are totally 8 flats still there in their custody, my lord. Now I'm paying 7.5 crores DD, my lord.
I am not
Still
asking
they
any
have 8
additional
flats.
order. What was agreed to be
No,
recorded,
no,
that's all.
because my lord, my senior argued saying that only if they release 5 flats, then we will file an affidavit of undertaking.
No, they have released.
They're not to release, my lord. Now I'm handing over
And
the
if you
DD.
say so, I will recall this order and I'll hear it again.
No, my lord, they just said that. These 3
That's
flats.
a fair order. We will see next time. Already
I'll hand over the
continuing
DD today, my
and
lord.
shall not alienate.
Yes, ma'am.
Please
Please.
hand over the key today itself.
Right away, I'm handing over, please, my lords.
keys
All the
are-
keys are for
Land
the
counsel for the
501,
petitioner.
502, handed over, please.
A memo, the matter is moved today, seeking clarification in the order dated 24/6/2026, stating that in the operative portion of the order, at clause number 3, instead of 1702, apart flat number 1702, it is mentioned as 1701, and in clause number 5, the court has observed tenants are already continuing, and as far as they shall not alienate is not finding part in the order. Considering the same, the order is clarified. Accordingly, the corrected order shall be uploaded.
My lord,
I have written
my lord,
it.
they handed over the DD for 7.5 crores. They delivered the.
I have
It is
I have
submitted
handed over the
that-
keys. I have
It is
taken
submitted.
delivery
No,
of the
this-
DD,
this-
please.
Then where will I record all this?
We have completed,
Yes.
please. process.
Till number
Thank you.
Yes, is enough. How many matters are there? Yes.
33 matter.
Yes.
The electricity has been disconnected pursuant to a letter at annexure A, page
Appear for the
14.
respondents?
Yes,
Please,
ma'am.
Malad.
Copy has been served to the BB party.
Similar
ESCOM.
case,
Yes.
When, why it was disconnected?
Floods, they had sought for an
13.
NOC from me that I had to obtain from BBMP within 7 days. But there is no determination as to the legality of my building as yet by the GBA. Before that only, my lords, they have issued a letter calling upon me to submit an NOC. Thereafter,
What did you do?
Lords, I was in the.
Without, if you don't do, they gave you a show cause notice.
Lords,
You
they don't pass an
respond to
order.
that.
They don't pass an order, my lords. They unilaterally announced come near the property and disconnect the electricity connection. There are pregnant ladies in the schedule.
Short an instruction, my lordship. We have been, will file an objections in this.
No. Purpose of serving papers on you is
have no instruction,
not for filing objections. It is for getting instructions. Tomorrow, I'll read this matter on the top of the list tomorrow. You have to get specific instructions.
Yes.
You should a show cause notice. Pursuant to that, have you passed any order?
Much.
Without passing any order, how can you disconnect the power supply? These are the questions. Get instructions only on that. No objections are required.
Okay.
This
Till,
is matter
till
as
such time, my lords, there is no electricity connection. Virtually,
they
there
have
are
done it
pregnant
2 days back.
Lords,
So
Lords,
till
yesterday,
today,
Lords,
or tomorrow is a holiday.
please, my lords, that is why, my lords. Over the weekend,
We will see on Monday.
Lords,
Pending, it is submitted by the land council for the petitioner that the respondents, without passing any order, has disconnected the power supply. Land council,
BB Patil.
BB Patil, land council who takes notice, accepts notice on behalf of the respondent, submits that they'll get instructions. From the submission of the land council, so far they have not passed the final order in that view of the matter. The respondent shall forthwith shall provide the electricity supply.
restore the electricity.
Restore the electricity supply.
I request for hand delivery of the order.
Inform.
I will inform.
He'll inform.
Pass over matter.
And they should
list one.
restore the power supply with forthwith. Yes.
List one pass over.
Much obliged.
List number 2, serial
Please
number.
wait. Every time, please don't mention. Yes.
No, in the yesterday it was listed, my lord.
Yes.
Please, my lord. List one, serial number 25, my lord.
Yes.
The limited prayer of mandamus, the petition is before this court, my lords.
Why it is mentioned now? If it is a mandamus,
It is passed
this is
over.
mentioned matter.
Pass over matter.
Mentionings are over. Okay, yes. Which year is the suit?
My lords, so suit is of the year 2012, my lords. In the
Which court is this?
17th additional city civil court, my lords. CH-16, my lords. Application under
Pass
section.
an order particularly directing the trial court to hear in IA number 2. When is this IA number 2 filed?
It was filed on 2024, my lords.
Come, the petition is filed, sing the following prayer. Then counsel for the petitioner submits that I number 2 is filed in the year 2024 in the FDP proceedings, and even till now, the said application is not considered with the court. Next, considering the submission of the land counsel for the petition, this court is passing the following order: the writ petition is disposed of, directing the so and so to dispose of I number 2, IA number 2 in accordance with law within a period of how much time it takes? What is that IA number 2?
Arguments are over, my lords. It
Within a period of 2 months from the date of receipt of the copy of the order. No, say no notice is issued. Yes, what is your problem?
Grateful, my lords.
My lords, yesterday this matter was listed. Your Honor, my lords has told me that at the end of the list it will be taken up, but because of want of time, it was.
Why? What is that is mentioning? I said it will come in the list. That's what I said. I didn't say end of the list I'll take up. I said all the matters will come up in the whatever not reached, they will come in the today's list.
But today's list, it is there, my lord.
What do you want? What is urgent
lords,
to take
no.
up this matter?
My lords, we have questioned the order passed by the trial court regarding court fee. Now the matter is posted for dismissal of suit because of non-payment of court fee as per the order passed by the trial
You
court.
have to pay the court fees
No, my
and
lord.
also you can come here.
They filed application under order 7 rule 11B.
When is the suit coming up?
Today is there, my lord. Yes,
When
from
was the
yesterday.
earlier order passed?
This order passed on, my lords, 27th November, my lords. We have filed immediately, but
You're waiting for that, for that.
no, frequently it is listed, my lord, but it's not reaching.
27th November, we are in July. And you say the matter is
My lords,
listed
previously
tomorrow.
we filed a writ petition that came to be withdrawn with liberty to
Also be
file.
reasonable, in making the request. You're considerable, for how long you kept quiet without insisting for the matter?
Frequently it is listed, my lord, but matter is not reaching, my lord. Some urgency.
November.
No, my lords.
Give that file. When were the office objections complied with?
My lords, it's complied and only one memo was moved before the registrar regarding dispensation of notice to other.
When was it? It was on 36/2026. Till 36/2026, you were comfortable by keeping quiet on an order which is passed in the month of November. And first time it came up before the court on 2/7/2026. 1/7/2026, it has come up before the court.
Yesterday it was listed.
And today you should be heard, and
No,
finally I should pass orders.
In the morning yesterday, I was submitted, my lords, his
No,
lordship
just
has
this-
directed me
in the
to
list.
submission,
Yes.
make submission at the end of the list.
Serial number 75 in first
All
list.
to the court officer.
My lord, lease to serial number 7, my lord. It is a matter of electrical connection, my lord. Bescom, my lord.
All these electricity connections, disconnections, let it come in the top of the list.
Please, my lord.
Submission, my lord. Serial number 5, second list to your lordship. Second.
I have instructed the court officer.
ನಮಗೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬೇಡಿ ಮೇಡಮ್, ಇದು ಸುಮ್ಮನೆ ಬರೋದಿಲ್ಲ.
ಕಾಯೋದು ಹೋಗೋದಾಗ್ತದೆ.
ಸುಮ್ಮನೆ ಎವ್ರಿ ಟೈಮ್ ಇಟ್ ಇಸ್ ಹ್ಯಾಪನಿಂಗ್. ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಉಳ್ಕೊಳ್ಳುತ್ತೆ ಮೇಡಮ್, ರೀಚ್ ಆಗಿದೆ.
ಮೇಡಮ್ ಎಷ್ಟು ಏನಾಯ್ತು ಮೇಡಮ್?
ಲಿಸ್ಟ್ ಎಲ್ಲ ಅಡ್ಜನ್ ಆಗುತ್ತೆ ಸರ್, ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜುಲೈ.
ಅಲ್ಲ ಏನಕ್ಕೆ ಅಷ್ಟೊಂದು ಲಾಸ್ಟ್ ನಮ್ ವಿಕೆಟಿಂಗ್ ಅಲ್ಲ ಮೇಡಮ್, ವಿಕೆಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ 2 ವೀಕ್ಸ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು ಅಂತಿದೆ ಕಾನೂನು.
ನಮ್ಮ ಡೈರೆಕ್ಷನ್ ಇರೋದೇ ಆ ತರ ಸರ್. ಸಬ್ಮಿಟ್ ಮಾಡಿ, ಅದು ಡೇಟ್ಸ್ ಅವೈಲಬಿಲಿಟಿ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಾ?
ನಮ್ಮ ಡೇಟ್
ಜುಲೈ ಲಾಸ್ಟ್ ವೀಕ್ ಅಂತ.
List 1 remaining matters will be repeated in list 1 on Monday. And
much
all
of-
list 2 matters will be adjourned to 4th week as per the dates available. ಯಾವತ್ತಿಗೆ ಹೋಗುತ್ತೆ ಹೇಳ್ಬಿಟ್ಟು.
ಇಷ್ಟು ಒಂದು
ಎಲ್ಲ ಸರ್
ಒಂದು
ಹೀಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಅವರು ಹೋಗಿ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಸರ್. ಅದೇ ನಿಮ್ಗೆ ಲಿಸ್ಟ್ ಜುಲೈ ಬಂದ್ರೆ ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ ಸರ್.
ಹೌದಾ?
ನಮ್ದು ಹಿಂಗೆ ಲಿಸ್ಟ್
ವಿಕೆಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ, ಸ್ಟೇ ವಿಕೆಟ್ ಹಾಕ್ತಾನೆ ಇದೆ.
July 8. 29, 30.
ಮೇಡಮ್ ಲಿಸ್ಟ್
28, 29, 30.
ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಲಿಸ್ಟ್ 2 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಮೇಡಮ್.
ಅದೇ ಸರ್, ಅದು 29, 7 ಹೋಗುತ್ತೆ.
ಬಹಳ ಲಾಂಗ್ ಡೇಟ್ ಆಗಿದೆ ದಯವಿಟ್ಟು.
ಅಲ್ಲಿ ನಮಗೆ ಡೇಟ್ಸ್ ಇರೋದೇ ಅದು ಸರ್, ನಮಗೆ ಡೇಟ್ಸ್ ಇರೋದೇ ಅದು ಆಸ್ ಪರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
ಅಲ್ಲ ನಾನೇ ಈಗ
ಕೆಲಸ ಮಾಡಿ ನಾಳೆ ಬೆಳಿಗ್ಗೆ.
ಮೇಡಮ್ಗೆ ಹೇಳಿ, ಇವಾಗ ಅವರು ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಲ್ವಾ, ಈಗ ನಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಇರೋದು ಲಿಸ್ಟ್ 1 ರಿಪೀಟ್ ಮಾಡಿ, ಲಿಸ್ಟ್ 2 ಬೇರೆ ಡೇಟ್ಸ್ ಅವೈಲಬಲ್ ಅಂತಿದೆ. ಇಲ್ಲಿ ನಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ 60-70 ಮ್ಯಾಟರ್ಗಳು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಆಲ್ರೆಡಿ ಆನ್ ಬೋರ್ಡ್ till 27th of July ನೋಟಿಸ್ ಫೀಲ್ಡ್. ಅದಕ್ಕೆ ಇವಾಗ ನಾವು 28, 29, 30th ಗೆ ನಾವು ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ತೀವಿ. ಸಂಜೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ನೋಡ್ಕೊಳ್ಳಿ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 21 ಮೇಡಮ್.
Court officer, madam. Madam. Court officer, madam. Court officer, madam. Madam. Court officer, madam. Madam, court officer, madam.